also since we dealt with several instances where it was clear that there were some labor issues that related to the terms of reference of the committee. I am going to say that we always careful to context our discussions on the mandate of the committee, which is to look at expenditure or financial impact of the road accident fund. We also stay away from reviewing specific cases because that's not our mandate. Part of what will happen here is that some matters may be referred to the portfolio committee on transport. Matters that arise in our discussions, so we're not completely working alone. So we're not going to completely ignore things. Those that don't fall within our mandate will be referred to the correct structure to take them forward. We do swear in our witnesses, so I'm going to ask Ms. Ibrahim to do the honors today. So whoever is going to be speaking to the committee needs to be sworn in, and then we will begin. But I will explain how we proceed once the swearing in has happened. Ms. Ibrahim, over to you, and Happy New Year to you as well.
Thank you, Chairperson. Happy New Year to everybody. Good morning, Mr. Mbali, Mr. James, and Ms. Nsibanyo Mgambi. I hope I pronounced that correctly.
Good morning.
Colleagues, you've been invited to appear before the Standing Committee on Public Accounts to provide information in relation to the committee's oversight inquiry into the Road Accident Fund. In extending this invitation, the committee chairperson has indicated that you will provide such information to the committee under oath or affirmation in terms of the powers, privileges and immunities of Parliament and Provincial Legislatures Act. You have indicated that you wish to take the oath, so I'll administer that after I explain the parliamentary rules to you. Please be informed that in terms of the Powers and Privileges Act of 2004, that by law you are required to answer fully and satisfactorily all the questions lawfully put to you, or to produce any document that you are required to produce in connection with the subject matter of the inquiry, notwithstanding the fact that the answer or the document could incriminate you or expose you to criminal or civil proceedings or damages. You are, however, protected in that evidence given under oath or affirmation before a House or committee may not be used against you in any court or place outside of Parliament, except in criminal proceedings concerning a charge of perjury or a charge relating to the evidence or documents required in these proceedings. Please be aware further that in terms of Section 17(2) of the Powers Act, a person who willfully furnishes a House or committee with information or makes a statement before it which is false or misleading commits an offence and is liable to a fine or to imprisonment for a period not exceeding 2 years. I'm now going to ask you to please raise your right hand and repeat the oath after me. If you can all please raise your right hand. Thank you. I swear that the evidence I shall give
I swear that the evidence I shall give
shall be the truth,
shall be the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
So help me God.
So help me God.
Thank you so much. Chair, the witnesses are now duly sworn in.
All right, thank you very much. Just two things. The first is that we also encourage our witnesses to stay away from hearsay. So if you don't have first account of an issue, in other words, you heard somewhere, then it's not of much use to us, because we then can't ask the person concerned to provide another version to it. That does not mean you're not able to draw conclusions on a basis of experiences, but where there is a direct accusation against someone, it serves our purposes better if it's first hand. So that is the first thing. The second thing is that in order to streamline our proceedings, I'm going to ask you, colleagues from NUMSA, so I'm going to give you about 20 minutes just to pull out the salient issues in your submission, because it is 40-something pages long. The members have it. I would like to ask you that you, as you speak, you refer the members to the page, to the pages concerned or where the topic is. And unless it's absolutely necessary, also just stick to the issues raised in the document itself so that the members can follow. Unless, of course, you're adding something for color. I will then give the members an opportunity to ask questions. The questions may come from other hearings that we've had. In other words, members may refer to a staff member, to a manager, to an executive who had said something before the committee and ask you to answer regarding that because it pertains to this matter. So the members are not limited strictly to this. They might introduce other things that have been discussed in the committee in order to check for consistency, for accuracy, etc., etc. So that is part of the discussion so that you know. But to assist us in the beginning, what I'd like to ask you is to do that. Before you speak, please once again introduce yourselves. I'm going to ask Lwazigazi that we get name tags because the members are going to need to the specific name tags. Please introduce yourselves again, and then please go ahead. We will have until 10:30 for that. Thank you.
Good morning, Honorable Chair, and good morning to all the honorable members in the House. My name is Sive Mbali. I'm a former employee of the Road Extent Fund and also a full-time shop steward of NUMSA. Thank you.
Good morning, Chair, and good morning, members. My name is Viwe James. I'm the head of organizing campaigns and collective bargaining in NUMSA. Sorry. My name is Viwe James. I'm the head of organizing campaigns and collective bargaining in NUMSA. Thank you.
Good morning. My name is Zazinsi Wanyoni Mugambi. I'm the head of Secretariat working in the Office of the General Secretary. Thanks.
All right. Thank you very much. I will then hand over to you. It's your submission. You know who deals with what section. If it's one person, we're okay with that. If it's all three of you, you decide. You've got until 10:30, and then the members will ask questions until we break. Thank you.
Thank you, Chair. I'm gonna deal with few issues, and Sivembali and my other colleague will supplement where I don't deal with. I think we must first start with, I think, is it page 2 of the document, where we talk about the issue of mass suspension. But before we get into mass suspension, I need just to lay a history before that. I have been working with Road Accident Fund as of 2018. I have worked with various CEOs before Mr. Letswalo, which his predecessor, Ms. Lindiwe Jabav. I work well also with her. But the main issue was that there was a period where Mr. Letswalo called us just to give us insight of after he has been with the entity for a few months, his diagnosis and what he thinks that it's a direction to move forward and take the organization to a different direction. One of the issues that he highlighted is corruption that has been across the Road Accident Fund, mainly through looting of legal firms and certain staff within Road Accident Fund whom he alleged that have been working with legal firms. But then, because that meeting we were both with the General Secretary coming from SA Business Rescue, we then realized out of his presentation he was moving to the right direction, and we supported him throughout until I think sometime, was it in 2021? I can't recall the date now. In 2021, he then phoned me and he said we're not gonna meet normally as we normally meet at the head office. We'll meet in Melnin. And I call all the compliment of Shopkeyward, where he made various allegations around NUMSA members and the general workforce of, to say that they were working with lawyers to sabotage the entity. And we said to him, if then that is your view, I think it is upon the company to then prove the allegation. It can initiate discovery inquiry. If really the outcome of discovery inquiry prove that the members were found with malfeasance, then consequences were going to take place. And he drive this thing, and then he then suspended a lot of workers. So we had full-time shopkeepers who were doing inquiries, one for inland in a base in Joburg, another one for coastals. So they were moving around across the country and to represent members. But strangely enough, these cases never, majority of them were not finding the traction, getting to its logical conclusion. At some point, they were just abandoned along the way. So this thing have taken for some time. Some members got frustrated, others got sick because they were sitting at home because of this suspension. But Shopkeyward continued to defend them. Some, the chairperson found them not guilty. And then that's when they were now many that the chairperson find them not guilty, management decided to abandon a lot of these cases and leave the workers suspended. Then ultimately, because this full-time were going, he actually took some and said they must join the ranks of management, which some joined the ranks of management as initiator from NUMSA. Then we then operated with others because we had pipeline, we operated with others. So they started to be, and one other issue was that all these cases, we are not talking about complex cases, just normal disciplinary inquiry, all of them. The company was represented by lawyers, the presiding were lawyers. So one of our concern, if you are dealing with, you want to remedy the financial challenges of the company, then how do you then start to use? I mean, you have a big HR and ER complement to deal with these matters and line managers. But they continue with these cases, but we defend it, as that is our duty. So then subsequent to that, because I had to leave because I was focusing on SAA business rescue, I took one of the sector coordinators in my department just to focus there. But ultimately, they called me sometime in August 2022 to say that management was pushing restructuring through collective bargaining committee, which is the bargaining structure of which NUMSA established with the company. Then I attended and I saw some presentation and we asked questions and management could not answer. Then subsequent to that, the main issue of that restructuring was to deal with two issues. The first issue was to use that process to get rid of all these workers that were suspended, because he raised that in one meeting. The second aspect was to close two offices, East London and Durban. And both offices, he indicated that those employees were corrupt. The only office that was actually performing for him was Cape Town. Then we then dealt with the rationale of that. When we realized that now he was starting to move out of control, we met with him, with the General Secretary. Then when he presented these issues, we asked them questions. Management themselves could not be able to articulate their own restructuring plan. Then we then insisted that CCMA must facilitate the restructuring. CCMA facilitated the restructuring. CCMA also got to a point where they got frustrated because whenever they are required to produce document or explain the document, management is unable to do that. To a point that they decided to abandon the restructuring. So in 2023 January, they insisted, January or February, they insisted CCMA to give them reports. CCMA said, you have recordings. If you need recordings, you can have them. And CCMA have actually given a report to Senior Commissioner Khanse from head office that as far as CCMA know, REF have abandoned the restructuring. Because ever since they were required to produce document, they postponed and never actually indicated further meetings to that effect. So the other issue probably that I will talk to, it's an issue of unsafe working condition. I mean, if we talk about Joburg, before they moved to the new office in Parktown, they were in Marble Towers, not far away from High Court. There were times where even lifts were not working in that building. And that building was a mess for long. We intervened, discussing with him around that. There were a lot of issues, and workers were frustrated. They were not productive in that building. It's the same issue with Menlyn. I mean, Lean, each and every time when workers start to work, there were sheriffs that were attaching furniture and even computers. So it was a mess. We visited that, we engaged that. That has always been a problem, in particular those two Gauteng offices. So I think I will leave it there. I will leave my colleague just to deal with the other issues that he, like your Bokamuso. Thank you, Chair.
Thank you, Chair. So I'm going to cover the Bokamuso part of the presentation and various other topics, but I'll try to be as brief as possible, seeing how lengthy our document is. Now, Honorable Chair, the issue of Project Bokamuso was introduced to the union by the former CEO of the Road Extent Fund, wherein he called a meeting to meet with the shop stewards. And the intention of the meeting was to basically make it known to the union that the Road Extent Fund has an intention of introducing a system called an integrated claims management system. And how the system was introduced to NUMSA was that its intention was basically to automate the work that is done by claims handlers at the Road Extent Fund. In other words, the claims handlers will no longer be required in the processing of claims. What will happen is that the claims will be loaded onto the system. The system is going to work out the merits automatically, thereby decide whether or not a claim should be repudiated or should be settled. And furthermore, that the system will have capabilities of sourcing case law that is relevant to the claim in question. And what then will be required, according to what we were told by the former CEO, would be that there will only be administrators whose duties will mainly be to print repudiation or settlement letters. that will be sent to the claimants. And the CEO then made it known to NUMSA that for that reason, there's about 200 plus claims handlers who are not going to be required at the Road Extent Fund, to which then we got an understanding that not only has the employer contemplated retrenchments, but the employer has actually decided that these employees are not going to be needed. Hence, Corbett Viewer had stated that NUMSA insisted that we should consult with the employer in terms of Section 189. Now, whilst we're in the midst of engaging with the employer through consultations, it became apparent that the employer intends to introduce a new structure at the Road Extent Fund. And the structure basically would be informed by the system that has been introduced. And we're informed that the system is going to cost the Road Extent Fund an approximated figure of about 800 million. I'm not really sure of the exact cost of the system, but I'm just merely stating what was said to us in the meeting. And throughout our engagements with the employer, we've always expressed our interest to find alternatives in order to save jobs and all of that, which of course was not really, it was not met with any sense of good faith on the part of the employer, because the employer was not interested in basically finding alternative solutions to these job losses that have been identified. And we're informed that the intended number of retrenchments, apart from the 200 plus claims handlers, but the targeted number is about 400, I think 427 or so. Now, as NUMSA, we're very concerned about this because, one, the Road Extent Fund is severely understaffed. And this is not a new phenomenon, because the Road Extent Fund had decided a while ago that positions would be frozen and there wasn't recruitment of new employees to fill positions of employees that probably would have resigned, dismissed, or retired. And the situation became even worse after the termination of the panel of the attorneys that were representing the Road Extent Fund in court. And the reason why I feel, Chair, that it is important for us to highlight this part is that these employees at RAF were faced with a huge work backlog. And each employee of Road Extent Fund, claims handler, was allocated at the time about 2,000 files each person. And this workload was unbearable. As NUMSA, we have raised numerous grievances with the employer, trying to get the employer to come to the aid of this members, because members were drowning in the workload. And we're deeply concerned because whilst the employees are faced with this huge backlog, the employer has intentions of letting go of about 400 plus employees. Now, whilst we were facing that, Chair, it then became apparent that the employer, I think around 2023, if I'm not mistaken, had an interest of introducing an external call center to run the client relationship management system of the Road Extent Fund. I must mention that the Road Extent Fund has always had an internal call center that was functioning very well, actually, and there's never been complaints. And we expressed our displeasure as NUMSA to say the call center was said to cost the Road Extent Fund, I think approximately 200 plus million per annum, which was said to us by the employer. And we were informed that the intention was to create jobs for young people, and I think the estimated number at the time was about 300 positions that would come with this new call center called Alteram. And we raised our concerns as NUMSA and objection to say, one, because there's a new structure that is being introduced at the Road Extent Fund, our members who are working in the call center will be left displaced. Two, why do you not preserve the positions that you are creating with Alteram for the internal staff that has been identified to be redundant, that the employer intends to retrench, which is 400 plus? Why do you not preserve those positions for internal staff, reskill the employees, and take them to the call center if needs be? Surely it doesn't make sense that the Road Extent Fund should spend so much money creating jobs outside of the company itself. As NUMSA, we are not opposed to any job creation. But our first preference in this context, Chair, has always been that we need to save the jobs of the employees that are already in the system of the Road Extent Fund. But of course, that was not basically resolved by the employer, and they went ahead and implemented the call center as they had actually intended. Now, we continue to raise these issues with the employer, and basically we were not assisted. And we decided to approach the CCMA, of course. And the reason for us to approach the CCMA was to basically fight for the members who were left displaced internally, because they were not placed in any positions. And our issue was that this is a unilateral change to the conditions of employment of our members. Two, this does not assist the claimants who are waiting for payment at the end of the day, because everything that is happening at the Road Extent Fund, in terms of mismanagement and all of that, is affecting the claimants who are waiting for their monies at the end of the day. Whilst as NUMSA, our primary goal and intention is to safeguard the interest of our members, but we understand the important role that the Road Extent Fund plays in the context of the public and South Africa. Now, Chair, we might have mentioned the question of the 50 plus claims handlers that were suspended and all of that, but we want to stress that these are not the only employees of Road Accident Fund that were placed on suspension, that were subjected to unfair dismissals and so forth. We must stress that the Road Extent Fund had actually adopted an attitude of appealing or reviewing matters, even in instances where they clearly don't have a case, or where they clearly have actually dismissed an employee unfairly. They made it a point, Chair, that the matter would actually be challenged even if it gets to the highest court in the land. And of course, we once were informed by the former CEO that this is exactly the stance of the Road Extent Fund in a meeting that we attended with him as Shops to once, that the stance of the Road Extent Fund is that once an employee has been dismissed and has been basically eliminated from the system, there is no way that the employee will return to the Road Extent Fund for as long as he is the CEO of the organization. And we probed him on this to say, but what if then an employee has actually won a case at the CCMA and or Labor Court? He said, it does not matter. The RAF will review the matter, even if it gets to the Constitutional Court. Now, we took a serious view on this, because it really showed us that there is no fairness in terms of how employees are treated at the Road Extent Fund. And Chair, what I'm saying today is not only theory, but there is practical examples of instances where the employer had actually challenged cases, even when the court has pronounced that the employee must be reinstated to their job and all of that. But the RAF will still insist. And that, Chair, has actually ballooned the expenditure on cases of disciplinary action against the employees. And it has amounted to probably 100 million, the estimation that we actually had, but we're not entirely sure of the figures, but we can always supplement documentary proof if needed. Now, the Road Extent Fund had actually adopted a stance that even in internal disciplinary hearings, RAF would be represented by attorneys against employees who do not have the funds to hire lawyers. And in some instances, employees would be refused legal representation. There had been instances where employees had requested to be legally represented in a matter internally, and RAF would actually refuse on the basis that the employee could actually get a fellow employee to represent them. If not that, an employee can get a union shop steward. And I must stress, Chair, that things actually became even worse following the termination of the recognition agreement of NUMSA, which happened, I think, around the 14th of March, 2024. The termination of the recognition agreement of NUMSA came around about the time that NUMSA was organizing an industrial action, fighting against the unfair retrenchments that were planned by the employer. At the eve of the industrial action, the Road Extent Fund approached the Labour Court on an urgent basis and sought an interdict to interdict our strike. And further, the former CEO had mentioned to NUMSA that he holds a view that NUMSA is organizing in an incorrect territory. In other words, the scope of NUMSA does not cover the Road Extent Fund, despite the fact that the Road Extent Fund is in the transport sector and belongs to the Department of Transport. NUMSA's scope actually does cover the transport sector. However, what was said to NUMSA was that the Road Accident Fund belongs to the, I think the CEO had said, social services sector, if I'm not mistaken. And as a result, NUMSA cannot continue organizing there. And indeed, they went on to unilaterally terminate our recognition agreement, including any collective agreements that were entered into. We took the matter to court to challenge it, and we are still waiting for a date, with the understanding that, of course, matters do delay in court and stuff like that. Now, of course, following our termination, I think probably a month or so later, in fact, he had informed us that he's in talks with a union called NEHAO. NEHAO intends to organize the Road Extent Fund, and currently NEHAO is a union that is organizing at RAF. NUMSA had been organizing at RAF, I think, since 2017 until 2024, I think the 14th of March. I just want to see, Chair, if I have covered everything. Sure. And as NUMSA, we are equally concerned about the issue of the rates of attachments that the Road Extent Fund continues to receive as a result of non-payment of claims. This has actually severely affected our ability, or rather the ability of our members to carry out their duties. As a result, Chair, it happened in so many instances that the sheriff would actually visit the offices of Road Extent Fund and attach furniture. Employees were even forced by management to work on makeshift desks using literally boxes and I think dividing boards for cubicles and all of that. We've got pictures of such. We've got letters where we had actually written to the employer and expressed our displeasure in terms of the risk that the employees were actually subjected to an extent that at some point, SCOPA, when it was still led by the current Deputy Minister of Transport, had visited the Road Extent Fund, and I personally had an engagement with the former chairperson of SCOPA, Mr. Mkhuleko Hlengwa. And I had appraised him of the conditions that employees were subjected to at the Road Extent Fund. And they actually visited the the office and saw for themselves what was happening. Not only, Chair, did we complain about this in terms of internal processes, we even wrote to the Department of Labor for them to come and do an assessment and visit the building and assess for themselves whether or not what the employees are subjected to is not risky. And there was no furniture at the time. The building was leaking whenever it is raining. There was electrical issues and all of that. And we insisted that employees cannot continue working in such conditions. To an extent that, of course, the employer was forced to go and look for a new building, which now is in Hatfield from Menlyn. So, Chair, we came here as NUMSA to basically make these submissions to assist the forum in terms of the inquiry that is ongoing. And we are available to submit any information that is required further to what we have actually submitted today, including documentary evidence. If I've left anything, I think Comrade Viewer is going to add. Thank you.
Thank you, Chair. No, I just wanted just to give clarity on the issue of termination of recognition, because Road Accident Fund wanted to use the same tactic that it used with Auditor General to say that the company was under social services. And this matter, as much as when he served the interdict against us, he served on the incorrect email address and got the interim order, and we went back to court. And subsequently, Judge Legrange delivered the judgment and terminated all the allegation against the union. The only issue that Judge Legrange have omitted was to instruct Road Accident Fund to reinstate our collective agreement, which then NUMSA then brought the second application for declaration that the termination of those agreements was unlawful, which when we brought that application, Road Accident Fund never opposed. That was in late 2024. The matter was scheduled before Labour Court, or I think on the 3rd of May last year, and Road Accident Fund just opposed it just a few weeks before the court. And subsequently, to our surprise, we also saw Mr. Letsolo project, which is Nehau, also intervene, but it was never been part of the processes. Because the issue of him bringing Nehau, he thought Nehau was going to have the membership that we have. At the time, we represented more than 1,600 members. And Nehau was still struggling with non-unionized members who are less than 500, which that was the issue. So there is still litigation that is between NUMSA and on basis of that termination, which probably we are going to bring the third application to recover all the monies that we have lost based on unlawful termination of the agreements. Thank you, Chair.
Thank you very much. So can I, just 3 points from me, and then I'll hand over to the members. The first is that we've dealt before with testimony relating to direct claims and how some of the people that were originally were then were withdrawn and reallocated positions elsewhere and so on. I just want to know if any of your members were affected. Were you involved in that process? Is there any information you can give to us regarding that, if you know? The reason is that the committee, I think, is unanimous in the sense that we want claimants to be able to have a seamless process as far as possible. And if a matter does not need to go to court, then it should not go to court. it must be settled. So that's why it's important, because then the road accident fund saves on court costs, paying advocates and that kind of thing. So that's the one issue I'd like you to pronounce on. The second is, there is somewhere in your statement, your submission, where you talk about the termination of the panel of attorneys and therefore the impact on the operations. Can you also just give us your first-hand account? The third one, I wanted to say, Mr. James, you've mentioned Mr. Letsoalo and NUMSA and what the motive was, etc. I'm assuming that you are speculating he did not say this to you, that he wanted how to replace you. And the reason I'm raising it is because I had said earlier, if you say that's your suspicion, sure, but I don't want us to speculate on people's motives if we don't know. You understand? So I'm raising that issue. So if you can also address me on that. Otherwise, if you can just help me, in fact, help me with those three. So it's the direct claims handlers, it is the workload issues around the panel of attorneys, because you talk about it here, and then yes, the third issue. Thanks.
Okay, thank you, Honorable Chair. I will take the two questions concerning direct claims and the termination of the panel of attorneys and the impact thereof. Yes, it is correct, Chair, that the Road Extent Fund initially had offices in public hospitals where the RAF does not have a main office. Typically, for example, if I can make an example, with regards to all the public hospitals in Limpopo, Northwest, the Eastern Cape, Free State, the RAF had offices in those hospitals. And the main reason for those offices there was basically to assist the public with the quick lodgement of claims, a swift process of assisting them so that they can get help from the Road Extent Fund as speedily as possible, insofar as admissions are concerned and so forth. Chair, if I can just give a bit of a context, the Road Extent Fund has what is called an undertaking certificate. An undertaking certificate basically works like, I would say, if I could just put it in layman terms, like a medical aid or an undertaking that the Road Extent Fund will assist a claimant in terms of medical expenses. Now, the undertaking certificate does not only come after a claim has been settled and paid, but even when a claimant is still in hospital, that undertaking certificate is very much crucial, because it then enables the Road Extent Fund to be able to dispense funds for the payment of medical expenses while the claimant is still there. But most importantly, you get illiterate claimants who do not know how to lodge claims, who need the assistance of people who have the know-how from the Road Extent Fund. Now, accessibility has always been a problem in the Road Extent Fund, in that you have claimants that are based in rural areas who cannot necessarily be able to drive, I'll make an example, from Kuruman to Kimberley to go and lodge a claim. Whereas if there's an office available in Kuruman, a claimant can simply lodge that claim right there at the hospital, and the claim would then be brought to perhaps the head office of Road Extent Fund, or at least a regional office that is responsible for the Kuruman office. And in this case, would be typically Johannesburg. And that assisted in terms of fast-tracking the process of lodgement of claims. Now, a decision was taken by the employer that all of those offices must be closed with immediate effect. And employees were forced to relocate to offices like Johannesburg, Gauteng, and I think some had actually been forced to relocate to Polokwane, if I'm not mistaken. And all of this actually happened without proper consultations with the union in order for employees to gear up and prepare for the cost that would come as a result of them being relocated to another province. For example, the Road Extent Fund has a policy called the relocation, I think it's called, relocation policy, where the RAF is supposed to actually assist employees with the costs associated with the relocation, like for instance, the transportation of their movable assets like your furniture and all of that. Assist them in terms of finding schools for their children. Now, in most cases, this was declined by the Road Extent Fund. So I'm trying to highlight, Chair, the impact it had on the public and also the employees internally. The decision to terminate those, or rather close those offices permanently. Now, when NUMSA challenged this matter, an explanation that was given to us was that this is a temporary measure because of COVID-19. Otherwise, these employees are going to be returned back to those offices. But it became apparent that that was incorrect. None of the employees were actually returned back to those offices. I will not mention a name, but I have one particular matter I've dealt with in the Manlin office of an employee who is wheelchair bound, who was working, I think, if I'm not mistaken, somewhere in the Northwest. I think in Rustenburg, if I'm not mistaken. The employee was a claims consultant in one of the offices there. Since the office was closed, the employee was forced to relocate to Pretoria because he was told that his position now would be in the Manlin office. Because the employee is wheelchair bound, the employee needs what is called a caregiver. And where the employee stayed in Rustenburg, he had a house there that he was paying. And in that house, he had a room allocated specifically for his caregiver. Now, because the employer had forced him to relocate to Pretoria, he is now forced to look for an apartment that he can rent temporarily. And that apartment must be accommodative for a person who is disabled. And that apartment also must be suitable for his caregiver. And in the meantime that the employee is still looking for such, despite the fact that he's paying a bond in Rustenburg, he is forced to travel between Rustenburg and Manlin on a daily basis. He had raised these issues with the employer countless times, and he has never received any assistance. Now, it's examples like those, Chair, that make you wonder as to what exactly is the intention of the employer. Is it to basically fix the road accident fund, and in the process of fixing the road accident fund, assist its employees? Or what is actually at the core of these changes is just implementing the ideas of management irrespective of the impact that they have on the employees and the claimants. Now, in terms of the termination of the panel of attorneys, NUMSA is on record having initially submitted the idea of terminating the panel of attorneys because an engagement that NUMSA had with the CEO when he actually had advised the union of his intention to terminate was that he intends to save funds for the road extent fund. I think he estimated some billions, I can't really remember the exact figure. And he said that the intention is for those billions to now be taken from the pockets of the attorneys and be taken directly to the claimants, who are the intended receivers of these monies. And of course, to fix any administrative issues of the road extent fund, including, of course, issues that we're complaining about, the buildings, safety, and all of that. We didn't have a problem with that. However, what we stressed as NUMSA was that provided that the employer would see to it that the work that has been done by the panel of attorneys is going to be handled in a structured manner, to such an extent that it won't affect our members. What do I mean by this? I've testified earlier on that these members had an approximate number of 2,000 claims per person. These members were frustrated during COVID-19 because nothing was working during COVID-19. We were working from home. In fact, initially, workers were just sitting at home and not working, and we were going gradually to the office, and actually we were taking turns and all of that. Now, it goes without saying that these employees would then be flooded with a lot of emails, which actually may lead to some court orders being missed and all of that. Now, additionally to that, despite the fact that we've complained about the workload, we knew that the termination of this panel of attorneys would mean that the bulk of work that is being done by these attorneys is going to go back to the claimants, sorry, the claims handlers. We warned about this as NUMSA. Now, I want to give this context that when a claim is being assessed by a claims handler, it is a tedious process, a tedious exercise. This is what typically would happen when, let's say, for instance, a claims handler was working in the litigation department or determination department. Once they receive a claim, they don't only receive the personal details of the claimant, including, let's say, for instance, some information about the merits. Additionally to that, they receive medical legal reports. And you might find that probably one claim has about 5 to 7 medical reports that this claims handler needs to go through. And you might find that one report contains about probably 200, 300, sometimes 500 pages. They need to go through all of that. And after making a determination in terms of the merits of the case, and then they give a recommendation as to, in terms of quantum, how much can they offer the claimant to settle the matter? They need to prepare what is called a memorandum. That memorandum should contain all these details, including the recommendations that they've made and including what actually supports those recommendations. Thereafter, they take the memorandum to the senior claims officer, who must endorse. From senior claims officer, it goes to the team lead, who must endorse. From team lead, it goes to the manager, who also must endorse. From manager, it goes then to the RGM, the regional general manager. Thereafter, the claims handler should go back to the attorney that is representing the Road Accident Fund in court and say, this is what we are tendering as an offer, following this process. Then the attorney will then go to the plaintiff attorney and say, well, as the Road Accident Fund, we are tendering this offer. If then the plaintiff attorney does not accept, they reject, the attorney needs to go back to the claims handler for a new revised instruction. And for that revised instruction, the process again needs to start from the team lead up until the RGM. Now, when this panel of attorneys was terminated, plaintiff attorneys now began to engage directly with the claims handlers. And in some instances, Chair, claims handlers were forced to appear in court themselves to go and explain as to why is a matter not settled or why is there no offer tendered by the Road Accident Fund. Now, that took away a lot of time from these claims handlers in order for them to actually be able to go through their emails, in order for them to be able to process other claims that are actually outstanding and so forth. So that is the severe impact it had on operations.
No, thank you very much, Mr. Mbala. I really appreciate that. So, honorable members, I'm going to hand over to you. Shall we agree on 20 minutes per member? Is that acceptable? Honorable Isaac looks like he only wants 5 minutes, in which case we will not deny you your 5 minutes. I'll start with Honorable Ment. So each member, oh, sorry, so Mr. James wants to add something. My apologies.
Thank you, Chair. I think you asked about the termination and how.
Oh yes, I forgot that part. My apologies. Yes.
No,
You got into Mr. Litswalo's mind there. That was my concern.
No. He was speaking openly, and how simultaneously issued memos to that effect. How NUMSA is going to be terminated. NUMSA was organizing truck drivers, not the entire transport. Which that statement was misleading. This communication was communication given by NEHAU to all its there are also communication of Letswalo himself around that, because how this thing, how came on board, NUMSA agreements were terminated today, the following day, how was recognized without even following all the necessary processes of Section 21 in line with the provision of the labor relations. So that's a premise, because the only inference that we have from our side is that obvious, maybe NUMSA was too militant and Letswalo was more comfortable with Nehao then. Because that is why the reason Nehao could not be able to be recognized in REF is because we represented 2/3 majority of employees of REF. And even if they were recognized, they were still going to be forced to pay agency shop. That is why they could not. The only way for them to come in was to terminate NUMSA totally. That's a premise that I was coming from, Chair. Thanks.
All right, thanks, Mr. James. The members can deal with all of these matters anyway. So, Honorable Mende, you've got until 20 past, so 20 minutes. Is it too much? You can finish early if you. Looks like the members are not going yet this year. That's fine. Members are free to finish early if they feel like. Thank you.
Thank you, Chair. Good morning to the colleagues, our visitors from NUMSA, and everyone from Parliament. Happy New Year. I don't know if it's still time. No, thank you very much.
Till April, Honorable Member. We say
Yeah,
compliments.
for as long as we have not seen each other, it's still Happy New Year. Yeah, thank you very much. Yeah, I've gone through your submission. And in the main, it summarizes everything else that we have heard from different people who submitted information to us. And I could only pinpoint on 2 matters that are new to us. And those 2 matters, I would like you to explain them to us. Secondly, I think the Chair has already explained the hearsay and things that you will not be able.
In road accident fund. So those are provision. There's nothing stopping any trade union to organize as long as you are going to play within the collective bargaining framework. That is why Section 1 of the Labor Relations talk about orderly bargaining. Thank you.
You wanted to add?
Oh, no.
Oh, okay.
No.
That's my understanding. You're talking to a former shop steward.
Yes.
Now, I want to understand what were the reasons for RAF to remove NUMSA from the workflow?
It's a misguided position of saying that road accident fund fall within the scope of social services, and NUMSA scope is in transport, then does not cover road accident fund. That was the basis of the termination. And that particular issue led to a road accident fund trigger interdict when we were responding against termination of our members and down variation of their condition. And which then subsequently was heard before Judge Lagrange in April, and judgment was delivered in May 2025 or 2024. 2024 was delivered by judgment, which then Judge Lagrange disagree with the view of road accident fund. That is why we are on Part B now. We are in court now for a declaratory order to compel road accident fund to reinstate our agreements, because the membership that we represented before termination is still affiliated with us, has not changed, except those who are no longer working for road accident fund.
Do we have a court date yet?
Not yet, because when the matter was postponed by the judge on the 3rd of May in 2025, then the judge said he will request the judge president for expedited date, which then we were given an opportunity to respond on road accident fund, and which we responded and submitted all the affidavit. And subsequently, NEHAU came in, we responded and opposed what their submission also. We are waiting for court to give us date. It's unfortunate Labour Court operate with volunteers in a form of lawyers who are presiding over cases due to high caseload. So we're still waiting for a date.
Now, the last question on this one is that during your engagements from the arrival of the former CEO and the management collective, did you get a sense from that time that the arrival of the new CEO is in any way driving the end of NUMSA within RAF? Did you get that sense?
No, to be honest with you, when he arrived, I mean, he came as working with other CEOs before him. We had engagement bilateral with him. And even when he talked about transformation, and that is why in my submission I indicated we left the SA Business Rescue meeting and we went to meet with him, where he indicated the direction that he was moving. And one of those issues was that there were law firms that were looting, that he was going to deal with all those shenanigans. And we supported him throughout until where we could not find one another when he introduced restructuring, because we knew the restructuring was dead, because management themselves could not understand what they were presenting. Basically, they wanted to test something that they don't know. So that our duty, we are trade union, our core business is to defend workers from unfairness. So anyone who tamper with that, we fight on behalf of workers. If you come with the restructuring that where you are able to present a rationale, we'll agree with you and find solution to mitigate the adverse termination of workers. But if you are unable to explain rationale, you just want us to rubber stamp the termination, knowing very well there's a sea of unemployment outside, we are not going to agree with you. Because even himself, we asked him. I was with the General Secretary. We asked him about this thing, and he insisted about this thing. Because also when you talk about the system, the integrated system you can buy from the shelf, or you can build your own system from scratch to suit your own needs. So what he was proposing is it's something that comes from shelf. I mean, even when we said, can you present to us how this system is going to work, at least by that time, the company management should have known how this system was going to work, whether they bring consultant or whoever. They should have known how this system, they couldn't understand. The list that they have, it was PowerPoint presentation.
Now let's try to shorten the length of answers. I know that this thing of a system was also canvassed here, and I'm asking you the questions around your removal solely because there could also be a political motive. And I want to get to the bottom of that. And according to me, There is just 2 new submissions here. Your removal as NUMSA for Nahau, as well as you want to canvass the removal and termination of some of the employees. The last question on this of your removal is that, do you think there is a political motive surrounding the removal of NUMSA? And I'm going to say this, is it because you no longer affiliate under COSATU that you were then removed by management? You can agree or you can disagree.
Thank you, Honorable Member. I don't want to speculate on that, because if that was the case, I suppose that, we left COSATU in 2014. We got recognition with Road Accident Fund in 2018. I suppose that if it had to do with ourselves not being affiliated to COSATU, it was supposed to have taken from the start, where REF refused to recognize NUMSA. So I didn't have that sense. The only sense that I had, it's an ego of the individual that we were dealing with, who became a monster, because he was abusive to workers. If you don't agree with him, then he's going to fight with you. And the only issue that we could not agree is for him to throw more than 200 workers on the street without any justification. Let alone that, I think my colleague have explained that his targeted number were around between 400 and 432. Part of that number, substantial number, was given voluntary severance package. And those people who decided to take voluntary severance package are experienced people who have been with REF. The only reason they took that opportunity is because of the terror that they were exposed to. And they decided just to leave.
Okay, we cleared that one. Now let's go to these workers that were being removed. Earlier on, we had the head of employee relations, Chair will correct me if I'm wrong, that came to testify here. And part of his testimony was around 200 workers that were being removed from RAF. And his reason was that there was transgressions committed by those workers, that they did not capture on the system the judgments. Hence, then there were defaults, and then there were legal costs. What's your understanding around removal of the workers?
When Mr. Ritualo intended to start suspension, I recall it in 2021, he called me, I was busy in other meetings. Then we then agree to meet later. He said, let's meet with all your shopkeepers in Mandlin, not at head office. And he raised the allegation that you are raising. And we said, if then that's your view, proceed and charge these members. If there are NUMSA members who are involved in malfeasance and the outcome justify that, consequence management will take place. But the issue is that you made general allegation. When you are required to substantiate, you can't proceed. It means that more than 200 workers who are supposed to be productive are kept at home, and they are being paid with the money of taxpayers. Whilst they are sitting at home, there are others who are acting in their position, and there's no decision when they are going to be reinstated. So that's one of the issue. That is why I indicated in my presentation 2 issues that we could not agree, because when he could not find his way on proving the cases around these 200 workers, then he wanted to use restructuring to flush them out. And we said, no ways, you're not going to do that. You're not going to use restructuring. Restructuring, it should be a no-fault dismissal. When he realized he can't win there, then they decided to abandon the restructuring because they couldn't prove. And that process was facilitated by CCMA. He then triggered a year later, in 2024, wanting to use benefits of the process that is dead. That is why our response was that if you are going to use that Section 189, we are going to respond with the same rights that we have on Section 189, which is strike. And that night, he even went to find securities to make sure when workers come there, I mean, that circle of head office was full of securities to deal with workers of NUMSA there. And it's the same night that he actually brought this interdict that he did not serve properly to our email and got interim order, which we defended in April and succeeded in May when the judgment was delivered.
Okay. I wish the committee or portfolio committee on transport was here, because these matters, we may visit them as SCOPA, but we can't move forward with them because they fall within operations. However, for clarity once more, we need to understand this. Are you saying to us, within the 200 and the allegations of transgressions were not true or they were not provided, do you have a file you can provide to us that individually from member A up to member 200, individually, there were no substantive charges that could lead to dismissal?
Come. You want to respond? Okay. No, that's fine. He will respond.
Thank you, Honourable Member. Thank you.
So will you switch off yours, Mr. James? And Honourable Member, I'll indulge to 5 more minutes.
Okay. Thank you. Chair, I just want to clarify this part that initially the intended number that was communicated to NUMSA by the previous CEO was 200 plus claims handlers that were identified to be corrupt. And eventually, the number of claims handlers that were put on suspension, and I think we've recorded this in our presentation, is approximately 50 or so. And none of these employees faced any allegations of fraud or corruption in their charge sheets. What was listed in the charge sheet was, I think, gross negligence and dereliction of duties in that they failed to load court orders within a specified period, which is 180 days. And I want to bring this context that as NUMSA, we've always held a view that these employees are being punished. They're punished for a systemic issue that they are not responsible for. We've outlined all the issues about the workload that they were faced with, the backlog, COVID-19 that happened, termination of the panel of attorneys, which literally led to them not being able to attend to emails. Because I want to clarify this part, Honourable Chair, that at the Road Fund, I think there's about 3 ways of receiving court orders from court. The first one is it being served via the correspondence department, which will then find its way to the relevant department and to the claims handler who must load it on the system. The second one is via email. The third one would be it being delivered by the attorney representing the Road Extent Fund, if, let's say, they had gotten it from the plaintiff attorney and all of that. Now, what gave rise to these allegations of gross negligence and dereliction of duties is that these claims handlers were not able to attend to their emails timelessly. They had a huge backlog, thousands of emails. And we always argued that this is a systemic issue that has caused these employees to not be able to deliver on time and all of that. So our view is that, yes, the initial target was about 200 plus, and what was said was that these employees are corrupt and none of them faced any criminal charges or cases being opened against them as a result of any involvement in corruption. Thank you.
I'll be mindful of how much time the other members spend and reallocate time, if that's okay. We're on 25 minutes for you.
Oh, sorry.
Yeah. So,
No, Chair, I just want us to be clear because the employee relations led evidence that the members were charged for not capturing the court orders within 180 days. And that leads to accumulation of costs or cost against a non-payment for the victims that are supposed to be getting their money. In debunking that, or rather clearing that that's not true, are you in a position to provide us with evidence of such, that it is not true that the workers committed gross negligence and dereliction of duty? We have evidence to that.
I suppose, Honorable Member, the onus rested with the employer to prove the allegation, which the employer have failed to prove the allegation. I mean, it's been years now. Us is to, the onus does not rest with the trade union or employee. If the employer is of the view that they have a case against these employees, they should have charged. That includes the ER that appear before this committee, who were presiding over all these matters with Letswal. None of them actually have been able to prove that these workers are corrupt. I mean that, I'm just saying that the period of time, if we are to look between 2021 and August, not August, October 2022, when the restructuring started, I mean, it's more than a year. Surely the company should have been able to prove its case by then and remove all those people that it regard as rotten in the process, in the system, and it failed.
Okay, so in a nutshell, there are no such allegations proven. That's it. Now, just one more last thing that I want to find. Before the arrival of the former CEO, what was the practice during the DC? Was the employer represented by lawyers against workers who are represented by shop stewards? Or was it employee relations or anyone at employee relations as chair and the prosecutor of the workplace against the shop steward? Were there lawyers featuring during DCs, or is it a latest practice?
Thank you, Honourable Member. Chair, I think I'll put it this way, that it was a combination of two approaches. One, the Road Extent Fund would be represented by an initiator or evidence leader, if you like, coming from the Employee Relations Department. And that evidence leader would be an employee relations specialist. In some instances, the Road Extent Fund would exercise its discretion and appoint an attorney to represent RAF as an evidence leader internally, prior to the arrival of the former CEO. And post the arrival of the former CEO, that practice continued, but the presence of lawyers in internal matters increased. Thank you.
Thank you, Chair. So lawyers were part of this. Thank you.
Thank you. Honorable Matiwane.
Ndibhodise namhlanje kumalungu ekomiti namalungu amele uNUMSA kunye nestaff sethu. Nami ndiphinde nditsho ndithi compliments of the new year. Nyaka omtsha. Sihlalo ndifuna uqala kule meeting. I want to start with the meeting that you had with the CEO. Was it a formal meeting where it is minuted?
I will regard as a formal meeting by the fact that you are called by the CEO. It's a formal meeting because he called his complement of management to be there. In particular, one of those that I could recall is the regional manager of Menlyn region. He was one of those, including the ER department was there, where he was actually sitting in front addressing all these issues. So I can't regard it as informal. If something is informal, he would have called me maybe in his office and speak to whatever he want to speak and then leave. But he called the full complement. That is why he requested. Also, I brought all subsquad of NUMSA, in particular those in Gauteng, excluding those in coastals.
Okay. No, not the meeting where he called the shop steward. The initial meeting where you had to leave the SAA business rescue to go and meet with him, where he provided a diagnosis of the challenges that he thinks exist in RAF.
Yes, it was. I also regard that one as formal because, I mean, our General Secretary is busy in many things, but I managed to find him. We drove together to meet him. And so that meeting was formal. That's where he actually unpacked his plan, which we supported.
Okay. So in his diagnosis of the challenges at NUMSA, at RAF, you are saying that you were in agreement with him, that he raised the question of corruption and the looting of funds by attorneys. When he speaks of attorneys, which attorneys was he speaking of?
No, he was speaking generally around attorneys. So ours was to see as he started to execute what he regarded as his plan, how he is going to execute his plan. Not because he was speaking general to say attorneys are corrupt. And there were times even publicly there were fight between him and attorneys public. So all that I know that what we were supporting, if there's malfeasance and he deals with that, we support that. Because ours is to ensure that the claimants are paid, workers are employed, and the entity continue to run its own business. As to what are the details behind that, that's his business. We'll see as he execute whether what he is saying, it makes difference.
So you say you agreed with the initial diagnosis that he provided in that initial meeting you had with him. What did you agree with him on which points? That these points really need to be prescribed, or these points need attention at RAF, according to your own assessment. You said he provided a diagnosis, and you agreed with that diagnosis. So can you share the concerns that NUMSA had, that the CEO had in his own diagnosis? I want specifics to say you agreed that there is corruption, or maybe there is a looting of RAF by attorneys. I want to get an understanding of what is it that NUMSA agreed with him, that in his diagnosis of the challenges that are there at RAF.
Ours, what we were supporting, if there is corruption taking place in the entity, it deals with the corruption. As to the detail of that corruption and which law firm that was looting, that was his business to execute. He never shared that information. He just gave us high-level information as to there were people who were looting REF. And I mean, we could see also REF balance sheet was not healthy at the time. So obvious, if there are people who are using REF to loot, which we are not saying they were not those people, but it was for him to prove and work in a structured manner to expose all the corruption that is taking place. Ours was not to get to the nitty-gritties of which law firm. We did not ask for data. We just listened his presentation. In our view, it made sense. And if then his intention was to clean the system, we supported that. As long as that system will make sure that REF deliver its mandate to claimants and workers are having a job security. That's what I can respond to you.
Perhaps let me be more direct on the issue of attorneys. He had an issue with the panel of attorneys. He was of the view that the panel of attorneys was looting the road accident fund. Would you agree with that?
I don't have the actual detail. As I indicated, we never requested the actual data of which of those firms. He gave us high level, and we then, on basis of what he was giving us, we will support any form that seeks to deal with transformation in road accident fund to ensure road accident fund does not continue to remain as a burden to taxpayers.
You speak of transformation. That was one of the issues that NUMSA had a particular interest in. What are the challenges around transformation within the road accident fund?
I mean, transformation is broad. Transformation can take place in different shape. Part of those, I mean, some of the issues we have raised that there were problems with the entity. I mean, first of all, getting an entity where workers come to work, they don't know whether they are going to be able to work. Anytime sheriff could come in and remove whatever entity and just leave file lying mixed up on the floor, that is part of transformation. And if you deal with the issue that there are challenges that relate to corruption and that actually overburden the financial status of road accident fund, it is the duty of the CEO to deal with that. Obvious, the board will always set the tone and give the strategy to turn around the entity. The CEO will execute in accordance.
Okay. Moving on to suspensions of the claims handlers. What was the role of the CEO in the debacle of the suspension of the claims handlers? Is it normal for the CEO to be involved if he was involved with claims handlers, or there were other senior management officials who were involved in the suspensions?
With my experience in trade union dealing with both private and public entity, it is not normal that you will deal with CEO going to do the operational issues to lower level employees. CEO will normally delegate to senior management who will also delegate to junior management. For instance, if we are to talk the hierarchy, Iron Burial was sort of like an executive. Below Iron Burial, you will have Motloding, who is the senior manager. Below him, you have Walter Ramas, who was also a senior manager below Motloding, who was more dealing with ER issues. Below Walter, you have number of ER specialists. So ordinarily, the issue will be driven through the level of Motloding and Walter. But in this instance, CEO was going himself to engage directly on these issues. He was the one who was calling meeting with employees and raising all the allegation against them and terrifying them. Because we were getting a lot of calls to that effect. So ordinarily, if I were to be straight, it's not normal for CEO to go himself and do the work of junior managers.
Okay, thank you. And then I want to check now in terms of the restructuring. Are you aware of any job evaluations that were conducted? And what is the role of the union when such a process is being done, when the company is going to do restructuring? How do you feature as a union? Before the restructuring, the actual restructuring, do you get consulted? Even for job evaluations, I'll make an example with the municipality. Now, how will be consulted when there are job evaluations that are going to be conducted? So I want to check whether the job evaluations that were done, how did they come, what was the rationale for the restructuring? And was NUMSA ever consulted before they came to present the final or restructuring model that they had?
NUMSA was not consulted, although that we engage with the employer even in CBC, which is collective bargaining structure, also deal with the employer with policies. If there are amendments in policies, ordinarily that will be engaged in the CBC. But on this one, NUMSA was not consulted. There's a presentation, in fact, which I think this presentation was done through consultants. It says leaping the, say, I will just, or leaping the road accident fund forward. And that presentation will show you very clear that people who were involved in the entire issue was senior managers and in a form of executive and general managers. That's also what their own presentation is stating. So the entire restructuring was done with general managers and executives. So the operational staff was not, as far as I know, were not involved. That is why in part of my presentation, I indicated that whilst I was busy with SAA, I had to intervene after Shokyo had raised concern in August and attended the CPC. That's where we indicated to management in that forum that that structure did not have a right to discuss the restructuring in that form. If they want to engage on restructuring, they must come and engage with the union separate, not on bargaining issues. So because they wanted to run through backdoor in order for them to steamroll the shopyard and implement something that they never consulted on. That is why we said, then if that is the case, you trigger Section 189 so that we have a structured process facilitated by CCMA.
So there were no job evaluations before the restructuring.
As far as I know, there were no job evaluation because they were not presented in the restructuring process. The list that we were provided with is the presentation of consultants, which the company themselves they could not, because part of the issue that came there was that part of the criteria of retrenchment will be culture fit. When we asked what does culture fit means, they could not explain. So it means that I will just look at C and say, "Hi, you don't fit in our culture, so I'm retrenching you." That's what put us to be on crossroads. Because if you come with presentation, you must be able to articulate to its logical conclusion. So job evaluation, no, because that should have been presented, job evaluation. Because ordinarily when companies are making a restructuring, this thing starts from the board when they are pulling the strategy. Once they pull their strategy, they are giving the direction. I mean, even if you can compare in the same period, the strategic plan of REF and annual performance plan, they does not talk to what REF was doing. So as to how did REF get to where it was, it's only management knows. That thing of the year, that restructuring was dead from the start, before it even got to, because they couldn't even understand their own restructuring.
I'm getting I'm trying to get to an understanding if there was a build-up, if there was maybe a conflict between on most of things that you would expect a union to be informed of. For example, we are saying there were no job evaluations. You're saying that there was no consultation between the union and management. So was there a breakdown, a point where you can point to say there was a breakdown between the union and the executives, which eventually led to the termination of your recognition as the lead union within the Road Accident Fund?
First, I need to indicate that between the restructuring and termination of the agreement, there is almost a year in between. So the only breakdown that could have been is for us to defend our members in the process of retrenchment using the legal instruments in a form of Section 189 to say, show us rationale. Section 189, we must reach consensus. We must find solution together. You can't come and want us to endorse something that is going to throw more than 200 workers. I mean, we know one worker might be supporting around 5 people. So if you throw more than 200 workers on the street with something that you are not sure of. Because I suppose now, if really this thing of is it integrated case management system was genuine, REF should have been transformed by now, which that is not the case. So this issue basically the report that, the presentation that I'm talking about, leaping, it says it's a proposed, and even management don't understand. I mean, there are various ways of dealing with integrated. At least by the time you get to that point, you're supposed to have tested the system and see that the system is fit for purpose. Then you see that now I have this pool of workers that ordinarily would have done this work. But now, because the system is more efficient doing all this work, I have this pool that I can utilize. Then subsequently, if you have clear strategy that is structured, that is well thought, then you will then say, I need to reduce my workforce with the X amount of workers. So there are two ways of dealing with it. There's something that I will regard as a soft restructuring, to say, I'm gonna just give voluntary severance packages to those who are close to retirement. And in order to reduce that, so that I take the young ones to fill in the position. That was not the case.
One more.
Okay, last one.
Yeah.
I want to have to make a conclusion for myself after your presentation. Would you say that the plan to do away with the claims handlers was to make way for the Bokamoso contract? Or because the allegation you make, you say that the former CEO was a bully who bullied employees, and then when he couldn't get his way, he went for restructuring. That's a different issue. And then there's the Bokamisa issue, which is part of the restructuring, which would have replaced the proposed people who were going to be retrenched. So I want to get a causal link between the retrenchments and the introduction. Would you say there is a causal link between the retrenchments and the introduction of Bokamoso, or it was just internal workplace dynamics that led to the suspensions? And the final question would be, how much did you lose in subscription fees when your services were terminated from Road Accident Fund? Thank you.
So I'll partially respond on that. First, without getting to Bokamoso, the first starting point is to first deal with the issue that if then I'm outsourcing this service and I'm having a department that runs this service, what benefit that I am going to derive from outsourcing? Here I'm paying a flat cost in a form of salary. Here I will pay a contract that will continue to increase based on inflation or whatever that comes. So if then you talk outsourcing, you need to justify the benefits of outsourcing, which that with Section 189 has not come forth from management. So introduction of Bokamoso, I can't be able to understand how do you introduce something that you don't know what benefits that you are going to derive. As much as I think it is upon this committee to demand from management to give the cost of that staff that they have employed and the cost of Bokamoso, and then you reconcile the two and see whether there was a benefit with outsourcing or not. I think that should be a starting point. Because here you have fixed cost of few employees, now you are outsourcing the service. We know the outsourcing, both from private sector and public sector. A lot of outsourcing was meant for other intentions. That is why currently some companies now have rethink. That thing is coming from 80s, 90s of outsourcing. Even if you go to globally, now companies are starting to insource some services because this thing came on basis of core and non-core. And if we are to talk about call center, it's a core business of road accident fund. You can't regard as non-core. What you outsource is non-core. Even with non-core, you need to rethink whether you are going to derive benefit out of that. On the latter issue of subscription, at least what we have been losing a month should not be less than 250,000. On basis of wrong allegations. And it is our duty to recover the cost that we have lost as a trade union. That is why we thought that when the Minister of Transport brought a new board, we thought, let's write to the new board and indicate, which we wrote through the office of the board secretary. They have not responded. So we regard them as accomplices. When we seek cost, we're going to seek cost to road accident fund. Because there's this tendency of public servant to think that they will use the public funds willy-nilly because it's not their money. Thank you.
May I just...
Thank you.
Okay.
May I also ask that we keep our answers concise, because we will leave at night if we don't. So that will happen. You can add quickly, then I'll allow you to close, Honorable.
Thank you, Honorable Chair. Thanks, Honorable Member. I think I just want to clarify this part, that Project Bukamuso, the integrated claims management system, and the failed retrenchments are interlinked. You can't separate them. The reason why I'm saying this is because when the idea of Project Bukamuso and the integrated claims management system was introduced to NUMSA, what was stressed by the CEO was that as a result of the introduction of the new system, a certain number of employees will not be required going forward. Even the notice of Section 189 that was issued following the meeting that we had with the CEO, issued by the Road Extent Fund, stated clearly that the Road Extent Fund is undergoing restructuring because there's an introduction of a new system called the Integrated Claims Management System, which will automate the claims processing, or rather the claims management process of the Road Extent Fund. Thanks.
You can close. You said you had an observation to share. I listened when you were speaking. Or did I mistake you?
No.
You asked a question and then you said you will share your conclusion. So I noted that you had not yet done so.
No, I'm going to reserve my conclusion.
You will reserve it. Okay. Okay. No, that's fine. Okay. Isaac?
Thank you, Chair. Morning, colleagues. Chair, lots has been said. I appreciate the input. And so, yeah, you've alluded to my 5 minutes, which I shall keep within the time frame.
Don't worry, I like you this year.
Great.
I won't cut you off.
Also,
New year, new me.
also, we're off to a great start for 26. Well done, Chair. Okay. Mr. Mbali, yeah, we just heard the discussion regarding the Bokomoso project, and of course, you know, in reading the documents, cost of some 800 odd million rand to introduce this. Some numbers get frightening as you read the report. I just very briefly, in your opinion, with the introduction of this program, and as was alluded to by the CEO in your discussions, I mean, was there any talk about training of the staff for the employees in terms of the introduction of this program and how they were then going to roll it out? So the employees involved with this program, were they then afforded the opportunity to be trained? And so that's the first one. Maybe just a short, concise one from you. Thanks.
Thank you, Honourable Member. To answer your question briefly, there wasn't any talks about employees being trained in order to be able to use the new system. What I do recall, or at least to the best of my recollection, is that employees that were actually trained were employees that were hired by Alteram, which is the external call center that replaced the internal call center of Road Extent Fund. And this is where the irony is. The employees that were removed from the internal call center of Road Extent Fund, a select few of them were identified to give training to the Alteram call center agents, which were effectively from the external call center. But as far as the integrated claims management system, there wasn't any talks about employees being trained. And in fact, an assertion that was made was that claims handlers would no longer be required going forward. In other words, the system is going to automate the entire claims management process. But to our surprise, claims handlers continue to work on the integrated claims management system to date. Yet, the assertion was that they are not going to be needed going forward. Thank you.
Okay, well, thanks for that explanation, but that is exactly why I asked the question. Because I was trying to piece this thing together, based on the discussions that transpired earlier. So I just needed to get a level of understanding, and that was obviously a great foundation for breakdown in communication within the organization in terms of this 800 million rand spend. That is what I just needed to understand. So I'm not going to be repetitive of what has been discussed and said. If I might ask this one, maybe Mr. James would like to answer this one. What are your comments regarding the SIU investigations that have been transpiring thus far? If you would like to comment, anybody, Mr. James, Mr. Mbali.
No, I have no idea around the SIU within REF, what they are doing. So I can't comment.
Okay, so you haven't been following this matter in terms of the SIU investigations within the employees, etc., and what has transpired. You're not aware of what's going on there, right?
Not really. Not
okay.
really.
No, fair enough. I won't push you on that one. So the questions are for the board. Let's just move on. Mr. Beasley's waiting down there anxiously to get involved. So let's just move along here.
Don't worry, he's undercover. He's undercover.
Thanks, Mr. Mbali, Mr. James, Mr. Mugambi, I read here, and sometimes with dismay, because we've been involved in huge discussions with the Road Accident Fund towards the latter part of last year. I mean, this matter seems to have been unfolding since the early 2020s. That's my understanding here. It is now 2026. So we're 6 years down the line now, okay? And we've seen people come and go within the organization. Then there was this issue now as at November 2025. I remember I'm skipping a lot of parts now because I don't want to be repetitive, okay? So what transpired in the last 6 years with obviously all the investigations, etc. It seems to be just a protracted matter ongoing. But we now, ESCOP, are tasked to bring this matter to some finality. And I can tell you, with the guidance and leadership of the chair, we are going to get somewhere with this matter. So, be that as it may, now in November 25, that's what, some 2 months ago, there's alluded to that there are still some 50 to 60 employees that are being paid full pay, still sitting at home into their 4th year, if not their 5th year. Okay? Now, where are these people now? Are they still sitting at home, getting full pay, full medical aid, pension, and it's all well and good? I want to just ask you that concisely, because I want to move on to something quicker.
Thank you, Honourable Member. Chair, we are certain that from the initial number of suspended employees, there are employees that had actually won their cases. The employer refused to reinstate them. There are employees who passed away, some resigned, and so forth. We are just not certain at this point in time as to how many employees are still remaining on suspension. However, we are aware that the new board had taken an initiative to review certain cases and reinstate employees. I think I'm aware of about probably 2 employees from that list who have been effectively reinstated. And obviously, on grounds that there wasn't any concrete case or at least evidence against these employees. And our view as NUMSA is that this is precisely why these cases have taken this long without these employees being actually processed and all of that. Some of them have been charged. They've appeared in disciplinary hearings. The disciplinary hearings have been postponed a number of times. So to answer your question briefly, I do not know at this point in time as to what's the exact number, but I can confirm that some employees, like I said, have been reinstated, some resigned, and some passed away. Thank you.
Thank you for that. You know, and if I hear and I read, and then I go to, for example, paragraph 3.1.24, and then just to make it easier to cross-reference, under misrepresentation of purpose, and the first paragraph there, the last line speaks to by acting against allegedly collusive staff. Okay? Now, it's a strong statement in that you, as NUMSA, obviously are representing members that obviously belong to NUMSA. Now, obviously, you would have taken strong and vehement objection to that. You know, RAF's leadership publicly framed these suspensions as an anti-corruption purge, even informing SCOPA in earlier engagements that they were uprooting corruption by acting against allegedly collusive staff. Now, I know this might be a difficult one for you, but I must ask you this. After having looked at everything, huge discussions, in your opinion, would you say, quite frankly, that they were perhaps, might just have been some collusive staff for that you represent under NUMSA?
Thank you, Honourable Member. Chair, from where I'm sitting, I can't conclusively confirm nor deny that there are staff members within the Road Extent Fund that are corrupt. What I can confirm is that from the suspended employees that were accused of being corrupt, none of them faced any charges of corruption, whether criminally or in terms of internal processes. None of them.
Thank you for that one. And then, yeah, I'm going to move towards concluding. I just wanted to understand now, prior to NUMSA, there was the other union, SATAU. Okay? So they, according to what I read, is that they used to be representing the major members or employees, if I can put it that way. So now, what are your comments to the SATAU matter? Are they still involved? Are they other employees that still belong and are part of SATAU? Just to educate me, if you could just explain that to the members of the committee.
Thank you, honorable member. I think majority of workers who are affiliated to SATAU joined NUMSA. So what has come up in the process was that the full-time shop steward wanted to revive SATAU, but they could not enjoy support from workers. And subsequently, then they moved to find the current union now to be affiliated under NEHAU. So there has not been that much of an issue between the transition of workers from SATAU to NUMSA. Workers just decided decisively they are leaving SATAU, they are joining NUMSA, and they joined NUMSA in numbers. That's what led us to get into recognition with the Road Accident Fund. Thank you.
Thank you, Chair. As you can see, I was concise, to the point. Thank you for the opportunity.
Highly unusual for this honorable member. You know, very highly unusual. He normally keeps witnesses the longest. No. I'm kidding. I sometimes skip him accidentally. So that's why I said I like him this year. And then he says, I know I'm not your favorite. But Honorable Skosana is up next. By the way, we've got more than one Honorable Skosana in the committee, but the other one is doing duty in the more exciting committee, the ad hoc. But the family is very well represented here, the clan. Honorable Skosana.
The attire is always somewhat different.
Yeah, no, thank you very much. Yeah, we are running this parliament as Kosalas. That's what I like to do. Yeah, no, Chair, no, thank you very much, and good day, or is it good afternoon? Yeah, good afternoon to all the colleagues and our colleagues from NUMSA and our other colleagues from the administration and other stakeholders that are present. And Happy New Year to everyone. I guess we have to say that today so that we exhaust it. We don't have to repeat it again. No, we appreciate this opportunity to have a conversation with NUMSA. I think I was talking to one of my colleagues who's not here today, Mr. Madlala, at some point. And asking myself to say, but is there a union at RAF when we're listening to all the matters that have been ventilated in this committee? So we had that discussion, but is there a union there? How come are we hearing all these things? I mean, if there's a union, the union should have dealt with these particular matters. Well, I'm happy that at least today we know that you have been there as NUMSA. Well, at some point, like my colleague is indicating, I think there was SATAU, and now there's I think there's also NEHAU and stuff like that. I think we appreciate to hear that and to hear your point of view as far as the matters that were ventilated in this committee are concerned. And I agree with Honorable Mente that I think most of the things that you are telling us, we're not hearing them for the first time. A number of witnesses who appeared before this committee, I think they've ventilated those particular matters. But it's quite refreshing I think, to hear them from yourself as a union. One, I want to check. I think I've heard that there are instances where a chair of the DC will find an employee not guilty. But then the management would abandon the case, and then the employee will remain suspended. I just want to find out how does that happen, because my understanding is that if the chair of the DC has issued a verdict that said, Skosana as a suspended employee, you are found not guilty, so you have to go back to work on a certain date. On that date, I must just go back to work. How does it happen that when the chair of the DC has issued a verdict that I'm not guilty and I must go back to work, but still I remain suspended? How does that happen?
Thank you, Honourable Member. I'm going to answer this question in this fashion, that initially, and before the arrival of the former CEO, the Road Extent Fund had a disciplinary policy that dictated that a disciplinary hearing may take place in two forms. One, it may be an informal disciplinary hearing or a formal disciplinary hearing. The policy then would empower the chairperson of a disciplinary hearing, who ought to be independent, to make a recommendation on whether or not the employee has been found guilty, and thereafter, what is the appropriate sanction. Upon issuing the appropriate sanction, management would then implement the outcome thereof. Post the arrival of the CEO, one of the first things that he did was to ensure that the disciplinary policy is amended. And there was a very critical clause that was inserted. And that clause dealt with whether or not the employer has got the right to say, I accept the recommendation of the chairperson or not. In the event that the employer feels that the chairperson did not probably issue an appropriate sanction, then the CEO has got a right to say, give me a reason why I should not dismiss you, despite the fact that the chairperson has acquitted you. Further, if the CEO is not convinced with your explanation, he would then give a recommendation that your employment must be terminated. That then would explain why an employee, despite having received an outcome which is favorable to the employee, continue to stay at home on suspension, because there's a process that needs to be followed. The initiator in the matter, which is the employee relations specialist, would have to formulate a memorandum which has to be taken to the CEO's office. And the former CEO would take time to consider and sign those memorandums. That's what would cause employees to stay on suspension despite having won their disciplinary hearings. And in the event that the CEO differs with the outcome that says reinstate, then a decision will be taken that you are dismissed, and you shall take your matter to the CCMA. Thank you.
Yeah, no. Yeah, no, it's for the first time that I'm hearing of that kind of a situation. But then when those amendments were made on how the powers of the chair of the disciplinary hearing, when the amendment were made that the chair of the DC, the verdict from the chair of the DC, it's not binding, it's just a recommendation. The person who's got the final say at the end is the CEO. When those amendments were made, you as unions, were you not consulted?
Thank you, Honourable Member. Chair, I think that's a very critical question. It's very important, because any trade union ought to be consulted when there is such important changes that are taking place in the workplace, especially where it concerns the conditions of employment of the members or employees. I would put it this way, Honourable Member, that there was a consultation that took place at the Central Bargaining Committee of the Road Extent Fund. However, that consultation was just a formality. It was just a box-ticking exercise. That document was presented in the Central Bargaining Committee, and we commented as NUMSA. And of course, we were opposed to that. But the employer went on to implement irrespective of our position. And if I recall, one of the things that the CEO had said was that he is not going to co-manage the Road Extent Fund with the union, which was never our intention, by the way. Ours was to represent the interests of our members. But of course, we have taken the matter to the CCMA naturally, because that to us amounts to a unilateral change to conditions of employment of our members without consultation. And this is not a unique matter. There's so many policies that actually were presented at CPC. We made inputs as labor, and we realized that the employer is going to implement anyway. And we've actually challenged those matters at the CCMA to an extent that the head office of CCMA had said that perhaps there should be an intervention by the CCMA to mediate between the Road Extent Fund and NUMSA, because it's apparent that there's a lot of disputes that are actually referred by NUMSA to the CCMA. So the long and short is that, yes, we were consulted, but that was just a box-ticking exercise. Thank you.
No, thank you very much. So with regards to the issue of doing away with the panel of attorneys, which I think you indicated that the former CEO related that to you, and the reason was that you want to save money from that panel of attorney and channel more money to road accident victims, of which I think that's it's on a face value, it's a good intention that he wants road accident victims to be the ones to be the people that benefit more from road accident fund. But now, as to how was he, what was his plan in terms of the management of the claims? Because subsequent to that, the challenge was that now the claim handlers are now were therefore unable to handle the claim to an extent that one claim handler ended up handling more than 2,000 claims. So during your engagements, was it not made clear as to how then, after doing away with the panel of attorneys, how then were the claims handlers going to be able to handle the claims moving forward? What was the discussion regarding that?
Thank you, Honourable Member. Chair, there was never any plan that was presented to NUMSA in terms of how this influx of work coming from the panel of attorneys is going to be managed going forward. And in fact, we were proactive as NUMSA in terms of raising that before management could speak to it. What I can confirm is that the CEO was dismissive in that he never wanted to accept that these employees are overworked. He never wanted to accept the workload. In fact, what he had said to NUMSA was that what is going to happen is that he's going to instruct Mr. Ian Burrell, I think he was head of human capital at the time, if I'm not mistaken, to conduct a work study to establish as to how is the workload looking like and what is causing it to be that way, and going forward, how is work going to be managed? But a plan was never presented, it never came forth. To an extent that we followed up as NUMSA to say, how far are you with the work study? But nothing was actually coming forth. So long and short, there was never any plan put in place. And that's why the Road Extent Fund finds itself in this mess today. Thank you.
No, thank you very much. Now, with regards to the issue of the cancellation of your recognition, which you indicated that the matter is in court as we speak, and then that the majority of members that you had, you are still having even now, which is about 1,600, and then you've got Nihau, which is having less than 500, I think. So what is the current status of workers' representation as things stands? Because you are still in court, meaningly you don't have your full status of representing the majority of workers there. Yet you've got NIHAU, which is representing a quarter or less than a quarter of the employees there. If there are issues that require workers, organized labor at the moment, how is the institution handling that? Because you are still in court, and then NIHAU is there, but they are only representing a quarter or less of the workers. How, at the current moment, what is the situation there?
Thank you, Honourable Member. I'll partially answer the question and I'll hand over to Comrade Viewer if there's anything that I've actually left out. The lived reality at the Road Accident Fund, Chair, as things stand, is that workers are left unrepresented, unorganized. Workers are refusing to join NEHAU. They still demand that NUMSA should come back, and they are rooting for NUMSA to come back and organize them once more. Workers have not lost their confidence in NUMSA. The only challenge that they are having right now is that they are sitting with a union that they feel, so they say, has been imposed on them. And the reason why they are saying this is that majority of them have not joined NEHAU. What NEHAU did was to organize employees that were not organized by NUMSA at the time. A select few actually left NUMSA. I think, if I'm not mistaken, Comrade Viewers, it was about 200 or so from the 1,600 members that we were actually organizing. And it's sad because those members are calling NUMSA almost daily, that when are you coming back? We want to be organized by you. We want to be represented by you. We still receive requests from workers to represent them in disciplinary hearings and so forth, and including the CCMA and all of that. So that's the lived reality at the Road Accident Fund currently. Thank you.
No, thank you very much. So you said that you started organizing at RAF in 2017. So when exactly did your problems start? Would you say your problem started after the arrival of, after the appointment of Mr. Collins Litswalo as the CEO?
Thank you, Honourable Member. We have not had any issue until 2022 when there was restructuring. And because the issue of suspension initially we have allowed it to unfold for inquiries to take place with a view that the company will prove its own case, which that was not the case. But when there was a threat of mass dismissal, that's where our problem started. And subsequent to that, after the company abandoned the restructuring, there was a period of a year which the company was quiet, the union was doing its own business, until the company wanted to resuscitate again the process of restructuring that it has abandoned a year ago, which that's where the problem started. If I were to summarize, thank you.
Okay, no, thank you. Now we've heard from other witnesses that some employees were charged even though their line managers didn't find any prima facie evidence against them. And I think in terms of the norm and in terms of the relevant legislations, I think line managers are also expected to play a role in this disciplinary processes. But then some of the witnesses indicated that there are line managers who did their own preliminary in internal investigation processes, and they did not find any prima facie evidence to warrant the charging of a member and suspension and all that. And I think Mr. Litswalo M, who was the ER manager, I think when he was here, I think I posed that question to him. And I think he indicated that from their side, as the ER department, they did try, I think, to reason with the office of the CEO and try to halt some of the suspensions, which in their view they felt that were not procedural and what. However, they were pressurized to an extent that they ended up succumbing and allowing other employees to be suspended without due processes. What is your understanding about this as the union? Because I think you are a key stakeholder there. I think you are involved in all these things. Are you aware that some line managers were not involved, or that there are people who were charged and suspended without their line managers finding any prima facie evidence against them, and that the ER department tried to assist some of the employees, however they were pressurized? What is your understanding about the handling of all these suspensions, especially those mass suspensions that happened?
One thing that I can remove the employer relation is the issue it has mitigated for these workers not to be charged, because at no stage that the ER have raised that with the union. The least that we know is that the ER was the one that was charging, allocating presiding officers over these workers. That is why when we were I was making presentation earlier on, I indicated that they were full-time secured of NUMSA, one responsible for inland, one for coastal. So both of them were busy attending these cases all over the country. So at no stage where we could find sense that ER was sympathetic to these workers. It's new to us, because they were one who was were driving this thing. I mean, I could remember now last year, just towards the end of last year, one of our full-time had to go, which we made arrangement for his traveling and accommodation to defend one of the workers. And that worker also was not found guilty. Thank you.
Okay, no, thank you very much. My last but one question, how many members do you have as the union in the whole country as NUMSA?
Our membership might be between 340,000 and 360,000.
Okay, so you are above 300,000 members. Okay. I think you indicated that you yourself, Mr. James, and your General Secretary met. I think you left another meeting to go and meet with the former CEO. So I just want to find out as whether it is a norm in your union that I mean, the person who's holding such a high office like the General Secretary would go and meet with a CEO of one of the entities, whereas you do have the leadership in different levels. And when I'm comparing the membership that you have versus your total membership versus the employees that we are representing at RAF, which is only 1,600. It's less than a percentage of your total members. Is it a norm that your general secretary would go and meet with a CEO of an entity, which is a very important entity, but which you've got very few members compared to your entire membership? Is it it's something that normally happens, or it was just once in a while there were some critical matters that the General Secretary felt that it's important for him to personally go and engage with Mr. Litswalo, whereas you do have leadership, I think, structures at the level, at that particular level, that can engage with the CEO?
If I may respond, yes, it is. NUMSA has 3 levels. We have local. Local will deal with issues, your day-to-day issues. And we have the regional teams in our region that deals with all the regional matters. Then you have head office, in particular the department which I'm heading, which is the operation. So basically, I work with the General Secretary on issues that need serious attention that might have implication to workers. Either I deal with them direct, but when I am of the view that probably he also needs just to engage so that he have sense of the indeed. In particular, when there's a new CEO, to engage and understand the direction that he goes. So it's a norm, not only with road accident fund, across all the industries. NUMSA, we don't treat companies on basis of numbers. Even if the company, there's one member that comes to NUMSA head office, we treat that member with all the dignity that we are guided by NUMSA membership charter, which one of its purpose, it says above all members first. So that's how we interact with companies. We don't look in numbers, but mainly head office is focusing on critical issues like restructuring and national negotiation. If there will be strikes, head office intervene.
No, I'm happy with that answer. Because the reason that I'm asking, there are 2 ways to look at this matter. The positive one would be, it would show that the General Secretary he is highly involved and committed, and then he pay attention to details and to all the members, which is a good thing. But the negative part of it might be that you might find a CEO or any leader of a certain institution end up undermining your leadership at that level. To say, no, I don't have to talk to you, I will talk to your General Secretary. I've got a direct access to your General Secretary, so I don't have to talk to you anything. So that might be the negative part of it. But I think I'm happy the way you have explained it. No, thanks, Chair.
And don't worry, Honorable Scosen, I won't speak directly to the Chief Whip. I'll speak to you. Thank you, Honorable Pila.
Thank you, Chair. Good day and compliments of the new season. Let me join the people who are owning the Parliament to welcome the presentation or the submission by NUMSA. I just want to sympathize with you guys. After supporting the vision of the former CEO, without knowing that something big is coming your way, which will lead you into the situation where you are now. Sorry for that. I just want to check with you, were you still in the representing RAF employees as a union when the restructuring process started?
That's correct, honorable member. We were representing workers at RAF.
Thank you for that answer. According to Section 189 of the South African Labour Relations Act, I think there are requirements that need to be followed when dealing with this process. One of them, it requires the employers to follow a fair consultative process in order to minimize job losses. And it mandates meaningful joint consensus seeking between employers and employees regarding alternative to dismissal, the selection criteria, and severance pay. According to your knowledge, was this process done according to what the Section 189 requires?
No, I can't agree with that.
Can you briefly explain why are you not agreeing with the...
Thank you, honorable member. I think, let me appreciate that you highlighted critical issues that becomes the foundation of Section 189, which deals with fairness to mitigate job losses. But obvious, before you even get to that, you need to come with a rationale. And that's where the ball could not move from center on the rationale. Because if then you are able to justify the rationale, then it means that you are going to justify why there must be job losses. And then we find alternative measures. When we find alternative members, we can find alternative members such as training layoff scheme, just to buy time until the company find its fit, whilst you are reskilling or upskilling workers. Because once you do that, you are also saying that even if I'm not gonna use them, I can then be able to look my sister entities and second them, instead of them going to street to be taken by the sister entities. That has always been some of the measures in public entities. But the sticking point, which obviously have made us to not to be in good terms, was to interrogate the rationale, which the company dismally failed to explain its own rationale. So that is why we believe that there has not been fairness in the entire process. And the process was not, I mean, management thought they were going to take something from consultant and just impose it without having to put their mind on it. In fact, the responsibility of working on the strategy is a responsibility of the board. So if then the board is of the view that we need to bring efficiency, that's okay. To remove all inefficiencies. If you intend to introduce integrated system, that's fine. But you must be able to justify this integrated system. How is it going to benefit the company? How is it going to be effectively respond to claimants? But management could not get to be able to explain that. When I'm talking about management, starting from the CEO, Ian Bariel, Yomoto Ding, all of them could not. Instead, they decided to run away from the process and send their juniors.
If I may add, Honourable Member, just speaking to the question of the rationale, at some stage, the former CEO had mentioned to NUMSA shop stewards that the Road Extent Fund does not have a problem with paying the salaries of its employees, which actually confused us as to why then do you want to retrench them if you can boldly confirm that the Road Extent Fund does not have a problem with paying salaries. Left us confused. Additionally, during the consultation, the Road Extent Fund pulled out of that meeting before the conclusion, effectively saying that on their part they are done. They are convinced that they are going ahead with the retrenchments, and they will implement the retrenchments in line with the criterion that we had actually disputed as NUMSA, which involved the culture fit assessments and so forth. Thank you.
Thank you. There was a time, I can't remember the year, where some of the specialists were brought into a road accident fund, coming to replace the employees who were there before. Were you consultant as a union to say that an expert on this level is being brought to the organization to come and help on other matters there?
No, thank you. I don't recall any consultation to that effect. My issue is that public entity have this tendency of bringing consultants, because, for instance, we raised the issue that there were level of junior old managers with experience who were sidelined in the process. So, because of they have their own view around the entity and the CEO has his own view. So we're not consulted.
Thank you. During your presentation here, you make made of two things that the management were focusing on when implementing this process of restructuring. One, you said it was to deal with suspended employees. The second one was to close 2 offices, the East London and the KZN one. I just want to check if those 2 offices are still closed for now or they are fully operational.
Thank you, Honorable Member. The offices were not closed because when the company then wanted to close them, we pushed back on them, and leading to the facilitation by SSME. So in reality, those offices were not closed because the basis to close those offices is that those offices, they were corrupt, employees, they were corrupt. The only office that was performing was Cape Town. And that's how we end up getting to Section 189 facilitated by SSME. Because if we talk about those 2 offices, they were also going to partly cater some of the suspended employees.
Thank you for that explanation. I just want to check one question here, which was asked by my brother, Honorable Esak, the one of the suspended employees. You said you are not sure where are they, some of them now. I think because they were affiliating to NUMSA, even if your contract have been terminated from RAF, you do have their contact numbers, you do have their names. Can you please check on them? Where are they now? so that their matters can be taken forward so that they can be able to be reinstated or to get a job elsewhere. Lastly, Honorable Chair, I just want to check from NUMSA, when all these things happening, did you raise alarm regarding this to the board?
There has been a number of correspondences returned to board. Even before this whole thing, there were some meetings where we met with the board. But the last time we met with the board, it was the time when they were talking about reps, where the change of legislation. And subsequent to that, the board did not cooperate with anything because Letsoalo was running the show.
Okay. You also indicated that employees at the Road Accident Fund, they don't want to join NEHAW. What is it that you are going to do now as NUMSA to make sure that those employees are members of NUMSA as a union? Because they need to be represented by union. They can't be left in that way. What is it that you are going to do?
No, we still assist those who come forward. As I indicated that, for instance, last year, one of them had to undergo to disciplinary inquiry, and we had to arrange traveling and accommodation, and for one of our secured to go and represent that worker in a different province, which we assisted. But sometimes there is a problem when workers are still getting money, they become comfortable and keep quiet as long as they are still finding money. But we appreciate your input to say that let's continue to reach out to them, which we will do that. Thank you.
Thank you, Chair. I think in terms of time management, I tried.
Honorable Bila, you continue to walk away with the gold medal. I'm about to end the competition now. So we must just give it to you.
Thank you in advance.
Before we start, we just give it to you and everyone fights for silver. Thank you. Honorable Nilme.
Good afternoon to my colleagues, to Chairperson, and to our representatives from NUMSA, and compliments of the season to you all. I want to just take a few steps back because I wanted to actually just have a look at the original cancellation of your agreement. Was it the RAF board that actually did the termination of the agreement? Was it management or was it the CEO? And if it was the CEO, did he just basically inform the board and they then approved the termination prior to even the implementation? I wanted to have a look at the sort of serious governance failure of that board at that time.
As far as we know, we got letter of the intention to terminate, was it February 2024? March, yeah. February or March, from one of the ER managers, which we responded. And subsequently, then the CEO went ahead with his down variation of condition of employment outside the process, and also with the possibility of termination. Then we responded to say that if then you want to revive Section 189 benefits, we are going to do the same, because the Labor Relations Section 189 gave us two options: either we strike or we go to labor court. And when we weigh, our labor court could take more than 5 years without finalizing the matter. The only solution was to take our members' power. When he actually look his risk, because if we take our members' power, it will mean that 1,600 workers were going to withdraw their labor. Then he realized that the only option was to terminate our agreement. The following day, he terminated our agreement. The next day, he signed a new agreement with NEHAO.
And so, and that's the reason I asked the question, was what was the involvement of the board? Did he go back to the board after he had written the letter to you and asked them to ratify it? Or was the RAF board on board with all the activities that he was involved in with regards to your termination?
As I indicated, I mean, the board, I think the last time we spoke with the board, that was probably before COVID. So we can't say anything with the board. The least that we know is that ER issued the letter of termination, and we then come across the signed agreement of NEHAO by the CEO, Letsoalo.
Now, in hindsight, what would NUMSA have done differently had you now seen all the sort of challenges that have since occurred? Would you have possibly invoked your rights at that stage? Or, because what we've seen is there was smoke and mirrors. He was playing a game, he was talking to you, hedged his bets, and then terminated. But in hindsight, what would you have done differently? Because my next question is, how would NUMSA characterize the current state of labor relations at RAF?
The current labor relation does not serve the purpose of the labor relations, or to democratize the workplace and allow the workers, in terms of Section 23 of the Constitution, to have freedom of associate and join the union of their choice. Basically, what he was doing, he was actually doing what Section 5 of Section 4 and Section 5 of the labor relation are against, or to coerce workers to do what you want, which is regarded by Section 5 as a victimization. And actually by Section 4, but Section 5 gives protection to workers. That is why we thought, because we had a choice, if we were reckless, we could have short-circuited this entire process, even after termination, by responding by strike again. There's nothing stopping us in law to respond with strike, to force him to reinstate that. Because the matter had went to court, we thought, let's allow the court processes to unfold. If that fails, then we'll use our alternative, which is Section 64 of the labor relation, to go on strike, to force him. And unfortunately, he's out of the system. As long as our agreement is terminated, we regard that the current management and the board are accomplices to Letsoalo. If they are not, they should have reinstated our agreement, because the longer you keep, the more you expose REF to unnecessary costs, because we will have to recover what we have lost financially out of REF.
Hence, I asked that question because there is a new acting CEO and there is a board, even though it is a temporary board. Have you gone back to the new acting CEO and to the current board that has been put in there?
Certainly we have. We have written to the office of the company secretary and to summarize the issues, and also requested them to meet. And we have never received acknowledgement. We have not received any response to that. Probably that letter was it September last year. So that is why we are of the view they are accomplices.
Have you tried engaging the Minister of Transport or the Deputy Minister, seeing the Deputy Minister is aware of the circumstances surrounding RAF?
That's correct. The General Secretary of NUMSA engaged the Minister personally. And subsequently, the Minister requested him to write all the issues. And he wrote, and until today, there is no acknowledgement from the Minister, no response from the Minister.
No, thank you very much. Because later this week, if I'm not mistaken, we will be speaking to the Minister. No, thank you very much. Most of my questions have been answered because we're at the end of the queue here. The only last one that I did have as a thing was to your knowledge, the unsafe conditions, working conditions at the offices of RAF in Johannesburg and in East London and Durban. To your knowledge, has that been attended to?
The Johannesburg, how it was attended when REF moved from city center in Johannesburg to Parktown by getting a new office in Parktown. But the issue of Menlyn has not been. And you can't even blame the landlord because REF is a landlord if they are not doing maintenance. And if they don't make sure that the work environment is conducive for workers to work and be productive, then REF needs to take responsibility.
May I just make a brief addition that in as much as the office has actually relocated from city center to Parktown, there are still issues with the Parktown office surrounding the safety of the employees there. Employees are getting mugged in that area when they leave the premises after work and all of that. So it's something that the employer needs to really look into, because we understand the fact that, yes, the employer is not responsible necessarily for what is happening in the streets. Perhaps that is the responsibility of SAPS and other law enforcement agencies. However, a caring employer would see to it that the security guards that are operating at RAF are not only limited to the employees inside the premises, but also the precinct where the RAF is there is equally crucial as well. When it comes to Menlyn, we had to force the employer via the Department of Labor to basically relocate from the Menlyn office to the Hatfield office, which has effectively happened. What had actually happened is that the employer refused to acknowledge that the building is simply dilapidated. The building is simply rotten because it leaks when it's raining and all of that. And workers are affected by this. Workers are working close. We're working close to electricity boards that were actually exposed. You could see the wiring next to where the employees were sitting and all of that. That's how bad the situation was. I was personally involved in that matter, wherein we made a referral to the Department of Labor. When Labor came to Menlyn to basically do an assessment of the situation, an inspection in loco, Road Extent Fund Management refused that Labor should enter the premises. And in fact, what we were informed by management was that the CEO said, there's no person who's going to enter there. Why didn't they make an appointment? Then the inspectors said if the employer is refusing for them to enter the building, they will request the assistance of the SAPS. That's when then they agreed that they should enter the building. And they actually uncovered the filth that was happening in Menlyn. But long and short is that eventually they were sanctioned that it's either you fix the mess that is there in Menlyn or you actually find an alternative building, which actually eventually happened. Thank you.
Thank you. At least I think our chair has noted that, because we are going on a visit to the RAF offices this week. Chair, that is all that I have. Thank you very much.
Thank you very much, Honourable Nilmay. Honourable Beasley.
Thank you, Chair. Greetings, colleagues. Greeting, NUMSA. Thank you for your submission. I thought it was an excellent submission and very well written. And you highlighted in 1.12 the impact of the various issues in RAF, and I'm just going to quote, these issues have rendered the RAF increasingly unable to fulfill its mandate to compensate road accident victims promptly and equitably. And then you highlight poor claimants are especially disadvantaged. But I put it that there's a third impact, and that is the human cost of this unfair labor relations, what's the word? Your policies within RAF, and there's also the actual cost of it. But we've had grown men cry here. You know, we get untold messages by people who've been badly treated by RAF employees. And Zama Shlopi, can you just tell us about that particular matter, please?
Thank you, Honourable Member. Comrade Zamashope was a shop steward of NUMSA based in the Durban office. She was suspended together with another colleague because of allegations stemming from a meeting that they actually attended in the Durban office when the CEO had taken over from the previous CEO. From what we understand is that the intention of that meeting was to basically meet and greet the employees in that office, and for the CEO naturally to introduce himself. And what the comrades did there was merely to raise their hands to ask questions from the CEO based on his presentation. And the CEO had refused to take questions from them, from what we understand. And as a result, these comrades were told that if they do not want to lower their hands, they must leave the meeting. So effectively, they were chased out of the meeting. And they did so. Now, the second colleague that I'm referring to is Tinama Africa. Some of the colleagues that were there in that meeting were never eventually suspended. But these two ladies were identified and suspended and effectively dismissed and all of that. They challenged their dismissal at the CCMA. They went to Labour Court, Labour Appeal Court. And throughout, Zamashope in particular had won her cases against the Road Extent Fund. But the Road Extent Fund refused to reinstate her. And I cannot speculate as to whose decision was it, in as much as the whole thing stems from the meeting with the CEO and that the CEO felt disrespected by the fact that the comrades only merely wanted to ask a question. I then cannot speculate as to who made that decision. But the long and short of it is that that is exactly what happened in the case of Comrade Zamaswazi. But I must mention this before I step off this issue, because I feel it's very crucial. The current board at the Road Extent Fund has taken serious view of what has been happening under the administration of the former CEO, Collins Litswana. It goes without saying that a number of things have actually gone wrong during his tenure as CEO, including unfair labor practices and unfair dismissal of employees. And particularly the fact that there was a blatant refusal to reinstate employees who were found not guilty. We appreciate the board's intervention in saying that all cases that stem from the reign of terror of Mr. Litswalo should be reviewed. However, we take serious concern in the fact that it then becomes the very same employee relations specialists who were executing the mandate of the previous CEO in one, investigating the I almost said claims, the dismissal, the disciplinary hearing matters. After investigating, they then initiate. After initiating, they then are the ones who implement the outcome of the disciplinary hearing. And that becomes problematic because then the board has entrusted the Human Capital Department, where the employee relations specialists belong, to actually review these matters. Matters that went to court and matters that are still pending at the CCMA, and where employees were unfairly dismissed. Those matters must be reviewed and workers must be reinstated. I can confirm that there are employees that have been reinstated following this process. However, we have realized that there is a selective approach in terms of the reinstatement of these employees. Why are we saying this as NUMSA? We have actually observed that these employee relations specialists who are tasked with reviewing these matters are themselves conflicted. Because imagine a situation where, as an employee relations specialist, you have decided that this employee must be dismissed. Whether fairly or unfairly, doesn't matter. But you must be the one now to go against your own decision that this employee must be dismissed. This is where we say that they are conflicted. They should be removed from the process of reviewing these matters for workers to be reinstated. And there must be a panel, either of attorneys, I do not know, that is actually independent. That must be tasked with reviewing these matters, and not the very same people who initiated them. Thank you.
Yeah. So I just want to read a quote that Zama Shlopi had in the Sunday Times when she was interviewed on this particular matter. And I read, Shlopi said the former CEO had caused her untold emotional and financial distress. To say the CEO has destroyed my life does not even begin to describe it. My health has deteriorated and I'm now treated as if I'm embezzled fund or committed fraud, which is battling. And then she says, I've lost count of how many times I've wanted to end my life. I mean, that is tragic. Absolutely tragic for somebody who stood up to something that's wrong. How many times I've wanted to end my life. But the question I put to you as NUMSA, she was a shop steward of NUMSA. What have you done for her?
I have not actually followed up because he's in Durban. The NUMSA regional office handled the matter, but I can get the details.
Well, I put it to you, you guys have done nothing for her. She's been thrown out, and there's a concern that a deal was made behind the scenes for some of these people to be thrown underneath the bus. Because she was a shop steward for NUMSA, and she's received zero support for you. She's received zero support from RAF, and you know what's happened now? She's gone back to work now. The former board have asked her to be reinstated. She goes back there. She's got no work to do. She's got no desk to sit. She just goes and sits there 8 hours a day looking at the wall, and nobody's there to actually help her. Nobody's fighting for justice. And I say that to you guys, Norms, and I'm saying with respect that you guys have let people down in this matter too.
I will disagree with you because I think we have given testimony in this committee stating very well that NUMSA have been fighting in different fronts on behalf of workers. we can't say that everything will be 100% done, but if issues come to our attention, in particular as head office, we have intervened. So that is why I'm saying that I can't respond in detail now unless I go back to the region and understand. But any shipyard of NUMSA has always been represented by union official in disciplinary inquiry. And subsequently, if that leads to a dismissal, then the official then represent that employee to CCMA. Then if then it comes to the higher courts like labor court going up, then the region then make decision. In most cases, the region will request the head office legal department to get a lawyer to be dedicated in that particular case. So I don't have all the details of that case. So that is why I'm saying that some of the issues we're not gonna know because we're not really 100% in operation now. But when we were in operation, we have attended all the matters. For instance, I made a very a recent example that last year we had to transport one of the shipyard to go and represent one member. If someone does not come forth to us, to our attention, sometimes we're not going to know other issues. That is why the onus rests with the employee just to communicate. If then you have done, the employee have done everything, then the union still fail, then the employee can then take, but we can't take responsibility for something that we do not have facts currently.
Okay, I'm putting the facts to you. Will you look into the matter and please assist her as a former NUMSA shop steward who stood up for you guys, and it appears that you guys aren't standing up for her. Then in terms of claims, the claim handlers' files have gone up to 2,000, from just over 1,000 to 2,000. What is the ideal number of files for a claimant to actually, a claim handler to actually have?
Sorry, I missed the question. Can you please repeat it?
Claim handlers currently have 2,000 files. What is the ideal number for claim handlers to actually have? What would you guys say is the ideal number for files for a particular claim handler to have?
Thank you, Honourable Member. So, if I recall correctly, I think around 2017, 2018, when we had started challenging the issue of the workload. At the time, it was around 1,500 or so, but it was still unbearable per claims handler. There was, I think, a case wherein a judge had actually made a pronouncement on the ridiculous workload of claims handlers at Road Accident Fund. And I think an estimation was made in that case, but I will look for it, Honourable Member, and share it with the chair if necessary. However, I think the estimated number was about 700, 750 maximum for each claims handler to handle. Yeah, thank you.
So currently, in your opinion, they've probably got 4 times too many files as they should have. Okay.
Essentially, yes.
Yeah. Yeah, and then my understanding is that the call center, it was insourced, it had good quality people, it was outsourced with people who had no idea of the actual business. You know, from an Action SA perspective, we fully support insourcing. You know, it's a way to go. It's a logical way. I mean, outsourcing just brings corruption, incompetence, and a whole lot of stuff with it. Is that correct? And why would they not use the people that they had was a total cost of the insourcing outsourced, so the employees actually went with it? Were they paid by the service provider, or were they paid by the RAF, the current call centre employees?
Thank you, Honourable Member. First, we agree with you 100% as NUMSA that ideally workers should actually be insourced, and any, should I say, department, whether IT, facilities, security, and all of that, ought to be in the control of the Road Extent Fund in this instance, and especially a department that deals with the heart of the relationship between ourselves and the claimants out there, which is the client relationship management systems. It makes sense that those should be internalized. And further, it makes sense that such resources that are used should be used by the organization to create jobs from within, or at least, at the very least, preserve the jobs that are in danger of being extinct or at least retrenched. And so there was never any concrete reason that was given by the employer, or at least justification for the outsourced call center, other than the fact that they are bringing new processes that has to do with handling queries from social media platforms and all of that, which was surprising to us because the internal staff was actually doing that. And we were of the view as NUMSA that if the question is about capacitation, then do exactly that. Preserve those funds for capacitating the internal call center and give it more workers. And we said, don't look any further. The workers that you've identified, 400 plus of them that you said must be retrenched, reskill them and take them to the call center, instead of you creating a call center outside of the Road Extent Fund. And from our understanding, the call center was operating very well. I think the estimated cost, but that's subject to confirmation, but I think what was estimated was about around 20 million or so. But this new call center has been acquired for a whopping 200 million per annum. And it beats us as to why. What is the purpose of this? It has been said here by previous speakers from the Road Extent Fund that the call center has been performing very well, producing results, and we differ with that as NUMSA, fundamentally. We differ with that. That is incorrect. That is misrepresentation. Because what happens here is that even if they can say it's performing the way in which they're describing it, but there isn't tangible proof of such. Claimants still remain confused as to the status of their claims to date. They do not know where to go. And these call center agents that are coming from this external company had to be trained by the internal staff. And in fact, that was actually a very brief kind of training and all of that, because it was rushed for these internal staff to go and focus on something else. So it was not effective, it was not adequate, in our opinion. Thank you.
Excuse me. We were also advised by people who presented here that all people with claims have been actually been given phone calls just to give them an update, missing documents. Do you know if is that a factual submission, that we've been told that all claimants have been phoned just to give an update of what's missing, where their claim is?
Unfortunately, I can't confirm nor deny that. Thank you.
And then one of you mentioned the former CEO as a bully. If you can just expand on that, please.
Thank you, Honourable Member. One thing I can say is that throughout our interactions with the CEO, we have realized that you can't tell him nothing. You listen to what he has to say, and he has no interest in listening to what you have to say on your side. And he's got an answer for everything. That is our view as NUMSA. When they were introducing this whole idea of retrenching employees, or at least restructuring, he held a meeting with management. We are informed reliably by people who attended that meeting that he informed them that you must go and tell your families that come January, you will not have a job here at the Road Extent Fund. Your employment is going to come to an end. And no justification was given other than the fact that you are no longer needed. You must go and tell your families. When he took over from the Road Extent Fund, and he had visited the Manlin branch, he made an announcement on the intercom that The new sheriff is in town. And heads are going to roll. In meetings where he has invited workers to attend, and NUMSA would be there representing employees as shop stewards. If you want to raise something in that meeting, he will tell you that this is my meeting, not your meeting. And therefore, you're not going to ask any questions here. I didn't invite NUMSA to come and join this meeting, which was a contradiction because NUMSA shop stewards are equally employees of the Road Accident Fund. Now, with these few examples I've made, you tell me, if that is not instilling fear amongst workers, what is it? Thank you.
Excuse me. What are your thoughts on the CEO getting a 40% performance bonus and the rest of the staff getting 12%? Justified?
Thank you, Honourable Member. What I can say is that that is very unfortunate. Very unfortunate because the employees that actually do the work are workers on the ground, whom I understand, based on the recent communication from management concerning performance bonuses, have been only given a share of 15%. We understand that the CEO bears the entire risk of managing the entire organization and. But the workers that are actually putting in the effort are the workers on the ground, whom we believe actually things must be put the other way around. They should be compensated more, actually. And it makes no sense that you would want to give a bonus of 40% to a person. I don't know exactly what the CEO earns, but if he's earning more than 2 million, it makes no sense that you give him a bonus of 40% on 2 million when a worker on the lowest level, task level 6, for example, or task level 1, for example, who earns, let's say, about 200,000 rands per annum is only given 15%. That is an insult. Thank you.
Yeah, just for your information, he's earning about 7 million, and he was, and then his bonus was 40% on top of that. Thank you, Chair. That's me.
Thank you very much. Thank you, honourable members. I just have a few questions, just around. Oh, Honourable Atkinson, you were not here.
Chair, there was just something that was said. I would just like to ask for a little bit of clarity, if you don't mind. Thank you.
Please go ahead.
Thanks. In one of your responses, you mentioned the fact that most of the Road Accident Fund officers were dysfunctional. And I think you mentioned the fact that the Cape Town one was the only one that worked. And you mentioned corruption. I was just wondering, could you maybe give a little bit more detail around that? What kind of corruption have you come across or have you heard about in those offices?
Thank you for the question. The allegation made by the CEO that these workers were colluding with lawyers, and they were the one who are contributing to Road Accident Fund having default judgment. That's why he led to the mass suspension of workers, which he could not be able to prove the allegation. And subsequently, then continuously, whenever he called meeting, he is always pointing fingers with Durban office and which he normally claim they are the most corrupt. And subsequently to that, when the restructuring started, he wanted to use the restructuring process to flush out these offices, but he realized that we were pushing back on that. And then he changed and moved to call center, which probably call center was a low-hanging fruit for him, this call center, because if you talk about East London, East London were around 200 workers, East London. So he could not pinpoint who is he referring to. It was just all allegation, making general statements without actually substantiating, which became a problem. these are allegations. That is why we said if management believe that these workers were corrupt, the owners rested with them in terms of Section 192 of the Labor Relations Act to prove, which they failed dismal to prove. I mean, you can't be sitting with an employee that was suspended probably in 2021 or 2022 by now, and you still want to justify that suspension. Surely, ordinarily, the period of investigation for serious corruption issues, it will not take so long. I mean, ordinarily, when a worker is suspended, he got suspended for 60 days, and subsequent management will do whatever sort of investigation, either before or after 60 days, then either uplift the suspension or proceed with disciplinary inquiry whilst the worker is on suspension. I mean, it can be, yes. It means that management jump the gun and suspend it without having evidence to that effect. Because someone now who needs to do the work that this worker used to do, if this worker was let's say, in the position of a team leader or supervisor, someone will enjoy acting. Because this worker, so it means that you will have a duplication of cost. You will pay two people for same thing. Thank you.
Thank you very much, honourable members. I'm mindful of time, and I'd like us to wrap up with NUMSA. I'll just have a couple of questions. It's really not a lot. Let me start with Mr. Mbali. So, can you remind us again? Isn't there a policy at the Road Accident Fund that matters must be concluded within? Is 90 or 180 days?
From our understanding, thank you, Chair. From our understanding, there had been a directive issued to employees of Road Extent Fund following, I think, a case of the Road Extent Fund and the LPC, wherein the CEO had requested to be given, or at least the RAF to be given some.
No, I'm not talking about claims.
Okay.
So in the disciplinary policy,
I apologize.
in the disciplinary policy, I thought I saw something about matters being concluded within a specific number of days. I just cannot recall what it is. Do you have any recollection of it?
I think, as far as I can recall, Chair, it was about 90 days that was allocated for a matter to be investigated and be concluded. Yes.
Okay. So we'll just ask the researchers to check. Do you know what's supposed to happen if that 90 days or that period, let's say between 90 and 180, I don't know, I seem to remember 180, but it's fine. Can you recall what's supposed to happen if that period comes and the matter is still nowhere near conclusion? Because we've got people who've been suspended for more than 4 years in some instances. Yeah.
The policy is silent on that.
Okay, no, it's fine. We'll take it up with the board. I just want to ask Mr. James, NUMSA, you said, has over 320,000 members nationwide. In your experience, how many of those employers use external attorneys for the first phase? How often do you encounter that problem where employers use attorneys for the first phase of the internal disciplinary process? Because one of the things we're looking at here is the cost spent on attorneys or on two ends: the chairperson of the disciplinary sitting as well as the initiator. And we've asked the Road Accident Fund to provide us with their expenditure on those, and they have. How common is the practice of doing both?
Thank you, Chair. This is uncommon, both private sector and public sector, because our membership is diverse. we have a lot of members in private sector and public sector, including multinational. All of them use their internal capacity. For instance, a lot of companies will capacitate their management with disciplinary processes, how to manage disciplinary. The only time where it will come to lawyers probably is when there are disciplinary inquiry in relation to executive or senior management for complex cases where then parties will be legally represented.
All right, thank you very much. And then my last question relates to the practice of refusing to comply with court orders. We know about Ms. Samahlope's case because it was in the paper and she sent a submission to the committee. So we are aware through a member, so we are aware of that. But I just want to ask, in your representation of RAF employees, are you aware of instances where the employee has won throughout, or at least through the external phases, and they have still not been reinstated?
Thank you, Chair. From the list of the suspended claims handlers, there isn't a lot of matters that have been seen through until conclusion, Chair. It's just a few of them. But I can confirm that there's one case of Mduduzi Chabalala from the Menlyn office, for example, who was basically facing allegations of gross negligence. The chairperson of that disciplinary hearing found that this employee has not committed an act of gross negligence. However, he finds that at some point he committed an act of negligence, which does not warrant a dismissal as a suitable sanction. Naturally, that employee ought to have been reinstated by the employer. They refused to do so. And as a result, Duduzi Chabalala remained at home. I'm not sure now if he actually still is with the Road Accident Fund, but he had indicated the last time I spoke to him that he intends to resign because he's frustrated by the process. But we don't really have a lot of numbers of employees actually from the employees that were suspended for failing to load court orders. Yeah.
Because the matters are ongoing.
Yes.
Okay, now I get it. You know, it's unfortunate what happened to Mr. Chabalala. Wasn't Mandoza to do the Chabalala as well? His name. I wonder if he was called Mandoza at work. Correct, I don't mean to make light of the of the situation, but the name struck me. So thank you very much, and thank you very much for this submission. So even some of the matters that we didn't specifically ask about, because the submission is made in full, we will nonetheless take them to account. We may, during the process of considering the report at committee level, we may ask you for further input, for further particulars, right? So that we've got as complete a process as possible. I just want to say that I started working in a company where NUMSA was the union, and one of the things that used to happen is that we were all trained in the internal disciplinary process, and we used to go through that process with shop stewards. And I don't recall a single time when lawyers were ever involved internally at all. And I think that for the entire public sector, it's just something that the committee possibly has to check, that it's used sparingly, because lawyers are expensive. They cost money. And I'm hoping that we can return to a situation where employees, as part of their own development, are trained in initiating and sharing and this kind of thing, so that it's done within. And I think that's the whole objective of the Labour Relations Act at first level, to make the process as inexpensive as possible. for all concerned, given that you have employers who don't have the pockets in any case for themselves to hire attorneys. So it's something that I think in terms of the founding of the thinking in our law is really important, even though it's got financial implications, and we are forced to look at that. The last thing is to say, in the context of some issues which do not relate specifically to the terms of reference, as I said, we will ensure that the Portfolio Committee on Transport gets to receive that information. We are working together with them. Some members sit on both committees, and occasionally even the chairperson of the Portfolio Committee on Transport comes and participates in the process. So rest assured that if something is not in the in the terms of reference, we will make sure that it is sent to the right body to deal with. We will have the former boards tomorrow. We will deal with some of these matters, at least as far as their level is concerned. In fact, this reminds me, so was there at any point when, during your various challenges, that you ever interacted with any of the boards? Because you've told us about this one, that you have not yet had the benefit of a response from them. But the previous boards, did you ever reach out to them at all? I just want to know whether we should ask them what we should ask them tomorrow.
Yes, Chair, we have previously, in particular, even in the tenure of Ms. Linda Lwachabavu, she arranged the meetings between the union and board, where the board also raised their view around the NDT, and if there are areas where there were grievances, the board will then instruct the CEO to resolve grievances. That is why in the period of Ms. Chabavu, we were able to resolve a lot of issues.
But with the board subsequent to that, were you...
No.
Is it because you did not reach out to them, or it's because you couldn't get to meet with them, but you requested?
There has communication to them, either brought also by Shop Steward. They have sent number of, there were no response. In fact, the only person who was responding, it was Letswalo.
Which one? There were two. There was the ER, there was Letswalo M and Letswalo C. Which one?
The CEO. He is the one who will, even in his response, he will respond casual. You will have a meeting for something else. He will do this thing of his, of just making silly comments along the way.
Okay, Mr. Mbali,
may I just add,
final point?
Chair, that there is a letter that was sent by Shop Stewards to the previous board on the 26th of August 2021, wherein we had raised issues surrounding the intention, for example, to terminate the employment of these claims handlers and stuff like that. In fact, they were given letters on the instruction of the CEO to say they must give reasons as to why they should not be dismissed following the allegations that were leveled against them. And of course, we contested that as NUMSA, and we said this is unprocedural, it's unlawful, and we did actually communicate to the board. And the board had simply just distanced itself that this is an operational matter and all of that, and they're nowhere involved. Yeah.
All right. No, thank you very much. I want to thank all three of you for the submission, as well as for assisting the committee with this process. I've explained how we're going to handle the various matters. But thank you very much. Honorable members, there is lunch. Also for you, there is lunch downstairs. You're taxpayers. So it's your lunch also. Honorable members, there is lunch downstairs. We will have the Legal Practice Council when we come back. I have asked Lwazi to print some spreadsheets because they may be relevant. It's really up to the members. The spreadsheets relate to the matter of legal costs. one of the things I asked the Road Accident Fund, because it's very topical, is a list of firms that have been referred to the LPC, that have been investigated for fraud and been referred to the LPC. That is the one aspect of it. So they've stated, if I recall, which region they all originate in. I have also asked the Road Accident Fund, not for the top 10, but for the top 20 law firms that received those big payments from the Road Accident Fund. They've broken down, you will see in the spreadsheets, they've broken them down by year. They've said how much was paid for each category of payments and what the total was each year and how many cases there were each year, how many claims and court cases there were relating to each. Members may want to ask some questions around those issues. When the LPC gets here, I'll do an introduction, we'll get straight to questions. We know the issues. We get emails from members of the public. Some issues have been raised by the LPIIF here, etc. So I think we know what to ask the Legal Practice Council when they get here. I've already informed them accordingly that we'll traverse various issues with them. So when you come back, Loazi will distribute that. It's in the file, but she'll just print and distribute. Thank you very much. Can we reconvene, let's say, at 1440? 1440, yeah. 1440, yeah. Thank you. It's close to an hour, so there should be enough. Yeah. Thank you very much. And thank you very much again, colleagues, for coming here. Thank you.
Thank you, Chair and members.
Everyone uses their allocated time properly. So, honorable members, welcome back, and colleagues from the Legal Practice Council, welcome back to Parliament. We see you quite often these days, but thank you very much for taking time to come here. I will just preface both for yourselves and members of the public in this way. We need assistance generally of a general nature from the Legal Practice Council, because both before the inquiry and during the course of the inquiry, we receive a lot of feedback about the legal profession in respect of the processes of the Road Accident Fund. And I will just go through thematically some of the issues so that we can just orientate ourselves. First, there is complaints from claimants. And claimants is the usual, we've canvassed it before. My attorney has eaten my money, as people will say. My attorney is not talking to me. My attorney is not updating me. My attorney told me one thing and it's the other. My attorney, I believe that my attorney took most of the money and I got a penny. My attorney said I would get 2 million rand and I only got 80,000 rand, etc., etc. There is that range of types of complaints that we get. We also had the Legal Practice Indemnity Insurance Fund. I hope I'm saying it right. The LPIIF. They came here, they explained what they do. And you know it, but for the members of the public, they explained that when an attorney has not performed within the expectations of the profession in terms of how they've handled the claim, and as a result the claim has been repudiated or it prescribes or whatever the case is, that matter gets referred to the LPIIF and they investigate, and therefore they have to step into the shoes of the Road Accident Fund and make good on that claim. Now, of course, naturally, the question from the members is, okay, then what happens to the law firm? Do they just walk away? What happens? And then they said, the Legal Practice Council usually, we refer matters to the Legal Practice Council where we feel that needs to take place. And of course, the members then want to know, okay, then what happens to those cases? Then you come in. That's another reason why you're here. We also asked the Road Accident Fund. There is a lot said about, even this morning, you were outside the room, but even this morning, law firms looting the Road Accident Fund and so on. So what we did was to say, we want information on two sets of law firms, because in the public consciousness, the legal profession, basically, your members are just, they're looting the Road Accident Fund. That is the terminology. Of course, not every law firm does this. There are attorneys who are unscrupulous, attorneys who do their job properly. What appears to be of concern to the public is the big amounts that they see. So now the Road Accident Fund has furnished us with a full list of all law firms that represent claimants that they've had to pay various types of legal costs. And also we asked them for information on law firms that they've investigated for fraud and tell us why they believe that there was fraud that took place and what they've done about it. Have they laid criminal charges, etc., etc. So we then ended up with two sets. And the members have it. I don't know if the team has given you some of the spreadsheets. We won't ask you to speak to each of the law firms. What we want to know, has the Road Accident Fund referred matters to you? And when the Road Accident Fund refers law firms that they believe have acted outside of the rules of the profession, what do you guys do? Because that is an issue. For fullness, we have also asked the Road Accident Fund, which is the second set of information which the members have got. Basically, we said, okay, these big law firms that you're always talking about, give us your top 20. They gave us a full list, but we asked them, a week and a half ago. We said, give us the top 20, because there are hundreds of them. Give us a top 20. That just break down what you've paid them, what it has been for. Because we are going to go to the Road Accident Fund on Friday and ask them to go into detail on these payments. And therefore, we're not going to be asking you why did they get paid. What I will ask you as chair is why do those kind of payments get made? How are those payments approved? Is it between the parties and so on? And what happens, for instance, to, if in that context there is an ethical activity and that kind of thing? So we understand that you don't work in those law firms, but we just need to know what the payments are for, because there are different categories, there are disbursements, etc., etc. So to the extent that you can assist the committee to say, this payment is for X, Y, Z, etc., etc., all the way down the line. And similarly with the law firms that have been referred, we really won't ask you to explain what happened in that case. What we really want to know is what happens when the Road Accident Fund refers law firms to you. Have you had any? Have you investigated, etc.? So I hope we're on the same page. To the members, I just want to say, and I'm going to ask the team to send you the one spreadsheet, because it can only be printed on A3 size. So I've asked the colleagues, I don't know if you've got your laptops here, to just you look at it on your laptop, because it's much easier. I'm also going to be looking at it on my laptop if you have. Otherwise, we've tried to find an A3 printer. Unfortunately, we couldn't locate it in the time. So I'm hoping that we're all on the same page. I'm going to ask Ms. Ibrahim to swear in anyone who is going to be speaking today, and then we will begin. We won't, unless you've got an opening statement to make, we will really just go straight to questions, because these matters have been canvassed with members already. They know what questions they've got in their minds, and they will just get straight to questions. I will ask any questions that I feel have not been addressed, and then we'll finish. Ms. Ibrahim, over to you.
Good morning, colleagues. Good afternoon, at least, colleagues from the LPC. Just for purposes of the record, we have Mr. Tia, Ms. Mfusi, Mr. Brill, and Ms. Herald with us. Colleagues, you have been invited, subject to the provisions of the Powers, Privileges and Immunities of Parliament and Provincial Legislatures Act, to appear before the Standing Committee on Public Accounts to provide information in relation to the committee's oversight inquiry into the Road Accident Fund. Please be informed that by law you are required to answer fully and satisfactorily all the questions lawfully put to you, or to produce any document that you are required to produce in connection with the subject matter of the inquiry, notwithstanding the fact that the answer or the document could incriminate you or expose you to criminal or civil proceedings or damages. You are, however, protected in that evidence given under oath or affirmation before a House or committee may not be used against you in any court or place outside of Parliament, except in criminal proceedings concerning a charge of perjury or a charge relating to the evidence or documents required in these proceedings. Please be aware further that in terms of Section 17(2) of the Powers Act, a person who willfully furnishes a House or committee with information or makes a statement before it which is false or misleading commits an offence and is liable to a fine or to imprisonment for a period not exceeding 2 years. Chairperson, the colleagues have indicated that they would like to take an oath, so I'm going to ask that each of them raise their right hand and repeat after me. I swear that the evidence I shall give shall be the truth, the whole truth, and nothing but the truth. So help me God. Thank you. You're now duly sworn in.
All right. Thank you very much. So, as I said, so I've laid out the issues. I won't ask questions at the beginning. I'll give the members an opportunity to do so. I started with Honorable Mende. I'll start on your side, Honorable Beasley. You don't have to stick to just the issues I've identified. If there's something that has been canvassed here in committee before pertaining to the legal profession, you really can ask if it falls within the terms of reference of the committee, and that applies to all of the members. So we will operate on the same time allocations as last time. and then then we'll proceed like that. Thank you very much. Over to you, Honorable Beasley.
Thanks, Chair. So I haven't got that spreadsheet yet, but I'm sure one of my colleagues will speak to it when it comes.
Which one? So
The
haven't you
A3 one.
distributed? So no. So there is a.
Yeah, but you talked about an A3 one. And
Have we emailed it to the members yet? Just the one that needed to be in A3. That is the law firms where there have been investigations concluded. That one needs to be with the members.
But I'm happy to carry one of my other guys.
And then we can come back to all right.
That's fine. Just how long does it take to investigate a claim? Because you receive 53,000 complaints. So how long would it take the LPC to actually investigate a claim? Because that's a lot of claims to investigate.
Thank you, Chair. Through you, the time periods are set out in the Legal Practice Act. So it gives time periods, for example, a complaint must, because it's not an easy answer. So for example, the complaint must be addressed to the attorney, him has been given 30 days and so forth. So at the shortest, between 4 to 6 months to investigate a complaint.
Okay, and then for you guys, do you have enough resources to investigate the 53,000 complaints in 6 years? Because it's a lot of complaints to investigate, do you?
We do not, unfortunately.
So then how do you decide which cases to investigate and which ones not? And is there any chance of that some of it might actually be slipping through the net?
Well, we investigate all the complaints that we get, so that the end result will just be there's a delay in the finalization because we deal with the volumes. Now, what we do is once we get a complaint, we identify, we look at the nature of the complaint. Is the complaint relating to the misappropriation of trust funds, a failure to account, and so forth? And those are the more serious, relatively speaking, complaints. We do profiles, so you look as you open the file. We still work with physical files. You will check and see, is this attorney like a new attorney, no complaints, or is there a pattern of complaints, how many? So then you expedite those type of attorneys, and then you deal with that a bit different. So we look at it, we consider it, and that's why the matters relating to the misappropriation of trust funds and the delay in payments sometimes, well, most of the times are attended to much faster.
And what are the consequences for these 280 legal practitioners have been found guilty?
Misappropriation.
Yeah, it says only 280 legal practitioners have been found guilty and 78 for misappropriating funds. So if they've been found guilty of an offence, are there different different levels of consequences?
Yeah, sanctions, it depends on, it can be contravention like failing to account to, failure to reply to correspondence of a complainant, one letter. So the sanction imposed can vary from a reprimand, a warning, and then up to a fine per individual attorney per contravention, 135,000. Companies, law firms, more candidate attorneys, less. Then, of course, the worst sanction imposed is referral to the council to approve an application to strike or suspend.
And have you struck any out or?
Well, we're busy, or we report on it all the time about the number of attorneys that we do strike, and most of them relates to the misappropriation of trust funds.
And then in terms of, you say here, it is advised that fewer than 1% of attorneys were guilty of misconduct in matters. You received 53,000 complaints to RAF. How many complaints would you receive in general in general? You got 53 specific to the RAF, but generally each year, how many would you receive for the legal profession in general?
Let me just make sure about the number.
Just estimate is fine.
I think about 12,000, plus minus 12,000.
Okay.
Yeah.
What percentage would the RAF of that 12,000 represent?
We did actually check earlier this morning. I think we're sitting with just over 300 plus that RAF-related complaints out of the total amount of complaints received.
In the greater scheme of things within the legal profession, it's not a major issue at the moment, 300 out of 12,000.
I think it is for me.
Yeah.
It's 300 too much.
Sure.
Because unfortunately, with the MVA claims, they are generally matters that relate to misappropriation. If we've investigated and found that a claimant has not been paid what is due to them, we obviously would need to approach the High Court and seek the harshest sanction, which is a strike-off. So it is very, very serious.
No, I appreciate that. And then you note here that the LPC's also flagged a growing litigation due to RF inefficiencies, with summons in Gauteng increasing from 354 a month in 2019 to 804 a month in 2023. Do you have an update what those summons might be at the moment? Is it getting worse?
We've not done an update of those stats. In Gauteng specifically, what the courts have now implemented is the compulsory mediation before trial dates can be obtained. So the effect of that is that from basically this year, all trial dates that were there have been removed, and parties are now compelled to first do the compulsory mediation. So far, the feedback has not been very positive. There's problems with obtaining cooperation from both sides in completing the mediation process. And even where the mediation takes place, the information that we get is that very few matters actually settle completely at mediation. So it's still too early to see what the effect of that directive from court is going to be. But preliminary indications are in Gauteng it's not very successful.
It was quite interesting. I was speaking to somebody the other day in KZN, and he sits on the body that oversees judges, and he was just talking about court cases in KZN for like next 5-6 years. And I said to him, well, what percentage, why is the delay? He said RAF is 90% of the delay. So it's actually having a huge impact in the actual justice system as a whole, and I think it certainly needs to be addressed. And on that particular point, the state attorney came out and he mentioned a special tribunal to clear these matters. What are your guys' thoughts on that? What recommendation would you have to actually clean up the system so it actually doesn't impact on the legal profession and the justice system? Because it's not only guys not getting paid accidents, but it's the rest of the justice system. You know, somebody's civil claim and trying to recover money, you're waiting 4 or 5 years. The guy spent the money the time you get a chance. So just some thoughts on that, how the process could actually be sped up.
Thank you very much, Honourable Member, and greetings to all members of this committee and Chair. We think if RAF can comply with the provisions of Section 24, subsection 6, to investigate the claims and settle the claims within 120 days. That would help. But since I practiced, I have never had a single claim that has been settled within those prescripts of Section 24. So then, if that can be done, that would reduce payment of costs for litigation. That would also reduce the backlog that we're having in courts throughout. And you'll remember, for instance, for Gauteng, if you go to court with a claim that is ready for trial, you will get a date in 2030. A case that is ready today, if you go to the registrar, you ask for a date, you'll get a date in 2030. And then there's no justice there if we are honest to each other. So we can manage that backlog if maybe the capacity of RAF to settle those matters as speedily in line with the Act, that would help. Thank you very much.
Yeah, thank you, Chair. I've stuck to my 5 minutes, but I might come back more just now once I've had a look at that spreadsheet, if that's okay.
Okay, I'll reserve the time for you, Honourable Beasley. So you've got another 10 minutes to work with that. Honourable Nilme. Sorry, let me just ask before you start. Have we now emailed it's been emailed? Okay, I'll give you time to just consider it, Honorable Beasley, but it goes together with this. There is a summary, Honorable Members. So the A3 is a summary of the last page. Can you see the last page of this? So there is something to look at there. So we've asked them for LPC referrals, right? So it's summarized here, but the spreadsheet has got each one, even the ones that aren't, you know what I mean? So all the cases, even where we haven't, yeah, okay, thank you. Honorable Neil May.
Good afternoon, and good afternoon to the representatives from the LPC. You know, as my colleague was saying here, I was reading the article that appeared by Simbongile Siyali. And, you know, it was very interesting when he said what was intended to be a compassionate and efficient mechanism for relief has evolved into a cumbersome and litigious process that has overwhelmed the judiciary and burdened claimants. And, of course, he mentions the mounting backlog of RAF cases, which you have said now. And my question to you is that, in your view, the systematic disregard of court orders by the RAF is undermining the rule of law, and what interventions has been made? I mean, I think if we in December last year, when the Law Society was here, basically, it came to the point where, with the removal of the attorneys, it has decimated the legal system. And the RAF, which continually does not, it's total disregard for court orders, which is what is happening in the legal industry. What is your view with regards to that? And is there anything that you are able to do as well?
Thank you very much, Honorable Member, once again. I think the problem that we think it's there caused by, obviously, non-adherence to the court orders at time, which takes forever to do these payments, would be the issue of either capacity or RAF not doing what they're supposed to be doing. Because remember, once the 180 days lapses without them making or effecting the payment, the remedy that is available is to apply for a written attach, the RAF, which is quite also a very bad process. Because I'll go to the incident of the Eastern Cape, where in East London a server was attached, and then you are unable to call RAF, you're unable to send emails to them for quite some time. The situation stayed like that for quite some time. So if we can maybe, our suggestion would be if we can try to incapacitate RAF with more staff who are able to perform, because I know for a fact that most of members who work for RAF, either for finance department or whatever departments, most of the time are people who studied law, no people who studied finances. So hence at times, I know law people don't like numbers. They will make serious mistakes with calculations even themselves and duplicate payments at times because there is a rate, so they have to rush to stop the sheriff from attaching. So if we can maybe deal with the question of trying to get more staff, and it is our view that the RAF need to establish a well-equipped office in every corner where there is a high court, because you'll find out their offices are scattered, they are far, one in Eastern Cape. In Eastern Cape, we have 5 high courts. They have to run the entire Eastern Cape. Obviously, that will cause a backlog for litigation, and they don't have an internal department that deals with litigation. Their department that is called internal litigation department does not deal with litigation. What they are doing, they are simply settling claims that are on trial. not that they're supposed to settle in terms of that Section 24. But once you have a notice of set down, that's then the litigation department comes in and try to settle the matter and to avoid a trial. Thanks. Yes, you can add.
If I may just also add there, practically speaking also, if you look at the impact of the non-adherence to the court order, specifically capital settlements, right? Very often what happens, a lot of our complaints coming from members of the public is as a result of the member of public not believing the attorney that says, look, RAF has still not paid me. You would find, I mean, you know the various cases where RAF has been seeking postponement and postponement of payments. There's matters that's been on the RNYP list for up to 5 years. Now, if you are a client of an attorney and the attorney tells you your matter was settled 5 years ago, but I've not been paid, you will not believe him and you will report him to the LPC. So it has an impact on our ability to deal with the complaints as well.
Thank you very much. Coming to my next question, has the LPC investigated allegations of collusion or unethical arrangements between RAF officials and certain legal practitioners? Have you received any complaints with regards to that?
Off the cuff, I cannot specifically say whether we've received complaints relating to collusion. It might well be, but we don't have specific record at this stage.
And another question that I've always had in my mind is the contingency fee arrangements in RAF matters. Are they being adequately monitored and enforced by the LPC?
Yes, thanks. Thanks, Honourable Member. Yes, Honourable Member, the LPC, remember the contingency fee agreement is in terms of the Act. And even most of the time, even the courts, when the settlement will be done in court, will require to have a look at that contingency fee agreement, and at times will require the plaintiff's attorney to prepare a Section 40 subsection 1 and Section 40 subsection 2 affidavits on contingents. Then we try to monitor, and our system is the one where, remember, each and every year, every practitioner, either practicing as an advocate with a fidelity fund certificate or as an attorney, you have to be audited annually. So our auditors, and even the auditors generally, are able to identify that there is this capital amount that was paid from RAF, but it does not address the question of contingents. What happened here? Why? Because an amount that was paid is 100 rands, and we could see here that 80 rands was paid to the business account and 20 rands was paid to some account. What happened? So we're able to pick up that this person did not adhere to the agreement with the client, and immediately we see such payments. We had to then have an inquiry, and we were able also to send our own auditors as the LPC to visit that particular law firm and demand the file itself, literally the file, so that we peruse it, we see the contingency fee agreement, we had an interview with the client as what was the agreement, what happened, what transpired. So that is the process that we are able to, that makes us to be able to monitor if the contingency fee agreement was followed or not. Unless of course, a situation where we will not be able to identify, Chair, where this particular attorney will for whatever reason have a bank account that is having the names of the client and pay to it, only to find out he did not pay that particular client. And that one would be difficult then to pick up through auditing. Thank you.
The contingency fee agreement makes provision for the Fee Dispute Resolution Committee. So that is a committee of the Legal Practice Council to determine whether the contingency fee agreement is valid. That's first of all. And second of all, if there's a dispute on the fee charge, if it's reasonable. So there is a committee, and if we receive, it normally comes through as by way of a complaint, and that will then be referred to that committee, and they will look at the reasonability of the fees. So there's one way in terms of the Act that the LPC can also assist.
My last question is, have you engaged with the RAF on practices that increase litigation costs and prejudice claimants? I know we were talking a little bit about, you know, those that were favored, but have you at all engaged with the RAF on their practice, which is now increasing litigation costs and prejudicing claimants?
Thank you very much, Honourable Member. On that one is quite complex because that is not part of our mandate. Ours is to just regulate the profession. Then that space would be the space for the Black Lawyers Association, National Association of Democratic Lawyers, Law Society of South Africa. It's them then who have a space to represent the members' interest. We do not have that particular mandate. Not to say that maybe if they may come to us, we can be able to engage. We can engage them as the council if they want to speak to us, but we do not have a mandate to represent the members' interest because that will speak to that. Thanks.
Thank you, Chair. If I can come back at a later stage, if it's possible. Thanks.
Honourable Pila. Thanks, Honourable Nelmay.
Thank you so much, Chairperson, and good afternoon to LPC. Checking here, I can see that one of your main duties is to make sure that legal practitioners are investigated when they do misconduct. And they have to practice while having fidelity fund certificates. So what do we do when there are attorneys that are practicing without a fidelity certificate? Because they are there.
Thank you very much, Honourable Member Bina. It is correct that in terms of the Legal Practice Act, no one is allowed to practice without a fidelity fund certificate who is practicing as an attorney in particular. Now, the process is like this. We communicate with the profession and with also the stakeholders, such as Nadel BLA and others, AFT and so forth, and advise them of their members that they are not going to be allowed to practice if they are not in possession of such fidelity fund certificate. We also communicate with courts and give them at times the list of members who are not in possession of the fidelity fund certificate because they are not allowed even to appear before a court and represent clients. But at times, of course, we are dealing here with people who know the loopholes of the law, who can, through their own shenanigans at times, want to force matters and go to court and appear. But once we know of such conduct, we always write to them that they must answer to those allegations of violating, I'm not sure, is it this section, I think around Rule 60, of violating that particular rule in the Code of Conduct, and that we brought them before the DC, and a due process will be followed. But they are not allowed to practice without a fidelity fund certificate because the public is not protected by the LPIF, because the LPIF, its purpose is to ensure every client. So if you don't have a fidelity fund certificate, then you are not insured, and it's a risk to the public. Thanks.
And after the disciplinary hearings of those attorneys, does it end there, or there is something that is done? Because you are saying that they are not allowed to practice without fidelity certificate. So then you bring them for disciplinary hearing, and what is the way forward from there?
Thank you, Honourable Chair. The proceedings ultimately culminate in us approaching the High Court for an order suspending the member. In addition, we freeze the trust account so that we ensure that this person does not have access to clients' monies, so they are not allowed to transact on the trust account. But coupled with that, we have just most recently in the past financial year, we've partnered with the Legal Practitioners Fidelity Fund, which is the insurer for the profession, and we've embarked on outreach projects. So what we are trying to do now is also educate the community on what the value of the Fidelity Fund certificate is. So we're trying to make sure that the ordinary man on the street understands that if they do business with a legal practitioner, there are some legal practitioners who are required to have a Fidelity Fund certificate, and we also try and explain what the purpose of that certificate is. So we deal with the member, but we are also trying to look at the public as well.
Thank you. Here is an Anthony. He's having a fidelity certificate, but he has been struck off the roll, but he's still continuing to practice as an Anthony. What do we do in that case?
Thank you, Honourable Member. So we have had instances of that nature, quite a few in fact. So if we get information that a practitioner, a struck-off attorney or advocate continues to practice, we actually proceed with contempt of court proceedings. There's just a recent case in KZN, I think it was in November, where the former legal practitioner was actually incarcerated for 30 days because of that. So we are quite proactive on that stance. We consistently, every month, we consistently inform our stakeholders. We inform the judiciary, the master's office, RAF, and so forth on a monthly basis of any change in the status of a legal practitioner. So that would include people who are struck off the roll, suspended, and even deceased.
Let me say it's fine, but we know that there are people who are still practicing, even if they are have been struck off the roll. But what I can advise the council is that just monitor the space where you are, because people are being violating the rules while you are there. Let us come back to the road accident fund issue. There were a time where there is a duplicate of payment for Anthony's. What is it that the council done to prevent that to happen in the road accident fund? Because some of the Anthony's were being paid a double amount according to the information that was brought before this committee. Thank you.
Thank you. The duplicate payment was not a mistake from the information at hand as a result of the conduct of the legal practitioners. It came about as a result of the administrative problems, challenges at the road accident fund. There was no indication in all the complaints that we received from the road accident fund, or ever was the allegation made, that the attorneys was involved and somehow this resulted in the duplicate payments. What we know is that the duplicate payments normally resulted as a result of orders was obtained, and at the same time the road accident fund failed to make payments. Warrants of executions were issued. Those two were not linked by the road accident fund, and therefore they made a mistake and made duplicate payments. So the problem why some of the complaints, and not all, 14 initially was referred to the Legal Practice Council, related to the fact that those 14 failed to make or failed to refund the monies when requested. In some instances, if I may add, the attorneys approached the RAF first to say, we received a duplicate payment, we want to make payment, and they struggled to make the duplicate, refund the duplicate payments.
Thank you so much. Let's come to the termination of legal service providers by the Road Accident Fund. As the council, were you consulted or informed when the Road Accident Fund terminated the contract with panel of Anthony's? And if not, why?
Thank you very much, Honourable Member. We were not consulted We unfortunately, honorable member, do not know the reason why we were not consulted, but we were not consulted. And unfortunately, as I said earlier on, I'm sorry, we do not represent members' interest. It was even not within our scope to say, to go to RAF and say, why are you removing our members? Thank you.
I think this will be my last question, Honorable Chair. I just want to check with you if there are measures that are put in place for you to improve the oversight and preventing a future misconduct by your attorneys that you are representing. Thank you.
Thank you very much, honorable member. We are trying to digitalize even the system itself, because you see with the current situation, like what you were saying, honorable member, that there are members of the profession who are practicing without fidelity fund certificate, and at times it's difficult for us to police every court, every member of the public who approaches a lawyer. So what we are trying to do now, we're trying to have a digitalized information where we'll know who has paid the due subscriptions and everything, who is in good standing and who is supposed to practice and not to practice, so that such information we are able to share it with all the stakeholders, in particular the courts, master's office, RAF, and the public general. And we want to also, Chair, we have introduced the issue of membership cards, that members must be identified of the profession. Remember back in the days, during the times of the law societies, the Cape Law Society, Law Society of Northern Province and so forth, there were membership cards for people who are in good standing, so that the members of the public can be able to ask themselves, if you are an attorney or an advocate, yes, can you show me your card? And then you issue a card of that particular year. So that is one of the things that we're putting in place so as to try to curb these bogus practitioners. Thank you.
Maybe just add to that, maybe also jumping back to the other questions. Any member of the public can go to the website or call any province, and you can check whether the practitioner is in possession of a Fidelity Fund certificate. So the member of the public, and this the provinces do with their roadshows, inform the clients of the complainants and the clients of the attorneys of their rights. Don't pay if the attorney is not in possession of a Fidelity Fund certificate, because you're only covered by the Fidelity Fund if the legal practitioner was in possession of the Fidelity Fund certificate once you made the payment.
Ni cancel
Thank you very much, Honorable Bila. Honorable Skosana is smiling knowingly. Honorable Skosana, over to you.
No, I thought you will also respond in Sitsonga. That's what I was expecting. I think Honorable Mentenkuna should help you.
Yeah, actually,
because I think she will be able to translate from Sikosa to Sitsonga, suppose.
No, I need to, but actually know how to respond. Because my fellow caucus member there, that was also multitasking. Honorable Skasa.
No, thank you very much, Chair, and good afternoon to everyone. No, we welcome the presentation from the Legal Practice Council, and we appreciate that you have came and then to make this presentation. I remember that last time I think we met with you, I think in June last year. Yeah, I think that was before the start of this inquiry. Yeah, but I think we learn a lot from you even at that particular time. There's a view or there's a narrative from some former members of the executive management at the RAF that at some point the RAF was captured by big law firms. So just want to find out from you, through your work as an institution that plays oversight on this industry of lawyers and stuff. Did you notice some tendencies that suggest that RAF at some point in the recent years was captured by big law firms?
Thank you very much, Honorable Member. Although we have not made any investigation or came up with any findings, but we are aware that there are firms that are prioritized by RAF for reasons that we do not know over the others, and also the outgone CEO used to utter the words that you are just placing, and there is nothing of that nature that has been ever brought before us, or any complaint by anyone that seek to suggest that there is some capture of that nature. But what I can tell you is that, Chair, these big law firms who are litigating RAF, they have a bigger muscle to mobilize more clients, either lawfully or unlawfully, so through touting, and then they have the biggest chunk of the monies that will be paid by RAF because they have quite a huge amount of clients. So we are then not sure if they are captured or not, but we know for a fact that even in the Eastern Cape, we have small firms in the Eastern Cape. I practice in the Eastern Cape. We have small law firms. The big firm would be Smith Tabata and other few. But we know for a fact that there are firms that are prioritized by RAF, even in East London, for reasons that we don't know. Either they know they will get something, or they love them. We don't know. Thanks, Chair.
So in a nutshell, we are saying there are firms that are dominating in the RAF business.
Correct, Chair.
Okay.
Correct.
Now, since your role, I think part of your role and responsibilities is to regulate the industry. When you look at all these complaints that are coming from the public, from road accident victims, about the RAF and the involvement of lawyers and their roles, do you think that perhaps there are some weaknesses in the legislations that you need to look at as far as the role of lawyers doing business with RAF? Are there some weaknesses that require the amendment of legislation so that you are better able to play oversight on them? Because as much as you did indicate, for instance, last year, that it's only very few attorneys who were found guilty on matters that relate to RAF by yourselves. However, we still even today getting a lot of complaints from different angles. So don't you think maybe there are some weaknesses in the legislations or what?
Chair and honorable members, this one is quite a complex one, because from now, I don't have anything that need maybe to be corrected, because the problem is that even if you say that let us reduce the number of lawyers or what have you, they must not be involved. But once a claimant is not happy, the last remedy in South Africa is to go to court. And even if you may make an act here of parliament, the High Court may overturn it and say, no, as a court, we can't allow to see where the rights of the people are being violated, and we keep quiet. We are changing that. Let us allow lawyers. This person must be represented, and will be represented by a lawyer. So I'm saying then that maybe it's one of the things that, through you, Chair, we may take as a package to go and look at if there are tweaks and turns that may be done in terms of amending either the Road Accident Fund Act number 19 of 2005, that is the amendment, or what have you, or even with our side within the Act. So we will have to look as the council what best can be done to try to assist in regulating what is happening at RAF, and not only maybe at RAF, even in other institutions where there is a lot of litigation, like the Minister of Police and Health.
Okay. Now, during the era of a panel of attorneys, when you compare that era to the current era, which is the post era of the panel of attorneys, and you look at the issues of litigations around the RAF, would you say that the decision to do away with the panel of attorneys, was it a good decision or what? Well, we, at least from where we are seated now, we are told that the intention, even if you had listened to our earlier engagement with the visitors that we had earlier, which is NUMSA, that the CEO said the intention was to try and save money. The intention to do away with the panel of attorneys was to try and save money and have more money going to the victims of road accident, as opposed to more money going to law firms and stuff like that. And I mean, as a reasonable person, when I'm listening to that, I say, no, but that was a good intention. However, we know what happened after that, the litigations, after litigation and all that. So looking at the situation prior to the dissolution of the panel of attorneys and post, would you say, as the people who are regulating this legal industry, would you say it was a good decision to do away with the panel of attorneys?
Thank you, Chair. Chair, the decision was not a good one, but the thinking behind the decision was a good one, to save the funds, because there was a lot of money that was going to litigation and legal costs at the time. But the problem that you are having now and that you are facing is that, for instance, from where I'm practicing, Chair, in Mthatha High Court, every Tuesday in the motion court roll, you will have around 118 matters. The majority today of those matters are RAF matters and Minister of Police. Now, those RAF matters, it's either they are brought to court for purpose of an interlocutory application, either a default judgment, application to discover, application to strike out defense because RAF is not showing up anything. So in any case, even there, all those matters, RAF will be punished with costs in all of them, which then tells you that whatever that you were trying to save, you are not saving it, because RAF does not have capacity to counteract every claim and every litigation that is coming in. And like never before, nowadays, you will find a situation where an RAF claim will be taken in court on default judgment. 5 million claim, default judgment, default granted. RAF had to pay. And you know what RAF will do? Will try to go to state attorney, approach a private firm to go and oppose and appeal. And they appeal a matter that is not appealable, because in any case, they are not running away from the fact that they are liable to pay that particular client. So I'm saying, therefore, that, Chair, let me maybe share my thought on this matter through you, Chair. I will not waste time. I was thinking, honorable members, Kosana, that the then CEO, what he is thinking is that let me get rid of the panel attorneys. Let me build an in-house law firm, because remember, the RAF is not a law firm like state attorney. They don't appear in court. Let me build my own internal house of lawyers. I will employ, maybe, let's say, I will just make random numbers, 10 attorneys. Per attorney, I will put 5 candidate legal practitioners who are going to assist with litigation. But unfortunately, that was not the position. That is why now I'm saying that in courts, there are more RAF matters on the roll like never before. Because before, even though those attorneys were to assist RAF with litigation, but they were all able also to settle. Where they said that, hey, here there is no case, we will be just wasting time. They were able to say to RAF, look, man, let's settle this matter. Let me negotiate a settlement with these attorneys. So now, in my view and how I see it, is that RAF is losing more money than before, not on payment of the claims, but on litigation. Thank you, Chair.
No, thanks, Chair. Now, last year, I think when we met with you, you indicated that a very few attorneys, attorneys, let me say so, who were found guilty of misconduct in matters involving RAF. And I think there was a figure at that time, which was June, that out of 9,671 complaints that you receive, only 280 attorneys were found guilty of misconduct. I just want to check at the moment, what are the figures? Is it are the numbers still so low of those who are found guilty compared to last time, maybe in terms of percentage and stuff?
Chair, through you, the numbers are still low, and I think we did explain it before. Most of the complaints that we do receive in respect of the RAF does not relate, or the allegation starts off that I haven't received payment. So what we do is we will approach the Road Accident Fund. They will provide us with proof once payment has been made. So we will know, has payment been made, has payment not been made. So in most instances, and that's why even if you go to trial, it's acquittal because, or we don't proceed with disciplinary action because the payment has not been made. And the complainant just, and it was explained before, just doesn't believe that the RAF has not made the payment. So most instances they say the claim is 8 years old, I haven't received payment, payment has been made. And when we check, for example, it might be a cost contribution that has been made. So it's, most of the instances does not relate to misappropriation, and where is misappropriation, of course, without fail, that will result in an application to the High Court for a striking off. Thank you.
Through you, Honourable Chair, there's also an element perhaps that we haven't touched on, and that is the ignorance sometimes on the part of claimants. I think not enough is done to educate them about RAF, because, you know, if you speak to a man on the street, I know of one individual who has been fighting for many years. I actually took the opportunity to go and meet him after I heard his plea for assistance on Ukhozi FM sometime last year. And when I met this gentleman, he's in a wheelchair, very, very bad state health-wise. You can see that he injured his, apparently broke his pelvic bone and so forth. But this gentleman for some years now is changing attorneys, gets this one, simply because the passenger that he had been traveling with was paid out a huge amount. I think at the time it was 4 million rand, and he was offered, I think, 1.2. But in his instance, he was the driver of the vehicle, and he had been the cause of the accident, so there was an apportionment. So he readily believes that the Road Accident Fund is in cahoots with every single attorney that he's engaged. So we also need to invest, and when I say we, I also mean the Legal Practice Council, which is why we have initiated these community outreach programs. We also need to invest in educating people, because people do believe that if they are injured, they become rich, and that is not always the case. So some of these complaints are legitimate, and that is where we would respond and even go to the High Court to get a legal practitioner struck off the roll if we have established that monies have been stolen. But others, it's just pure ignorance. A good example also is when a minor is injured, the parent expects money to come now, new house, new vehicle, and so forth. So there are a lot of mislaid public perceptions that both RAF and the LPC, we need to collaborate and try and educate the public on what exactly happens when you get awarded a claim. Thank you.
No, thank you very much. Yeah, my last question, Chair, is with regards to the RAPS bill. I don't know if we have had an opportunity to look at it. Was last time when we met with the Law Society of South Africa, I think it was in November last year, they indicated that they are opposed to the RAPS bill because of some sections that they think it's got a negative impact on the lawyers. So I don't know if you had an opportunity to look at it and what is your view about the RAPS bill. Thanks.
Yeah, thank you, Chair. Chair, at times, when we try to solve a problem, we must not create another problem. That was our view on the RAPS bill, like what the then CEO of RAF was trying to do to cap costs, only to find out on the other hand, he was making a backlog and also creating more costs for RAF. So I think, in my view, is that what we need to perhaps do to deal with this thing of RAF, because I think all of us, there are few things that we're concerned about, is the exorbitant payments, the fraud that is taking place there, and the collusion, because there is a perception that there is a collusion between the attorneys for the plaintiffs and the staff members at RAF, and of which I can confirm that even it's true that at times, even if you call RAF, you write emails, they don't answer. In another case, I even copied the chairperson of this committee, because what happened here, I was doing this claim for the past 3 years. All of a sudden, I'm told that I'm not the attorney for this claimant. And I'm asking to these guys, but how come? Okay, fine, who is the claimant? Who is the attorney of record? They say, no, we're not going to tell you. I went to look for the client, asked the client, did you terminate us? Did you give the instructions to anyone? Said no. Okay, can you do an affidavit to this effect? To the police? Yes. The client did an affidavit to police, a new power of attorney. We forwarded it to Mr. Lance Johnston, who is heading the East London RAF, and to you, Chair. I don't know if you remember that. But up to today, it was last year, we had not found joy and any response from RAF. But the point that I was going to, Chair, is that how much more if we would remove attorneys? Because this thing, yes, I am not going to say that attorneys are not also culprits, because we do have cases where we find people guilty. But the reality of the matter is that if you would see, in most of the cases where claimants go in person to RAF, all their clients, or 90% of their clients, their claims, they are undersettled by RAF, or else they are not done at all. I do have a claimant who submitted a claim at RAF around 2012. We only terminated RAF last year, trying to pursue that matter. Did we receive anything from RAF? No. And it was fortunate for her that there are records that were found on the system, because in other claimants, you will not find any records. So I'm saying that that when we look even at RAPS or whatever view, we must also try to weigh the interest of the clients or the public, that if we don't have lawyers, how much more in light of these particular problems that I'm trying to mention here. So it's quite a problem, but also even there, Chair, if maybe a need be, we may make maybe submissions in writing if we are allowed to that effect, what becomes the view of the LPC, so that when we sit as a collective, we agree what becomes our position, and we made such submissions to that particular effect. Thanks, Chair.
Yeah, no, thanks, Chair. I'm done.
Thank you very much, Honorable Skosan. Honorable Bill, you are in trouble. Honorable Skosan was on exactly 20 minutes. You are in serious trouble now. I just want to, because I don't want to forget, I've made a note here, but sometimes I forget, so you'll forgive me, Honorable Atkinson. I just want to test something with colleagues from the LPC. So we have a fault system, so you have to establish fault, and therefore who was at and who was not at fault, that kind of thing. I'm asking this in the context of the mediation process. Let me test something with you. If Parliament amended the RAF Act and instructed the minister to establish, and I'm asking this as a non-legal person, to establish a tribunal or a commission or whatever the case might be, but put that requirement in the RAF Act to say that in the first instance, the parties make representations to this structure, and the legislation states what type of people and qualifications are required on this panel, right? And that basically claimants, and these may be regionalized even, for instance, given where the Road Accident Fund offices are, but basically establish a structure through legislation that makes the same determinations, because I don't understand the RAF Act to be saying specifically the matters must go to court. It just says fault must be established. I may be wrong, but please correct me if I am. If that is in the RAF Act, and those panels can basically adjudicate, hopefully over a significant number of the claim, in my view, it may settle the matters quickly, etc., and obviate the need to go through a lengthy litigation process where the RAF also must then make, prepare for court process each time. Could that sort of thing assist? And, what works doesn't need to take the form that I'm articulating, but just some step that is legislated where you still meet the requirements of finding fault, evaluating the apportionments and that kind of thing, looking at the medical, legal reports, etc., and saying, you know what, actually claimant X is correct, we agree with the Road Accident Fund, this is proper. My sense is a lot of people, if the thing was properly adjudicated, a lot of claimants would basically say, fine, that's what we'll walk away with. What I'm battling with is, why is it the minimum that the thing must go through the judicial system? I don't get that. Because it delays justice for an insane number of people. And we can't sit here, and I'm sorry, and I part of why we're doing this, we want to improve the lives of claimants. But at the same time, you also don't have RAF litigants as the most important litigants in the country when people are also adjudicating estates, etc. There's like all sorts of other agencies. Can you just assist the committee? If something like that in our recommendations were to be there, could it work?
Thank you very much, Chair. Chair, I think what you are saying would work, but we must note that even that process, if it collapses, courts will have to come in.
No, I need to be clear. In South Africa, just about everything is subject to judicial review. I'm well aware of that, so let's not even bother with that one. I am trying to solve a problem of the high courts being hostage to two types of civil claims. It's RAF, it's medical legal claims. It's ridiculous. We can't employ 800 more judges to sit over these two matters. It's insane. We need to solve this problem, and I want to know, accepting the judicial review as a next step, could something like this work?
Yes, Chair, through you, it would work, because remember, here, as you are saying that there would be a clear stipulation, what type of people are we looking for to adjudicate over these matters and so forth. And for instance, we'll have a committee, for instance, like this or smaller, to look at these files. Does this file comply? Does it meet all the requirements? Yes, done, settle this one. And Chair, at times these things delays. Remember, what guides these claims are the precedents and also the quantum year book, which will tell that if so and so had a fracture in the tibia or in the femur, this is the amount that was claimed in 2010, and today this amount is equal to this particular amount. So if we can have that particular committee that you are proposing, I think it would help, and we simply outline the guidelines and the processes and put timeframes even to that particular claim. I was asking some other colleague of mine who was working for RAF at the litigation department. I was asking her, do you have targets of settlements that you must do maybe per month or per week? Are you meeting the targets, all those things. So that is another issue, Chair, that we would look maybe to make sure that it must also have the targets or the statistics that we must be able to settle this amount of claims so as to push this backlog. Because indeed the issue is not about the attorneys, it's about the claimants who at times even die without even tasting their money. Thanks.
All right, thank you very much. Final question. So when the National Consumer Act, I think it is, came into effect, those who've got cars know that now a couple of things happen at the dealership. One, there's that thing that you sign that motorists don't read. Take time to read that thing one day. But you sign that thing, firstly. The second thing is that they must call you to say what repairs they're going to make on the car and how much it's going to cost, even if your car is still under warranty. Third, the service advisor must sit with you there and explain to you what they've done, even if you've got no idea about cars, but they must tell you what happened. It's now a requirement. Can I ask, when a claimant approaches an attorney, is it a requirement that the attorney explains some things to the client? Because I also, on my email and social media and so on, people ask me questions, innocent questions, but are ignorant. I was in a car accident. I was driving by myself, and I haven't received anything from my claim. I'm unhappy. Now, that's a person who does not know. I mean, you were driving by yourself, right? You understand? It appears to me there is a whole lot of pain and unhappiness in the sense that people get engaged. Everybody just gets absorbed by the administrative process. Very little is explained to the client. Shouldn't there be a requirement like that? That if you're dealing with personal injury, it's not an option. You must do it. And once you've done it, the claimant must sign there and say, this has been explained to me, this is the content, and keep that thing, hang it on your wall if you must, together with your certificate of baptism, until the claim is done. Is there something like that?
Thank you, Chair. Chair, it is a requirement that if I'm going to represent you in a divorce matter, after consultation, I must be able to explain to you that, look, the law says, Section 7, subsection 7 of the Divorce Act, says that half of your pensions, we must give them to the other spouse. I must not say to you, no, it's fine, let's do the divorce, and I end there. I have a duty to advise you. But what I'm picking up from what you are saying, colleagues, is that there must be some sort of agreement after that consultation that we must make it a requirement that after you've met a client, you must be able, beside the power of attorney, but you must be able to explain this type of litigation that you are going to engage in for the client and what are the pros and cons of it. Because from what you are saying, you are correct, because the other claimant might have been a driver, and from what was also explained by my colleague, and then when the claim had to be apportioned, he does not understand why there must be an apportionment because, look, I lost a limb from that accident, not knowing that it was looked at the perspective that you contributed to this particular accident. So I think from what you are saying, we are taking that home as a package, but it's a duty of every legal practitioner to advise the client and not to mislead the client. For me to say to you that we are going to win, although I see that we're not going to win. We do have that legal duty as attorneys.
So just to be clear, in the same way that car dealerships must, and they must give you that piece of paper, and you must sign it. I think it needs to work like that.
Yes.
In these instances, not trust a lawyer, because I must be honest with you. I sometimes wonder, how do you have an attorney and you don't know this stuff here? What did your attorney tell you? You understand? Anyway, let me leave it there. But I was just thinking about some of the recommendations. But please take that with you, Honourable Atkinson.
Thank you, Chair. It's noted.
Thanks very much, Chair. And I'm going to take up a little bit of the first question you're asking there. And it's, again, to do with a possible settlement hub at the Road Accident Fund itself, okay? So it's my understanding that an earlier iteration of the Road Accident Fund, going back 20, 25 years ago, It was more a case of, it was an exception to the rule that a case would actually go to court, okay, and that most of the settlement was actually done within the Road Accident Fund. Now, you know, we've heard much of the former CEO trying to save money on legal fees and everything, but surely that would be the answer, is for you to run a properly constituted settlement hub at the Road Accident Fund where there's a proper menu of, you know, loss of limbs, the severity of the action, the effect that it has on your life and all that sort of stuff, and that they can actually calculate claims based on that, on effectively a menu of issues that is clear to everyone. You know, so there's nothing hidden, and it would make it a lot easier to expedite a claim. So, in other words, if you have a settlement hub, the claim can be put in. Road Accident Fund can come back and say, okay, on the basis of the fact that you've lost a limb, that you're paralyzed or whatever, we can pay you out X amount, and that's it. And then the attorney obviously can look at it and see whether they're happy with it. And generally, if it's a fair offer, you know, it's really no value in going to court and delaying the process any further. So, you know, it's in essence a little bit of what the chair was saying. It's happened before. I don't know why we can't go back to that. Why we can't go back to a situation where the Road Accident Fund's got people who properly legally set up to be able to make those assessments and make those offers. I don't know what your view on that.
Thank you, Honourable Chair. I think that also is an opportunity perhaps for greater collaboration between us as the legal regulator and the Road Accident Fund. My understanding is that the claim handlers at the Road Accident Fund, you need just an LLB. I don't believe that you need to be an admitted legal practitioner. So it then goes to the issue of quality assurance. So if they could then up the standard and have a discussion with us, I believe our colleague who is accompanying us and is a member of council did allude in his earlier statements about the possibility of them also looking at taking on candidate attorneys. Now, that would obviously require a legislative amendment to the LPA, but those are the discussions that should be had. How can we maximize output without actually, finding ourselves in a situation where you've got this entity that constantly is under scrutiny and underperforms because it has capacity issues. We also experience capacity issues, and we've also taken the initiative of amending our rules to, somehow short-circuit longer processes that were elaborate unnecessarily. So I think there is a conversation that we can have going forward, but I certainly believe that if the quality of the claim handlers was at a higher level, they would be able to deal with those type of matters internally. Thank you.
Just to add just one thing. Honorable Member, I'm sorry, Chair, through you. The other reason that makes claimants to go to court, it's because you must remember, from the date of accident, if you have not done anything about the claim to the lapse of 5 years, it prescribes. And the only way to stop prescription is by issuing summons. So I think that is also another problem. So once you issue summons, you will have to follow up. And I can tell you and be honest with you as a practitioner that from that process, there's a lot of money that RAF will lose on litigation, because the first one will be the first default judgment. After 20 days, the order say they must file their own plea. They don't file, you write a letter to RAF, that file your plea, there's this court order, they don't, again, you apply for another default judgment. Every time they have to pay costs. So I'm saying that also there is that particular requirement, that then it's a must that you must issue summons, because if you don't issue summons, the matter prescribes. Once it prescribes, then it's your fault as the attorney. You have to be punished by the LPC, and the LPIF have to come in and pay for you. Thanks.
But how long is it before prescription?
From the date of accident, Honourable Member, it's 5 years.
Okay.
And most of the cases, they go as far as 9 years without being settled by RAF.
So what I'm saying is that we should aim for a far more efficient RAF that settles all the claims within a year, basically. And if you've got a settlement hub, you can do that. So prescription doesn't actually become an issue because, I mean, we definitely don't want to be in a position where we making people wait 5 years to get a payout. And that's why I think it's all, you're right, it's all about capacity issues. It's all about having the right people, the Road Accident Fund. Maybe it was a very bad idea that they got rid of all their lawyers and all their properly legally constituted people who could have actually done this and actually saved the country a lot of money as well by having a group of people who are actually able to do that. And I think that's maybe something we should look at making as a recommendation. The other issue relates to prescription, and that a lot of the cases have actually prescribed in the RAF's hands. So I think people have lodged cases with the RAF, and they've sat there for so long that they found out or don't realise that they're prescribed. And what action do you think should be taken about that to protect the public?
Thanks, Chair. Chair, I think you should apply what is applied by the Minister of Police. If a police officer was negligent, then a portion of his pension will be deducted as a way of punishment from his negligence that costed the state. Because the problem is that with the RAF, they do whatever they want as it pleases them. I can show you a lot of emails, they don't answer, you call them, they don't answer even the calls, you call them to court, they don't come, they don't do anything. And at times, we even accuse the judiciary of defending RAF because at times, the judges will want to be productive a bit. So what I'm saying from what you are asking, Chair, is that there must be consequences of that because these claims prescribes at their hands. Yeah. And now it becomes a burden of RAF because the longer the claim it takes with RAF is the bigger the amount of costs it attracts.
What can be done to protect the public there? I mean, obviously if they don't know their claims prescribed, they can't go and then put, go for a legal injunction or whatever to try and get the claim current again, basically. So, I think the point I'm trying to make is that we face with the issue where there may be a lot of claims sitting at the RAF that are just never going to go anywhere because they're prescribed. And that member of the public doesn't know, and they're not able to actually go and get it reignited again by, as you say, bringing a legal action to make their claim live again. So how do we protect the public on that issue?
Thank you, Honourable Chair. Perhaps the committee could consider recommending that there be an insurer, because it's a very big and vast field. Road Accident Fund, there are always going to be accidents, unfortunately. And as much as it's not an ideal situation to cater for an eventuality where a claim prescribes in the hands of the RAF, but even when you have efficient systems, those things will happen. In our profession, we've got the Legal Practitioners Fidelity Fund, so they provide insurance for the entire profession. So that I think is something that the state could consider going forward, so that the member of the public is not adversely affected if the claim does prescribe. Because at this point in time, I'm not sure where the recourse would come from. Thank you.
Chair, if I may also maybe just add there, I think RAF cannot run away from the fact that once you establish something like direct claims, you take on a duty of care, right? And I mean, there's plenty of case law around duty of care. You cannot say to a member of the public, I'm an organ of state, come to me, I'm going to assist you. And then you fail in your duty. And then you say to the member of public, oh, well, sorry for you, bad luck. So firstly, I do not believe RAF should be allowed to hide behind prescription in matters where there were direct claims. Possibly what needs to happen is that those matters need to be identified. Let it go the proper route. Let it be referred to attorneys. Let it be referred to pro bono, whoever. But you cannot prejudice a member of the public where an organ of state has taken on a duty of care.
Your view on this practice directive on mandatory mediation on RAF matters. Do you think has that succeeded at all in addressing the backlog in court roles, mandatory mediation?
Yeah, thanks, Honorable Member. I think that was trying to assist because at some stage, Justice Mlambo tried to test it when he was still the president of the Gauteng province, the judge president. But I know that there was a lot of lamentation from the then CEO saying that in this mediation, Justice Mlambo appoints practicing attorneys who are doing RAF litigation, and therefore he does not trust the process to be genuine. But on the same vein, remember, these are the same people who act as judges. Either they are attorneys at the end of the day. So there was also that particular dichotomy from him that he does not trust the process. But from what you are saying, I think what you are saying is exactly coming close to what the chair was proposing, that there be a tribunal special to deal with RAF, and I think that would help a lot than to have a court. Because imagine, there are other litigious matters that have to go to court, and they don't have space to be heard immediately because of RAF matters that are clapping the backlog court, the court rolls. Thanks.
I think it's important to note as well that this issue of the settlement hub that I mentioned, the fact that it can be done immediately and actually doesn't require legislative change, because it has been something that's happened before. So we don't have to change the law to do it. It's just, in essence, we just need to get the road accident fund set up and to make sure they've actually got the right amount of people that can actually run the settlement hub. Then the other thing I wanted to ask was, does a person impersonating a lawyer and then charge a fee as if a practitioner had actually done the work, does that, in your mind, constitute fraud?
Thanks, Chair. Chair, there is a judgment in East London High Court by Justice Jolwana and Justice Stretch, where an attorney terminated another attorney, and this one simply facilitated the process and the matter was settled. And that judgment was saying that, no, you're not allowed to charge 25%. You can't charge contingency because the work that you have done is too minimal. You're supposed to prepare a bill of costs that will be taxed. So I think I agree with that judgment, because remember, RAF will then have a burden to pay the first law firm or the first attorney and to pay the second attorney, and that would be a double jeopardy in a way if you are going to pay both of them 25% from the monies of that client. So I think it's undue enrichment, that one. Thanks.
What is the stance of the LPC where such instances have been proven and shown that these people are employed or contracted by actual practitioners? How long should it be? How long should be a reasonable time to investigate such serious transgressions? And what would the penalty be if such a practitioner is identified and the case is proven?
Thanks, Chair. From this case I was mentioning, the practitioner appealed, and unfortunately, in the Supreme Court of Appeal, he was struck off roll. So that is now the precedent that we are having at the LPC, that once there is a matter of that nature, we will strike you off roll. Once we find out there is concrete evidence against you, then we have to strike you. But on the investigation, through you, it's very difficult to investigate someone who knows the law and someone who knows how to duck and dive, how to delay. Because I remember the other case, whilst I was still sitting in the diocese of the Eastern Cape, you will write to this attorney, you request him to come and appear before the investigations committee. On the day, he will serve you with a doctor's note that, no, I'm not available. At some stage, we took a decision against him. He went to court to apply for a review, and the judgment was saying that no, you are not doctors. You can't take a decision whilst he filed a doctor's certificate. So I'm saying that you are dealing with those types of people who know. So it becomes very difficult to, although we try to do matters as speedily as possible. I remember in the last council, the chairperson of the council, who said I must apologize for him for not coming, was even suggesting that let us give legal practitioners 10 days to respond. said even there, these people are going to go to court and say that this time was not reasonable. And they always have stories and stories and stories up until such time. That is why at times, whilst we're investigating you, we run to court to interdict you from practice. So we are trying to keep that because you know someone who is a chair will continue mosha once abenetyala kungona za moshela niba athi mandate send betiwe. So I'm trying to say that a person
Help you, Honorable Atkinson, but I totally get it.
I was trying to explain to him, Chair, through you. I'm sorry. Because, you know, at times, when you speak the mother tongue, you explain something better. But my point was that the reason we interdict them is because we know that other people, when they see that they are in trouble, they say they don't care about anything. They say, let me do whatever it takes, and for that matter, I'm going to be struck off road. So that is why we run to interdict them from practice, because we know that they are going to delay and come with tactics at the expense of clients and members of public. Thanks.
Now, Chair, we have had the explanation on behalf of Atkinson. We have heard on his behalf.
Yeah, no, I can literally see this.
Just one last question. Can you give me a definition of touting, or what your definition of touting is? And what are the limits of touting, basically?
Thank you very much. You are asking very technical questions. Remember, there is a thin line between...
I thought you were going to say you're asking the expert himself on touting. I thought you were saying you've come to the right place. I'll tell you how it works.
No, that is not the position, Chair. But the point I'm trying to raise is that there's a very thin line between marketing and touting. But with touting, once it amounts to unlawful attraction, there must be an unlawfulness. For instance, you can't say that all of us who are practicing RAF, you say that you are the best lawyer in RAF. Once you say that, then it means there is an element of touting. You are, because there is nothing that you would prove to show that you are the best out of all of us, because we also settle claims like you do and do whatever like you do. So once there is that element of unlawfulness in attracting clients, then there is touting. And also, you will remember that other law firms, they even have members of public who are in hospitals, like for instance in these orthopedic hospitals, where once they see an ambulance coming, bringing a person who was involved in a motor vehicle accident, they run to him and say that I work for this particular law firm, can we assist you with the RAF, all those things. And remember, the element of touting would be then because he's going to sell that particular client. He's not going to be paid at the month end. He's going to sell that client maybe at 5,000 rands, that I'm going to give you a client, give me 5,000 rand. Then that will be touting. Thanks.
If I may add, there is a definition in the Code of Conduct, paragraph 18.22. I don't know, must I read it to you? So it's the following is misconduct. Not tout for professional work. An attorney will be regarded as being guilty of touting for professional work if he or she either personally or through the agency of another procures or seek to procure or solicits for professional work in an improper and professional manner or by unfair and unethical means, all of which for purposes of this rule will include but not limit to the following. 1, the payment of money or the offering of any financial reward or other inducement of any kind, whatsoever, directly or indirectly to any person in return for the referral of professional work, or directly or indirectly participating in an arrangement or scheme of operation resulting in or calculated to result in the attorney securing professional work solicited by a third party. And then it explains also what is professional work.
Right, thank you very much. And thank you. I'm done with my questions. Thank you.
Thank you very much. You know, in the taxi industry, a tout is a serious person. But I see in the legal profession, you get into trouble if you are touting. But at the taxi rank, you are you're a person of power and status. Honorable Isaac. Thanks, Honorable Atkinson.
Thank you. I'll save you the torture. I'm covered.
I'm so disappointed. I am so disappointed that you could, you know, Honorable Matiwan, I think the two of you knew that Honorable Isaac wouldn't ask any questions, and you came back just in time. So it's your turn, sir.
No, thank you, Chair. Ingxaki isekugqibeleni. Ngoku sifika umongo sophelile. No, Chair, I just wanted to touch on what I think Honorable Atkinson has touched on. I missed the later part of the response on touting. Was one of in the last sitting that we had, I made an example about being socialized in Mthatha, and I think the current chairperson is practicing there in Mthatha. So one of the issues is that there is overreaching, which leads to overcharging, and then there's a failure to account. And one of the issues that we raised was that self-regulation has its limits because there is a potential conflict of interest. I remember the last chairperson said that they are in business, they are for profits. And once you are for profits, that means you'll always protect the bottom line and not put the interest of the public and put the interest of the public. So there was an issue that we raised with regards to the Legal Practice Act vis-a-vis the Contingency Fees Act in Section 5, which makes provision for client review of contingency agreements. And then the answers in that previous engagement that we had in June were a bit much not straight to the point. But I'm interested in hearing, because when we speak of touting, we usually associate touting with the smaller law firms. But the current chairperson now makes mention of the big law firms being the main culprits of touting. So how prevalent is touting within the industry? I don't know if that, in your response to Mr. Atkinson, you covered that. And also, do you think that the Legal Practice Council is best placed to deal with complaints from the public, whereas an independent ombud, maybe a retired judge would be appointed as an ombud, would give a much fairer assessment than a player who's within the industry? Because if you are practicing, you also want to protect your law firm in the future, that if I might get into this, I might not want to be harsh. So I just want to check that. Thank you, Chair.
Thank you very much, Honorable Chair. Firstly, let me deal with this one of the legal ombud, for instance, that make the example that you are making. There are quite a number of complaints that went to LPC, and after LPC, they went to the ombuds. All those, most of them, I think most of them, if not all of them, the ombuds will say also there is no case here. The LPC was correct. The difference is that all the professions, they are regulating themselves. HPCSA is regulating the medical professions, psych, and so forth, things like that. And remember, I think it would be quite very difficult for, just imagine if lawyers were to be regulated by accountants. Cases won't proceed, I promise you. Lawyers will come with the best technicalities ever so as to delay the cases and legal terminology and legal maxims so that cases don't proceed and court cases that are not known by the members of that tribunal. So I think, in my view, it remains better and best within the legal profession, which is that now is the LPC that is regulating, which is led by the legal practitioners. And you must remember that in the Legal Practice Council, we're having advocates and attorneys. And also in the same breath, I think I am the only one in the council who is doing road accident fund work. Most of them, they don't have serious clue about the modalities of RAF. They come from medium law firms. But the point is that I'm trying to make, that it's better that we have lawyers who also know the technicalities that may be involved, although even for us, it's not very easy. It would be worse for someone else. And the other issue that you are raising is on the issue of touting, how prevalent it is. Honorable Member, you can go to any orthopedic hospital. We go there as if we're members of the public. You will see ladies carrying handbags there, running after every ambulance that comes in. Or you approach the injured people, that did any person came to you and say he's working for a law firm? The answer that you are likely to get is yes. There is some lady who was here. I'm sorry to say ladies, maybe a person, let me say a person. But most of the time, it's ladies. So I'm saying that that is very prevalent. And also, it is also true that, Honorable Member, that these big law firms who are practicing RAF, they have a bigger financial muscle. They are able to do that thing of touting. But with me, Chair, if you bring a client and say, I must pay you 5,000 rand, the first question I will ask you, what if I'm going to be terminated before I finish? Will you give me back my 5,000? Where will I find you? So it then makes it difficult for me to allow you to tout for me, because there is a risk. First of all, you don't know this person. You only met her at the hospital. And this person tomorrow might get someone whom he knows, who knows some other lawyer, that let us terminate this one, I don't trust him. So that would be a loss to me, which then they will terminate it as a risk in these big law firms who have a bigger financial muscle to lose 5,000. To me, it's a serious thing to lose 5,000 rands. So I'm saying that this issue is there, although I cannot mention A, B, and C, although I know some of the big firms. I know even if you can go to Eastern Cape, Lusukisik and Port St. John's, there is a big white law firm that is in charge there. And they pay these clients 1,000 rand per month. You will not get those clients, even if it's the guys from your village, because you will not afford to put them on your payroll until the matter is finalized. So the issue of touting, it's there. But it comes back to what my colleague here was saying, that it's important that there must be some collaboration between RAF and the LPC in terms of engaging the members of the public about their risks and what and how these claims had to be done. Because the only thing that RAF tells people, they tell how cruel are the attorneys, although they don't tell the clients that they also not settle their claims at a reasonable amount. Thanks, Chair.
Sorry, if I just might add, I can speak to the number of complaints that we receive with regards to touting. That's few and far between. And I must say the quality of complaints that we receive, unfortunately, comes from the tout that hasn't received payment. So the quality of the complaint, unfortunately, is poor. Even as one or two complaints, most of those complaints, unfortunately, are dismissed. So we know it's there, but we don't get many complaints, and the quality is unfortunately very poor.
And Honorable Member, the rule of law is saying that when the reasons of the law falls away, then the law itself falls away. Iudes causae memo judex less.
We'll get the correct spelling for all of that for the transcript later from you.
Are you done?
No, I'm done, Chair.
Thank you very much.
I was just going to say I've dealt with a declaration. I've dealt with the English from that University of Transkei. You need so and then
I think you and I will need help. So the town basically says, no, we were together in the crook place, and now they're not paying me.
But I have encountered a tout. I was in an accident many years ago, and I was still young, actually. I think it was 1999, and I had not told my boss that I was going to town. So now I get into an accident. And out of no, I mean, there was a tow truck that got there, and then the tout before the ambulance got there. I don't know how the tout got there, but anyway, I was still like coming out of the car and everything, and there was this gentleman basically saying he can help me get money. It's called Imali Amatambo back then. This was in thing, and I was worried that my boss is going to need to sign this thing. So I refused because it was going to go back to my boss, and then I would have to explain why did I have an accident in work time. So I couldn't. No, I forfeited Imali Amatambo. Thank you, Honourable Member.
Thank you, Chair. Good afternoon to LPC. Now, Chair, I just want few clarities on these matters. First being the input of LPC to the RABs. And my brother here says the RABs is more of a reactionary response to the matter. I want to understand you clearly. What's your input to RABs?
Thank you, Honourable Member. Honourable Member, we submitted to this Honourable Committee that we did not prepare anything in that regard, and we even said to the Chair that if we are required to make submissions, we will request, we can do that after we have met and look at RABs. I was shooting from the hip when I was talking about the RABs bill. Thanks.
So, I want to believe, Chair, correct me if I'm wrong, when the Deputy Minister was here with the RAF management, they said they had opened submissions for the RAPS bill at some point, especially to stakeholders. And I want to understand, so is it the first time that you're going to make that submission in terms of RAPS? Or have you ever made any submission to the department in a process of drafting a law which is going to correct this whole mess? Have you ever done any?
Thank you, Honourable Member. Honourable Member, we have not made any submissions. Remember, our mandate is to regulate the profession. The people who are at the forefront in dealing with that would be BLA, NADEL, BCA, LSSA, AFT, GCB. Thanks.
Don't you think you will be missing an opportunity if you do not make a submission in a law that affects a profession which you also see over?
Yes, Chair. We would be missing an opportunity because whatever that may come in the future, we will not be able to change it immediately. That is why I was submitting that. That is something that as the council will have to look at. But our operation is that our profession is quite very fragile. Whatever that we do, we need to be very careful of our stakeholders because there is a lot of litigation, even against us, in particular by these bodies that I mentioned. Once we try to step in their own terrain, even, for instance, even in issues like bricks, they say, LSSA will say, no, you can't go there, LPC. That is our terrain. It's us who are representing members, not you. So I'm saying that we're still battling with that. And remember, we come from the regime where LSSA used to be in charge. And now there is LPC that regulates. So there's still a battle. We need to be very careful of where we step and how we step. But one of the things that we were debating with the chairperson, we were saying that let us have a meeting with all the stakeholders because remember, we don't perform union functions. We don't call even AGMs or what have you consultation meetings. We are only doing it through our provincial offices to go and talk to public and so forth. But we don't have a forum in terms of the legislation where we will call all lawyers, although we are voted to office. But we don't account back to them. We account to the minister and the portfolio committee in parliament. So that's what we wanted to engage on, that let us try to go to the ground, to the people and to the profession and engage members even about the issues. So this thing of RAPs, I think then it's one very critical issue that we must look at, and we must engage these other stakeholders that they must also allow us to have a view on matters of interest that will affect the profession. Because also as a body that is there, we have to make submissions and not allow anything to be done without us having a view. Thank you.
Thank you. Also, believe that I think you will have to engage the developments surrounding this, because before you deal with on a daily basis matters that are implicating lawyers in a rough space. Be that as it may, then I will forfeit my next question because I have not dealt with them. Now, I want to go to the issue of power of attorney versus termination of an attorney by a client. Here we have a campaign in the EFF that people who were never settled, their claims were never settled by RAF, should call us so that we can also speed up the process to understand who is failing. That is also due to the understanding that we have seen that the terrain within the RAF space has been a battlefield of other people want to loot it as fast as possible. Others want to sabotage others. Others are collapsing others. There's no one who wants the best interest of RAF. Anyone who wants the best interest of RAF is collapsed by the next one. Then the next one wants to loot as much as they can. When the other one is trying to stop them, then they are fighting on the other side. And then we have courts in the middle of all of this. And understanding the crime in South Africa, courts have no time, neither do have enough personnel to deal with the cases of RAF that are coming in on a daily basis. Now, here's what is happening with the cases that we've dealt with. I would say this with my chest out. More than 90% of the clients, the cases that we have now, Commissar, about more than 2,000 already. More than 90% of those people, their cases are with lawyers, but they have no clue what's happening with their case. The lawyers don't tell them. But when we call, they say, no, the matter is at court. When we call RAF, RAF says, no, their matter is at court, so we're waiting for court. So the people who are actually causing this whole thing, they don't inform clients of the offers to start off with. When there's an offer, they don't tell the client, they take the offer to court. That is for the benefit of a lawyer, because if the offer is less, there's less money they're going to get. Then on the other hand, there's a matter of 25% or the cost of servicing the client, whichever is lower than that. So for them to make the cost matches 25% is through the delay tactic. I'll delay, I'll do this, I'll do that. Thirdly to that, RAF was here. They say lawyers will assist people, submit a claim, then on submission and prescribed documents that should go with the claim, there will be this document outstanding, and when we ask for it, the document doesn't come forth. Then there's another document outstanding. And this is done intentionally so that the process prolongs. And then it gets to summons, and then it gets to court. And then there's default judgment. So the pile of work within RAF is not only of RAF's doing. Lawyers are also pushing things to court unnecessarily, where clients did not give them an instruction to go to court. Here we are dealing with people who do not have an instruction to go to court. So when I respond to any client who says, I'm told by the lawyer I'm waiting for a court date. For what? I don't know. The lawyer says my matter is at court. I don't know why it's at court. He had told me that 5 years ago, and he's still saying today my matter is awaiting a date in court. Now, what is the process that's there for the people to terminate such lawyers? And then number two, how are you reaching out to the public in terms of public awareness on the do's and the don'ts of the lawyers? Because we are dealing with a lot of corruption, and we don't want to be dealing with information that is not out there. Can we get to understand? Now, I don't understand how to get hold of LPC, how to complain at LPC. What's your public awareness program, as well as what should a person do when they hear that my matter is at court, yet I didn't give you an instruction to go to court? I don't even know what are you arguing at court.
Thank you, Chair and honorable members. Honorable member, you made such a very long input, but I will try to answer and my colleagues will assist me. Let me first address this issue of matters that are in court without clients' instructions. I wish there was time I was going to read to you what is contained in the power of attorney. One of the things that the client is agreeing to is for me to litigate. So we go to court because of that power of attorney. I think we agree on that one. Let's go to the next issue. The next issue that you are raising, honorable member, is that these clients are not briefed about what is happening on their cases, and of which that is where there is a problem. There is a charge in the Code of Conduct of failure to account to the clients, and of which legal practitioners, we don't have a duty to tell them what is contained in the Act. Every lawyer has a duty to read the Act. But hence, we said earlier on that we do have programs where we engage public to tell them about LPC, what are we doing. Even if you can go to our website, you see, for instance, the LPC in the Eastern Cape, they were in Mdantsane not so long ago, talking to the members of the public about what the LPC does, and so forth, things like that. And the other reality is that not everyone is having access to internet to know these things and to go to the website. But wherever, if we will come across a radio or TV interview, we always talk about these things, where to find us, how to find us. But then the issue of termination, when you want to terminate a lawyer, you simply go to another lawyer, prepare a power of attorney, sign, and a termination, you serve the other lawyer. Then if that lawyer does not comply, then the other lawyer or the claimant herself or himself reports that to the LPC, and then we come in, because that would be an unethical conduct. Once you receive a termination, you have to stop there and there, whatever that you were doing in that claim. Then, I'm saying then on this issue of, it seems as if there is a general problem, Honorable Chair, and even from what you were saying on your opening remarks, and the Honorable Member Mende is saying that clients don't know what is happening with their claims, and the members of the profession are not briefing them from time to time as to what is happening in their cases. And this problem, we once engaged about it, because even the Act, in the Code of Conduct, we don't have clear stipulations as to, maybe we are speaking of reasonableness. We don't tell that you have to brief clients about their cases, update them on monthly basis or quarterly basis or 2 months basis. We don't have a provision to that effect, but we are simply saying that clients must be briefed from time to time about what is happening. If you don't, then we will charge you for failure to account to the client, because you have to account to the client from time to time. So those are the issues. And in other instances, Honorable Member, I will be honest and tell you that at times we fight with clients as attorneys. We fight because either or the issue, Honorable Member Matiwan, there was that issue you raised about the settlements, and that attorneys don't accept settlements, or it's you member, the settlements. The reason you don't accept a settlement, remember, once you undersettle a matter, that is misconduct. We may charge you. It's not because this lawyer wants to enrich himself. And remember, with RAF, most of the things are not as complicated and complex as one would think. For general damages, for instance, there is a quantum year book. The quantum year book is updated every year. It will tell you if there was a case of Zneti Letia versus RAF in 1999 where he suffered a fracture in the clavicle bone or what have you, this amount was paid, and that amount today is this amount. Ne? That is not supposed to be. There's not supposed to be a fight about that, because we are relying on the precedents in the quantum year book. The RAF also have quantum year book. We also buy quantum year books. Let's go to the next issue on the loss of earnings. Loss of earnings and loss of support. You will have an actuarial report. Where then RAF, what they do, you will submit all the reports. They don't settle your claim up to the lapse of 3 years. And remember, after 3 years, if you go to the actuary again, it has attracted more money. And in most cases, you will have to take them to court time and again. They won't want to discover their actuarial report, because it will give more money than the one that you submitted to them. And they don't want to pay you that more money. And the perception is the public perception, that you are enriching a lawyer, it's not about the client. So I'm saying, therefore, Honorable Member, that those things, we need to look at them with that eye, that this claim is a claim of a client, it's not a claim of the attorney. And also the attorney, once he undersettles that matter, it's a misconduct. We'll have to charge him. And when we charge him, the other lawyer had to sue him for undersettlement. So there is also that problem. On the issue of delaying tactics, I will disagree with you, Honorable Member. It's not attorneys who are causing these delays, it's RAF. I talk this one with experience as a practitioner. I can tell you I have a matter, Honorable Member, Chair, that the accident was in 2019. RAF in December only rejected RAF 4 that we submitted to them in 2023. Who is delaying the claim? Because we had been following up with this claim. You can see the trail of emails. And also, in another matter, I like this client. He's a member of the ANC. She does, she will call RAF and come to me. When she comes to me, she will say that I called RAF. At RAF, they are saying, you did not file ABN sale. So I come, I open email, I show her that, look, can you confirm that this mail was received? You see that there's a reply later on at some stage. You say yes, and then say, who is at fault? You see? And once you sit on the claim, you don't take it to court. Once it prescribes for you, not for the client, not for RAF. So you have to take it to court. And I can tell you, Honorable Member, before I rest my case, there are claims that I'm doing personally that we have went to court for more than 3 times on default judgment. And at times, RAF won't even be there at court. And it cannot be rolled where there is no proof that a notice of set down was served to RAF. So I'm saying therefore that RAF do not want to take the blame in this matter. And I can argue this even in front of them. I can provide proof where it is needed that it's them who are delaying these matters. How could, the regulation is very clear, Honorable Member, Regulation 32B, that RAF are supposed to reject RAF 4 within 90 days from the date of submission thereof. I'm saying that an RAF 4 that we submitted in 2023 was only rejected in December 2025. And remember the process, on the other hand, you're supposed to appeal to HPCSA. We appealed in another matter to HPCSA in 2023 September. HPCSA had not replied up to today. That matter I have enrolled it before East London High Court for a review of that decision of RAF. So I'm speaking these things from experience, most of them. It's not theory. And where it's needed, I can provide proof. In the matter that I said I copied chair of this committee, all of a sudden, RAF, after 3 years, they are saying I'm not the attorney of record. Up to today, I've submitted every document to prove that I'm the attorney of record, even an affidavit from that client. RAF had not responded to put where we were going to be put here, RAF and us, so that we can try to check who is telling the truth, who is not telling the truth. Thanks, Honorable Member.
Sorry, Chair. If I may just add, you might be quite right that there are attorneys who don't tell their clients about the office, and that's not right. But what you need to ask the RAF, so if you look at section 17(3)(b of the RAF Act, right, it says the court, in issuing any order as to costs, may consider any offer that has been made, even without prejudice, right? And what that simply means is that if the RAF, before summons, right? If the RAF has issued an offer, they can bring that to the attention of court. So what you need to ask the RAF is, how many matters have the court refused to order costs because an offer was made? And I want to almost guarantee you it's going to be negligible.
Thank you, Honourable Chair. You touched on a point that's very close to my heart, and that is the issue of public awareness. I feel as an organisation we still have a lot of work to do in that area. We have started. My colleague raised the fact that we raise awareness on community radio stations and so forth, but I want to concede that it's still a gap, and it's something that we need to address, aggressively address. We are going to be having a strategic planning session in the next 2 weeks. I'm hoping that after that strategic planning, we'll come with a stronger communication strategy, because the people that we actually should be reaching are the vulnerable people in the rural communities. The ones in the urban areas and the cities, they know, they go onto the website, but for an older person who's sitting in Matatiela or Nongoma, I witnessed this way in the outreach program that I was part of in December. They had never heard of the LPC. But what I also learned from that initiative is that it doesn't help for us as LPC and our insurer, which is the LPFF, to go alone. It would also help for us to have a greater collaborative effort, have people from the Master's Office, have RAF, because some of the people in those communities have questions about deceased estates, which we cannot assist. So I want to take that point, and I want to assure you that it's definitely something that we are going to invest more in. Thank you.
No, thank you very much for that, because I have a couple of cases which I can, in the immediate, send to you for you to deal with them and reach a conclusion of them. One of them, just earlier on, I went out because I asked for information. One lawyer, for some reason, a client was deemed to be mentally unfit. They have siblings that are fit and all of that, and the money goes to a trust. So for safekeeping or some sort, and it gets released periodically on demand. This person doesn't have a house. He has money there. The lawyers don't assist in getting this person a house. They don't assist this person to get proper food, clothing and everything. The EFF just in December had to go shut down a lawyer's firm in demand of this person's money to have food. The siblings have been reaching out to the lawyer with quotations. They are not saying give us money, with quotations for contractors to build him a house. They have not done that. I have several other cases where money was paid, but kids are in care of other people. Those people have no access of money. The demands that are made in terms of proving that you need this and that and that. I mean, there are basic things. There's school. We open school in January. As a lawyer, you should know there is school fees, school uniform, school stationery, everything. But they have to go at pains, extra mile, go fetch this, fetch that, fetch that, fetch that. And one then asks a question, is this money even there if it's this difficult to release it? Is it even, does it still exist in that bank, which them only have access to? I'm talking about cases, just a few cases I can give you in the immediate. The second part is, I agree with you, Mr. Dia, passionately, because you have dealt with this matter passionately because you deal with it. But I can guarantee you that there are lawyers that have not filed necessary documentation of clients when they have them. To such an extent that when the clients are calling, they no longer pick up their phones. They no longer tell them what is happening. They don't brief them. They are at court. God knows what they are doing. You have my power of attorney, but you don't have the power of my intelligence. If I'm offered 1 million, and I think 1 million will suffice, you ought to tell me that in terms of the precedents, there's 2 million for these injuries. And in terms of law, the following process then has to be undertaken. And if I say to you, I can sign down and say, I'm allowing you to accept this offer because I'm in pain, I lost work, I lost my job, I can no longer walk, I'm in crutches, or I'm in, even worse, I'm on a wheelchair. I need a relief now. Well, now you want to take another 5 years, knowing very well that the courts are going to do that. There's no time at courts. So you are really not at liberty as a lawyer with that power of attorney to do as you wish. As a client, I can also say, I can sign an undertaking to say, I agreed to this, I need a relief now. But you can't then drag me and my name because the precedent says 2 million. Therefore, now we must go to court. At court, we don't know what date we're going to be given. And that first date, the lawyer of RAF doesn't appear. Then there's another date 3 years down the line. Again, the lawyer of RAF doesn't appear. Then there's another date 3 years down the line. Who's suffering? So these are the things that we are dealing with. The legal profession is at fault in many cases where people do not even know and they don't agree to what they are doing on their behalf. So I want to just check. This power of attorney can't be alpha and omega over my intelligence. Am I correct?
Yes, Honorable Member, you are correct.
Thank you very much, because this has been at the center of many of the things. So people, when they call it RAF, they are told you have a power of attorney, we can't listen to you. This is now the second part of my question. I call RAF with a client, or they are on the call on the other side, and I said, let's go, let's call RAF. We call RAF, and RAF says, no, that client has a power of attorney. Can the attorney call us? And I tell, no, this person can no longer get hold of the attorney. Or the attorney has been saying, I'll get back to you, I'll get back to you. It's been the past 2 years doing that. So what can RAF do? Now I no longer want to deal with attorneys. I want to go to RAF and see if I can settle on my own. What becomes my rights when we deal with that matter at that point? Because now I'm tired of lawyers. Now I want to deal with RAF and hear if they can settle. I will explore later after understanding where are we. But that which I have in power of attorney, therefore, the lawyer must be in liaison with RAF and I'm excluded, cannot be correct. But now I want to understand what's happening and I want to take over my case myself. What then becomes my right?
Thank you very much, Honorable Member. Honorable Member, remember at some stage I even said that a client can go to another attorney and terminate the other attorney and sign a new power of attorney. And you are not allowed, if a client come and say, I want my file, with or without termination, you're supposed to give him his claim, his file. And the only thing that will then be on your side will be the right to lien, where you will prepare a statement of the work that we have done already and serve that particular client. And remember, if you sign the contingency fee agreement, you can't demand the money now. You will have to wait until the claim is finalized by whoever who will be doing the claim. So that particular client does have a right to take his or her file at any stage when she wishes to take it and terminate the attorney of record of his choice. And also, I want to agree with you that indeed it is true that hence we have been talking about this thing of failure to communicate with the client, failure to account, failure to carry mandate, which are misconducts. Those are the things that are there, that are existing. But the only problem that I think we are having is that we have not been able to move beyond to reach every corner of the society to tell people what to do in an event they encounter problems like the ones that you are saying. It is further true that there are indeed lawyers, even ourselves, who get approached by clients who are saying that I have been looking for this attorney, I don't find him, can you help me with my case? You have to take it and liaise with RAF directly and tell them that I can't find this attorney to terminate, because RAF will say they want to prove that you served that particular attorney with a stamp on the termination of mandate. So you will be able to say, okay, sign an affidavit, we send it to RAF that we can't find this particular attorney. They must give us a copy of the file so that we can pursue the claim in your best interest as the client. So I'm saying, therefore, that the client can terminate the attorney at any stage, but the only problem, I think, is lack of knowledge in most of the instances.
So, Honorable Member, I'm in trouble with time.
No, just one last.
One last. And the reason is that this line of questioning is very educational, because the other reality, Mr. Dear, is that, notwithstanding, I think the reality of most people is that there is a power imbalance between the client and the attorney, even if you don't acknowledge. So, you know, one of us here can say, I want my file, I can take it with. But for a lot of the people from where we come from, they just won't know to do that, if you know what I mean. Which goes back to what I was saying earlier, that I feel that it must be, we must do things in the context of the society in which we live. We are not in the UK here, right? And so things to improve access to people, I feel it really is important. In the Eastern Cape, it must be in English, isiXhosa, and Afrikaans. And the person, you sit down with the person, someone sits down with the person, including, you can take your file. If you're not happy, you can, these are the scenarios that arise, etc., etc. If at these points, I'm going to ask you certain questions, this is why I'm asking you these questions, etc., etc., etc. And somebody from the law firm signs, and the attorney, and the client also signs to say, I understand this. And you tell the person, every time you come here, please bring this thing, or we'll make you a copy. We'll tell you where we are. You know, I know it might feel like a burden, but I think society will be served better if we do that, because most people just, it's an attorney, so, you know, they've got power of attorney, now I must listen to them. Honorable Member, your last question.
Yes, I wanted to check lastly with this proof, and I have encountered that on the call with Ralph, that for as long as you can prove you have terminated. Now here is a dilemma, you just also said it, that the person says, I can't find them, no longer on the phone. Some in Durban, I think about 3 cases I have, they even changed their address, they're no longer in the same building they were in. And I'm from Nongoma, I didn't document those things as to what. The only thing I will know is that it's Tia and Associate. Now, where am I going to assist the claimant to get this termination letter to the attorney. If we take those cases to you and say, LPC, here is one of your people. We can't find them, we want to terminate their service. We no longer want, even if they can clarify, we're no longer interested in their clarity. We just don't want them with this client. What becomes your assistance in that regard?
Oh, let me come first. Thank you. Before that, Chair, let us take what you are saying. We can, as the LPC, write to all legal practitioners and tell them that we would, as we are going to have this strategic session that we are saying we are going to have, that when you take instructions from a client, we want to remind you, you have a duty to explain what is contained in the power of attorney. You have to explain to the client in her or his mother tongue what you're supposed to and what you're not supposed to do. But the other limitation on this one would be this thing of touting, because really some other clients, they don't even know the face of that attorney. They know only that person who approached her in hospital. So I'm saying that we're taking that. I will talk to the chairperson that let us communicate with the profession that now let's create a way of doing things better so that we are able to address the issues of members' interest properly. Now, coming to your question, Honorable Member, on this, remember, even in the Act, but unfortunately some practitioners don't comply. You are not allowed to change your address without informing the LPC. You are not allowed to change your cell phone number without informing the LPC or your email address. But some, they do. And once you do that, and we find out it's a misconduct, we have to charge you for changing address, for changing contact details without informing the LPC, let alone informing the clients. Informing the clients, it's a serious issue. Even if we write to you, you don't respond, it's an offense. If the client writes to you and you don't respond, it's an offense. So those are the other issues. But the reality of the matter is that there are elements in the profession that are not supposed to be here. There are elements in the profession that are here, Chair, for the enrichment, their personal enrichment, not to advance the question of access to the profession, access to justice, and to respect the rule of law. But they just are vexatious people who are just there wanting to be rich overnight. So Honorable Member, I'm saying, therefore, from what you are saying, that we do experience as practitioners some difficulties with RAF when they don't want to accept termination without the receipt of the other firm. And you ask yourself, so we don't know where he is. How are we going to get him? And the client's case, maybe because summons were not served, it's prescribing next week. So there are those urgent matters that will need then for you as an attorney to even say, okay, that's fine. Go and make an affidavit to police, go to RAF and say you are terminating this attorney, RAF must take over your claim. If you can't find that particular attorney, so as to save prescription, so that the matter cannot prescribe. So I'm saying that there are those things, but also maybe it would be prudent that we have some bilaterals with the RAF to engage on issues of mutual interest, most particularly on issues where we have to defend the interest of public and the vulnerable and uneducated people that lawyers usually take advantage of, because they don't take advantage of people who are erudite and coming from the high class and middle class. They only take advantage of those who do not know. So I admit that I know that as a fact. I was sitting in the disease for Eastern Cape for some time. I know those matters were appearing before us. And even people who can't sign, where they will take advantage and sign for them and never pay them. You understand? But also from what you are saying, it is allowed that you have to explain to a client that this is an under settlement. And if the client is saying, no, take it, you don't have a choice, you have to take it. If the client says take it, because the client have to sign and say, no, we're taking, sign, and then RAF has to do payment as per that particular settlement agreement. Thank you, Chair.
Thank you very much. No, I feel like this exchange has really been helpful. Thank you to both of you, Honorable Member and Mr. Dia. So I am worried that we as members are able to come in and out and take body breaks. And so I just want to check with all four of you if a short break would help. What I will do at short break is afterwards is to check, because Honorable Beasley, Honorable Neil May, and Honorable Bila didn't utilize all of their time. They said I can come back to them. I will just complete that, and then I would just ask for your help in relation to some of the disbursements and so on, what is allowed, what is the process, and that kind of thing, because the issue of costs is a big one, because the road accident fund, as you know, pays billions per year in cost. And part of why we're doing this is to make sure that we assist the road accident fund to reduce unnecessary costs, whether it's legal costs and that kind of thing. So I will just talk to you about those matters and give you a document that the members have. It's not complicated. You can look at this for like 15 seconds and you know exactly what's going on. We've asked them to aggregate the cost awards by the court, and then, you know, if you can just help us, and I'll ask some questions. So is it okay if we take a short break? I do feel okay. All right. So, Denzel, what's the time? Can we come back at 20 past? I'm sure by 6 o'clock we should be fine. All right,
Yes,
thank
Chair.
you.
Hope
All right.
honorable members won't add more questions.
Thank you. I'm assuming, because I'm going to start with all three of you. All had, so Honorable Pilar doesn't, but Honorable Beasley and Honorable Neil May, you may have points to come back to. Okay. Thank you. Over to you.
Thanks, Chair. So my point's totally different from what we've been discussing now. One of the things that have come out in the Labour Relations Act is that lawyers have been used in disciplinary hearings and have been finding as independent chairpersons, and has been finding with the RAF in dubious manner in order to penalise the staff. So have you had any complaints in that regard? And how would somebody actually lodge a complaint in this regard? So it's not actually on the claimant side, it's on the labour relations side that the lawyers have been used to, I don't know what, to get the RAF's way of getting people out as independent chairpersons, allegedly.
Yeah, thanks, Honourable Member. You must remember that one is totally a different process. And that particular attorney who is sitting there, he's sitting there on a different cap. Then what's supposed to happen is that that particular member who felt that he was prejudiced had to appeal. And remember, when you preside, you have to be independent. And you cannot say really that if, for instance, I'm the acting judge and I decide to award 1 million rands, or I decide to send a particular person to 25 years direct term of imprisonment, that I was wrong. When on appeal, he will get 2 years, because that process, I had to be independent and do whatever I think is within the prescripts of law, which then makes it difficult and would make it difficult for the LPC to say that this person was used to advance this particular interest. But we have not received any such complaint thus far. And obviously, if we may receive it, we would ask that particular person in his capacity to answer, because whenever we receive a complaint, the first person, for instance, if we receive a complaint from the complaints that the honourable member was talking about, we'll have to write to those attorneys that there is this complaint against you. We are giving you 15 days to reply. If you don't reply, we say, okay, we're going to take a decision if you don't reply. So that's the process that we will follow. Thanks.
Thanks, Chair. That's me.
Thank you very much, Honourable Neil
Thank
May.
you, Chair. Chair, my last question was, how many attorneys, how many complaints do you have with attorneys that have left the country and that have not paid over their money to recipients? Do you have any that you have on the books at the moment? And do you have any other attorneys that are missing in action, that just are untraceable or have, just not been able? I think I heard some questions earlier. Thank you.
All right, so personally, I'm not aware of any where attorneys have left the country without paying over the money. It does happen to an alarming extent where practitioners, we call it, abandon their practice. And in those instances, we do still act. Even if we can't trace the attorney, we do end up going to court applying for a striking, because the mere act of abandoning your practice is a strikable offence. So what would practically happen is we approach the court for a substituted service order, which means we just simply publish in the newspaper to say we're looking for this attorney, we want to go to court to strike him. And there's a number of them that get struck on that basis.
Yes.
Do you by any chance have a percentage of those attorneys that have abandoned their practices at the moment? Thanks.
No, we wouldn't be able to give you a percentage, because usually what would happen is that the investigation would start from simple complaints, well, saying simple, but from a complaint to say there's failure to account or failure to respond to correspondence. And then as we investigate, more complaints come in, failure to account, misappropriation of money. So ultimately, the striking isn't purely on the basis of abandoning. we link it with all the other complaints that are there. So we don't, and Yalo, you can maybe just confirm, we don't specifically keep record of abandonment, but abandonment is a factor that would definitely persuade the court in granting the final striking order. So we don't keep that statistic specifically.
Sorry, just a follow-up. So if an attorney is struck off the roll now, who's to stop him from going to work in a company in the legal department, in legal, or in government in legal? He might not have his firm, he might not be able to practice as an advocate or attorney, but yet we find him out there working in businesses and in the private sector as legal advisors. Do you have any cases like that?
So remember, once you, apologies, once you work in the private sector, we do not have direct oversight over that, right? We can still deal with you if you're working in the private sector. In other words, in our terminology, you are non-practicing. Once you are struck or suspended, you are free to go and work in the private sector. I think from a labor law perspective, you would be required to disclose the fact that you've been struck or suspended. And we've had inquiries in the past, not many that I'm aware of, but we've had inquiries to confirm somebody's status as an admitted practitioner. And then we would provide the information. And again, even on our website, you can verify somebody's status as practicing, non-practicing, struck or suspended.
Add to that, in some instances, government departments will request a good standing certificate. And then, of course, we will refuse and they'll request the reason why. And then we'll indicate that this individual has been struck and suspended. And if they want to employ the struck and suspended attorney, they are free to do so, but at least then they are informed. And a lot of government departments do request this good standing certificate. Thank you.
Lastly, Honourable Member, I think you are referring to the old case of Darren Bobrov, who left the country for Australia without paying the clients. That matter was also dealt with by the court on criminally in the matter of Ronald Bobrov and another versus the NPA, and the Department of Assets Forfeiture was involved. His bank accounts were attached so that the monies can be recovered. But it was in 2016, that one, before the existence of the LPC. Thank you.
Thank you very much. Thank you. So I'm just going to ask for your assistance with two types of matters. So I understand that you've been given this sheet. So let me explain what this is. You'll see that it does not run to 2025. That's purely because of printing issues. But I think there is enough information on here to do the work that we need to do. The only thing that's missing would be 23, 24, 24, 25. But that information is available in electronic format. Now, one of the things that that really has got the backs of the public up is to see huge sums of money being paid to law firms, and the conversation is the RAF is being looted, right? And we've asked the Road Accident Fund to just break down these payments, give us the top 20 law firms, the individual law firms for our purposes here, because we are going to talk to the Road Accident Fund on Friday and go through this in detail and have those discussions, is not so material, except to try and understand whether these things claimed for here, in terms of your understanding of the rules of court, etc., and what attorneys are allowed to claim for, or at least in terms of the cost awards that the courts give. If there's anything that in your view that would lead you to conclude that there's something that smells, then we can talk about it. So I'm going to ask you some stupid questions, and please forgive me. So would I be correct in saying that these are all the costs that the court would award to a claimant? Or how does it work? Is it to a claimant? Is it to the law firm? But the litigant is the claimant. So I'm assuming that the claimant would be awarded costs. Is that your understanding of what's going on here when you look at the headings?
Yes, Chair.
Can you just explain that broadly, the process, right? Because, and we'll talk about that list as well, because what struck me when we asked for a list of law firms that the RAF has then investigated, it did not look the same. Right? So, which then can be confusing in terms of how can you say these guys are looting, and then when I ask for the list of law firms that have been investigated and referred, you give me a completely different list, not this one. But I'm asking these questions about this one because I understand the level of public interest therein. So when a court awards costs to a litigant, what are the rules governing what can be claimed in the context of the road accident fund? Obviously, what can a litigant tax? Because the term is taxation.
Thank you very much, Chair. Firstly, Chair, it depends on the type of cost order itself. If it's a cost order on a party and party scale, it's different. It's different from a court order where the court will say you have to pay the cost order de bonis propris, where the court will say it's on attorney and own client scale. It's different. On attorney and own client scale, you charge everything. You charge for consultation, for phone call, for everything. But on an attorney and own client, it becomes a different ball roll. Even when they are de bonis propris, they are punitive. You charge even for me going to drink water. I make part of the consultation that I was in consultation at that time. So here, when I look, for instance, let's deal with the one of De Broglie, the first one.
Yeah, just take us through to make things easy. So just say attorney, advocate, correspondent attorney. Just take us through all of that so that we can develop an understanding for our conversations with the RAF.
Yes, thanks. Now, with the attorney is the instructed person by the client. So that has his costs, obviously not emanating from one claim, where he will be charging for consultation, requesting medical records from the hospital, requesting police records, and all those things to prepare the file, to lodge the claim, and everything like that. Then for the counsel, in an event, for instance, you have to make an application for a default judgment. That means RAF, 20 days has passed without RAF filing a notice of intention to defend. Then you approach an advocate. Then those are the counsel's fees. And most of the advocates becomes very naive and don't want their bills to be taxed, saying that in terms of their rules from GCP, their statements are not supposed to be taxed. Then for the correspondent, let's say, for instance, this law firm, De Broglie, is in Pretoria, and the law says that you are going to represent a client where you must be 15 kilometers from the High Court, from that court. Then let's say they have a client in the Eastern Cape. If they have a client in the Eastern Cape, they have to employ me as a correspondent. They have to do whatever exchange of papers through my office. I will have to go to court to file, to print some documents for them. So I am that correspondent. So these 2,795 are for that particular person who is doing that particular job.
Well, we're dealing with millions here, Mr. Tia, but I get you. So that would be 2.7 million.
Oh,
yeah. This is all millions.
It looks like in 2020, 2021, it looks like 2,795. Yes. So, Chair, then we move to the disbursements. And remember, when a court issues an order, it will be clear to say that the defendant will have to pay the cost of this action, and also to pay the disbursements. In other instances, the court order will go as far as to tell who are those medical experts, for instance, that were used in this particular case. Because, for instance, here you see that there's an actuary, there are assessors. RAF have their own assessors, but other law firms, they prefer making use of their own private assessors to prepare a report for RAF in order to settle. Mostly, this applies on loss of support cases where the breadwinner has passed away. Then on medical costs, obviously, these are specialist reports.
Sorry, can I ask, so the assessors are?
The assessors are the people who go and make a thorough investigation and prepare a report for RAF to say this person was a breadwinner, was doing this. We have met some old lady who is a neighbor. He confirmed that this guy was having these 3 children, but he further informed us that this guy was having other 2 children out of wedlock in some other village. So we had to go to that village and find these other minor children. Here are their birth certificates, here are the names of their mother. So that person is an assessor. Yes, they prepare a report for RAF. So
let me ask, so these reports, so these people are employed by the RAF?
They are employed by the attorney.
By the attorney.
In this instance, hence they are in there.
So the RAF does its own process or what? So
Yes.
there will be 2 assessors.
Yes.
So basically, in all of this, it's double.
There is possibility of a double.
In that the RAF has got its own attorneys.
Correct.
The RAF has got its own counsel.
Correct.
It's got its own. So all of this, it's got its own.
Yes.
Okay.
And in other instances, Chair, I will tell you that at times it's not necessary. For instance, you'll find situations where RAF will reject an RAF4 form that was prepared by a specialist. It's rejected by a nurse at RAF. Now, they have to take this particular client. I go to court and make a review application, or else I appeal to HPCSA. They have to take this particular client to their own expert. Their own expert will request that particular RAF. And this person is a neurosurgeon like this one and their colleagues for that matter. And likelihood is that they are going to agree. So it's just a double. And here, it's supposed to be medical legal, not medical legal. These medical legal reports, these are the reports I'm talking about of neurosurgeon, orthopedics, industrial psychologist, occupational therapist, clinical psychologist, and so forth. Yeah. And then the other expenses, these other expenses, Chair,
it's photocopies and the like.
Maybe photocopies, transportation of clients, the food they prepare for clients, or there's travel accommodation that is separate. So it would be things like photocopying, telephone calls, but all the things that they paid for immediately before the matter was finalized. And then the interest is an interest that is always gazetted by the minister, and usually it's around 10.28%. At some stage way back, it was 15.5.
So that's interest on what?
That's interest on everything that RAF did not pay on time.
I see. Okay. All right. So you've assisted there. So let me just say one of the things that we have been concerned with as a committee. You see where it says medical, it's supposed to be medical legal reports.
Correct.
So if I look at Debrolio, from 2020 to 2021, I've got the full spreadsheet here, right?
Yes.
So the medical legal reports over the years, from 2020-21 until the 31st of December last year, amounted to 288,742,907. The number of cases concerned there, because I asked for a similar sheet, the members would have it, is 2,670 claims, of course, of differing severity and that kind of thing. And I'm asking this question to try and get to 2 points. The one, and this is for the members, in the context of the new RAF 1 form, where the claimants have to produce these reports before the claim can be registered. So if you apply that, the claimants in one or other way would need to fork out that kind of money before a claim is registered. Am I correct in that? Because we had the Road Accident Fund here. They said in terms of the new process that is in place, that is being litigated by everybody and their cousin, that the claimant must secure all of these medical legal reports, the actuarial report and that kind of thing, and then submit them, and then the claim will be regarded as compliant, and then the process kicks in. A, correct me if I'm wrong there. The second is that if I look at the medical legal and I look at the actuarial cost, the actuarial are 44 million, and that is a total for 5 years, and the medical legal at 280, that's about 300 million. Just one on 2,600 clients. So an ordinary person would need to find all of these things. And therefore, at the end of the process, they then, I suppose, if the matter goes to court, they then have to be reimbursed. Am I reading this correctly?
Not really, Chair.
Okay, please correct me.
Yes, not really, Chair. Chair, there is still a dichotomy in the fight over this thing of costs. Because the understanding is that if you take a claim on contingency basis, whatever that you have to incur does not make you to be entitled to costs. The costs are for the client. But you see these big firms, what they do, they don't like contingency fee agreement. They are able, through their tax consultants, to prepare a bill that would amount to millions.
Okay, let's deal with that as part 2.
Yes.
For now, I want to know what was the cost the court awarding here? Because as I understand, right, that's why I asked in the beginning, we're going to come to this.
Yeah.
What I want to understand is when the court says part of the expense, because I assume these go to the, what's it, a tax master or taxing master or tax master, whatever the case is, that person. They look at all of this and it's then approved for payment, which is why the Road Accident Fund has paid it. So for me, the debate is interesting. We'll deal with it. What I am concerned with as a committee is that this money has left the door. Yes. So I now need to know, what were they paying?
They were paying, Chair, the medical legal reports in these different cases.
Sure. So what I'm trying to understand then is, so when the court awards costs and the tax master, is it taxation or taxing?
Taxation or tax the bill.
Okay.
Taxation is done by a taxing master.
Okay, so the taxing master. So let's say the taxing master has now looked at the submission and it appears to me they have determined that these should be paid.
Yes.
We'll deal with the theory after. These should be paid. It's already done. So what you are saying is that when the law firm goes to secure to 5 specialists for different things because you are so broken up, they keep those invoices, and when the costs are awarded, they are then submitted for reimbursement by the RAF.
Yes.
Okay. Now let's go to the debate that we are talking about. Why is the taxing master then approving these payments?
It's approving them, Chair, because the court order said that they must be paid.
Okay.
Yes, because remember, when you go for taxation, before the taxing matter, you have to bring the file itself.
And I get all
now,
of that.
Now, if you say that we went for a neurosurgeon, Dr. So-and-so, he charged us this amount, we have to give the proof to that effect. Then,
okay.
Then, but what I don't understand, Chair, is that in other instances, you will find out the same expert who prepared a neurosurgeon report, for instance, in a matter of MVA, charged 24,000. But in a medical negligence case, he charged 94,000. I don't know how, but it happens.
Well, you guys are the Legal Practice Council. You can't not know because...
No, because
because we are then going to ask you, how does that happen?
The Chair, they are not regulated as by as they are regulated.
Oh, sorry, it's a medical, it's a HPCSA.
Yes.
Okay, so that's something then we possibly then need to ask, because what I'm busy wondering here is whether there are any standardized rates or anything like that.
Okay, if I may try to assist. So let's try and look at this practically, right? So let's take a child who's in a motor vehicle accident. Most instances of motor vehicle accidents, you're going to have fractures, broken bones, and very likely you're going to have a head injury. Okay, so let's use that scenario. Now you've got a child who's got a broken arm, a broken leg, and a bump on the head. The legal system of South Africa requires that if you have a civil claim, so you are the plaintiff, you want money from RAF, you need to prove your claim. Right. In order to prove your claim, there's the two parts. The one is the liability, the fault, and the other part is the damages. Okay. So for that child, the attorney would now have to appoint an orthopedic surgeon to assess the impact of the fractures. The orthopedic surgeon on his own is not necessarily qualified to say what's the impact of the fracture. So he can tell you there is a fracture, it's very severe because this is the nature of the fracture, maybe there's shortening of the leg, etc. Together with that orthopedic surgeon, you would then require an occupational therapist who will tell you, based on what the orthopedic surgeon has found, based on the prognosis of the extent of healing that you can expect, this is the future impact on this child. So let's say, I think anything up to a 3 centimeter shortening is still acceptable. Anything beyond that is going to significantly impair that child's ability to obtain labor or employment in future, especially if it's going to be physical labor. Right. So already now you've got the two experts. Now you need to deal with the head injury. So to assess that head injury, you are going to require a neurologist or a neurosurgeon who's going to have to explain to the court what is the extent of the damage in the brain itself, how severe that is. Again, the neurosurgeon or neurologist on his own, he can give you the extent and the severity and the prognosis, but now you require possibly a psychologist, because maybe there's behavioral deviations. You might require an educational psychologist who's going to tell you, this is the impact of this kind of brain injury on the educational development of this child. So already there you're looking at least at 5 medical experts in order for the plaintiff to prove his claim. Then comes in the industrial psychologist, who now basically collates all of this information and says, all right, the occupational therapist and the orthopedic surgeon says, this is the prospect of this person finding employment in this type of labor market. What they look at, for example, is they would look at the parents' educational background, the family history.
So rather than cutting you, so I get all of that. The only thing that I'm interested in is what Mr. Tia was saying, that the rates aren't the same. And they might not be the same. I'm happy with that. But they also, in my mind, to my mind, they need to be within a certain percentile of one another in the same city. Let's say you are all in Durban and it's a neurosurgeon. I would expect that there is a ballpark around which those kind of experts charge. So when to assess a patient, it's sometimes 25,000 rand, and then at other times it's 90,000 rand. I then wonder, because my concern is, it may be that each law firm, right across the board, big or small, have their own little panel of experts that they work with. And depending on how successful that firm is, they might actually just charge above what they would normally charge. Or you may find that what they charge Mr. Tia's claimant is not the same as what they charge Honorable Matiwane's claimant for exactly the same thing. That's where my concern is.
Sorry, Chair, if I
So
may.
does that kind of thing, yeah.
If I may try and possibly assist it a little bit further there. Again, the nature of the injuries would dictate the type of investigation that the medical expert needs to do, right? So there's certain batteries of tests that they call, and depend on the type of injury and the nature or the manner of injury, you would apply a different battery of tests. So that might explain a small difference in the costs. But you are correct. I don't think that there's any formalized standard rate that's relevant. And maybe that is something that you then need to take up with HPCSA.
All right. No, thank you. Look, in any event, I note that the Road Accident Fund did not challenge this. So they paid the money. So they appear to be okay with it, in inverted commas, in any case, right? So I look at some of these, as I said, some of my concern is I am looking at what 2,600 claims costs in medical legal reports, and it's nearly 300 million. It's something that is not in our conversation, but I think of the claimants, direct claimants, or whoever who are expected to pay for these themselves. The one thing and the conclusion I have, or at least observation I have, when I look at the size of the law firms which have healthy balance sheets, so it feels to me that my mate, who's the sole law firm in Elliot Dale in the Eastern Cape, does not have the kind of money to pay these experts and wait 5 years for the matter to eventually go to court. And I, Mr. Tia, we're from the same area. So my observation is this, that it appears that the system, especially now, can only mostly benefit the big law firms because of the RAF 1-4. Where is a law firm from Libode going to get this kind of money for medical legal claims? I'm going to go to, I don't know, a bigger law firm that's not going to ask me to pay any of this, and they won't feel the strain. Is that observation crazy?
I think, Chair, you are correct. Hence, when I was engaging Honorable Member Mende, I was saying that to me, 5,000 is a serious loss if I'm to take a tout for instructions. It is quite a problem. That is why, Chair, RAF, maybe, I don't know if they informed you. There was a case of LPFF and another versus RAF. It was on this issue, and RAF lost that case. They did not lose only that one. There was another one in Eastern Cape before the Grahamstown High Court. I don't remember the parties, but it was presided over by Acting Judge Nokes, saying that what they are doing, it's against the Act. So, you are correct to say that the system itself seeks to benefit those who have. Because, for instance, for me, I cannot be able to pay at once for all these medical legal reports, as Mr. Braille had alluded to. At times, you'll remember that, for instance, that first orthopedic will refer you himself to other 5 specialists and say that, no, for this patient, I noticed this and that and this and that, and you'll need this particular report and that report and that report. And the specialists that we're having in country, they are 4. 2 are in Cape Town, 1 in Pretoria, and 1 in Northwest. You are in Mthatha, you don't have money to run all those things. And at the end of the day, you will find out that even when you have some of the reports, you'll see that, but at the end of the day, it was not necessary. Because RAF usually, they will only, in order for you to get an actual report, you need an industrial psychologist. But for that industrial psychologist to prepare a proper report, you have to collect then therefore all these other reports. Yes. So at times, I believe some of the reports are unnecessary. At times, they are necessary to build a case. So it's an advantage for those who have, and for the big firms, unlike us who are owning spaza shops in every corner of Mthatha.
Yeah, I've seen those offices. Anyway, so I sometimes I'll make the comment at the end about the judge you mentioned. Nothing bad. So one of the things, like I said, is that we have to think of recommendations that could assist without doing anything unlawful. So when I look at these costs, right, and I'm assuming that the road accident fund would need to, to do the same things here, like, these kind of monies, it says to me, at least a significant percentage of them are mirrored on the road accident fund side, right? So let's take this one, law firm A, the one that is at the top there. So over time, the total costs attached to the claims amounted to close to $1 billion, right? Which means the road accident fund on those same claims, let us say, I don't know what they do, you're also looking at $500 million. Which means if we are to resolve all the cases, the road accident fund needs 7,000 employees. It does. It needs about 7,000 employees, and you need to give the road accident fund about 120 billion per annum, so that you can comply with these 90 days here, 120 days there, 180 days, right? You have, because earlier this morning we had testimony that people have caseloads of 2,000 claims. The internal law firms have a caseload of 4,000 each. So of course, you're always going to go to court. You're always going to get a default judgment. These costs are always going to attend and so on, right? And I'm saying this because part of what this kind of conversation gets to is the personalities. But I see a system that is completely broken from the legislation itself all the way, and it's busy breaking everything. It's breaking the courts. It's breaking everything. And what South Africa needs to reckon with is that this entire scheme is delusional. For a developing country, it's delusional, in my view. They've got 435,000 outstanding claims. To clear that backlog in a reasonable period, they honestly need 6,000 to 10,000 employees. I don't know how many acting judges must be appointed and so on. It can't work. So I'm not blaming you. I'm trying to deal with the reality because we're legislators here. And this entire scheme is crazy. If you ask me, doesn't have enough money. There are not enough people at the road accident fund. And then you've got inefficiencies like this, where over a 5-year period, from one law firm, you've got 1.5 billion rand minimum costs for both litigants before you've paid the claims. And I just want your comments. This is my observation, right, when I look at this. And we can fight and call people names and say they are looting or they're doing this. The whole thing, for me, is unviable, if you ask me, if we're all honest with one another. So I'd like your comment on that. Looks unviable to me, this thing.
Thank you very much, Chair. Chair, I think you are correct, and I will agree with you. But what I think maybe RAF needs to do, at times, there is no reason, as far as I'm concerned, to reject this RAF4 in the reports, because they only have to take the clients to their own specialists, where maybe they have mistrust issues over that particular aspect.
No, that's my last point that we're going to deal with together. I'm just talking about the viability of the entire scheme and the way that it works.
Yes.
Right? Because to me, if, and I'm going to get to how, this is the last part of our conversation. I'm going to get to how maybe within the current framework, we start reducing these numbers here, starting with the idea that I floated earlier on, right? But all I'm saying is that if we are to make recommendations as the committee, in order to do justice to the 430,000 claimants who are waiting, and that's the minimum that we know. This number is in the annual report of the Road Accident Fund. It's 432,000. That number looks impossible to me, given that there are new claims every day. And there is the backlog of claims that the IRF has rejected in terms of the RAF 1 form, which the courts are likely to reinstate, which means you're now looking at 700,000 and some odd claims. Now let us say you've got this total liability, right, of the claims that you know exist, and we now make an earnest attempt, all of us, to clear them. I can't make a recommendation that says the Road Accident Fund can clear 700,000 claims with 600 employees and 40 billion. It's not going to fit. You get that? All I'm saying. The numbers don't add up. They don't fit.
Yes.
Then we will talk about these, and that's my last point. Then we go home.
Yeah, thanks, Chair. Chair, that is why when we started at the beginning, we said that there are problems of capacity and so forth. So what you are saying speaks to that they are understaffed. And also that on the question of viability, it's unfortunate, Chair, that where we are sitting, we don't know how much RAF collects per month. The only thing that we know is that they are collecting from part of fuel price.
Oh, no, that amount is known. So they get between 3.8 and 4.1 billion a month. Yeah, so we know that because SARS transfers the money each month and it's published. So we know that.
Yeah.
Yeah.
So then, Chair, on the question of viability, I think, I don't know, but I think the reason why you are here starts from the question of the leadership at RAF and how they are handling these claims there by RAF, because to me it would be better maybe if we were saying that matters has been settled but there's no money to pay them. The problem is that they let the claims to sit there forever and attract more costs, and in that also we cannot punish them wholly for that, because we are also saying on the other hand that there is an issue of them not meeting the needs of the public because they are few. So I don't know really what I would suggest than to say that maybe if we can opt to employ that suggestion you were having of having a system that will speedily deal with these matters. Thanks, Chair.
No, thank you very much. In fact, I think part of I think the execution was poor. I think part of the whole ICMS dream was to try and get through some of this, to get to an offer that that even when the attorney looks at it, so it would take into account, that book that you were talking about, that has got kind of, that book, I call it the second-hand car book equivalent, because cars have a similar thing. That the reason I thought ICMS conceptually was a good idea is because it takes all of these things, the case law, etc., and it can, it can produce some kind of that appears to be in the right ballpark, taking account of previous judgments, etc., legal precedent and so on, and then say, listen, the system makes an assessment and it says, what, we'll offer you 8 million, right? You might have wanted to claim for 11, but then you now have that conversation that Honorable Mende was talking about, where the attorney says, I believe you're entitled to 8 million, but the RAF is making an offer of 8. And the plaintiff might say, that's good enough for me, I'll take it. I don't want to go through the court. So conceptually, in my view, I think the idea, but the implementation is another matter, not for us. The only thing I'm going to do now here is to just ask you colleagues from the LPC, if we recommended as a committee that legislation is amended, because the RAPS bill, whatever legislation they bring, is going to take 5 years. Legislation takes forever in South Africa, and we need to have justice for claimants. I think amendments can be done a little quicker, and that is, the minister is empowered to establish a panel or panels, right, with all of those requirements, that there are corresponding panels there too, where all of these people, the assessors and so on, these are the people who assess, and if there is agreement, and the person might still have an attorney, but it says to me, at least even if it's 30 or 40% of the claims, where the panel has said, we believe the right offer is X, right? And the litigants and the claimant accepts it. You then don't have these problems with medical, legal, with the advocates, the correspondent, all of that. You minimize it, and suddenly, out of that 1.5 billion, or at least at the end, maybe you're looking at 300 million, and you take the difference, and it goes directly to claimants towards clearing the backlog. I'm trying to find a practical solution here where fault is still established. The claimant may still be assisted by an attorney or not, right? But the system is fair, it establishes fault, the offers are within the right ballpark in terms of precedent and so on, and you also help the court system and so on. If we made a recommendation like that, would it potentially run into legal trouble, or constitutional issues, or not? And is it something that the committee should take further advice on and consider seriously?
Yeah, thanks, Chair. Chair, I think that would be the best way to go, because the issue that will attract litigation is where there is under-settlements that are being challenged, of course. And you must remember that the reason there are these costs we are talking about, it's because of that process of going to prove the case in court. If we were able to circumvent and deal with the matters as speedily as possible, we would save a lot of money. So I agree fully with your submissions, Chair, that if you can make such recommendations to the minister, they would help not only the fund but also the victims themselves. Thanks.
Sorry, Honourable Member.
No, Chair, thank you. I just want to put a rider on what you are proposing and further ask, what necessitates this gap and the actions thereof that are taken, which then end up in these costs in terms of law? Because we have a law that says only a lawyer can claim and all of that. And then we have a vacuum where a person comes to RAF and claim for themselves. And then we have another process that triggers summons in this same process, and you can't do it when. I can't go to court and do a summon. Now I need a lawyer. I want to get from you what necessitates all of this besides this part of the law where it says only a lawyer can do this, so that in our recommendation we are able to say there is a rider here. If we do the following, it will therefore curb the wastage. What necessitates this?
Thanks, Honorable Member. What necessitates it is that he who alleges must prove. So the one who alleges have to prove his case. In an event, it goes as far as the court. And you must remember, a member of public can go to court even in person without being represented by a lawyer. Can approach any registrar of any high court to say that I have this case against this person. He will or she will be assisted.
Sorry, Chair.
Except that the other guys will bring an advocate.
No, sorry, Chair. Yes, I get the part where he who alleges must prove. I'm coming here, both my hands, the fingers are all broken. That means they may look like fingers, they may look like nothing because fingers are broken. But in reality, I can no longer do anything because I don't have fingers. But then there will be someone whose skull is wide open. And if it gets closed medically, they will function optimally. So are you saying to me, now RAF requires me to go prove that I can no longer work because all my fingers are gone, as compared to someone who is regarded as a serious injury because their skull was open in an accident. However, medically, that can be dealt with swiftly and the person can come back and function optimally. Is that what RAF needs?
Correct.
Doesn't RAF have that in their, I don't know, actually regulations or order, that if it's fingers and the person is proven that this person can no longer function, therefore this is how we approach it. But if there's a chance that it can be fixed medically, this is how we approach it. So RAF doesn't have that.
Thanks, Chair. Chair, the honourable member is correct. RAF does have people that they work with in instances like that where they have to establish themselves how much they can offer to this person and or the extent of the seriousness of injury. Because on this thing, we are using the AMA Guide, 6th edition, which was gazetted by which the minister had instructed that it must be used. So I then believe that, honourable member, if the RAF was having their own internal, not private, possible the amounts would not be go as exorbitant as that, like that. Because, for instance, how they do it. For instance, in Mthatha, there will be a day where we'll be invited by Medical Legal. There's a place called Medical Legal. There's Protein, there's ZenMed, there's a list of them. They will bring specialist doctors. That day will be like we're going for the pension man, pay. Many clients, many lawyers. And these guys who are doctors, it's clear that they are able to make millions, maybe per day. So if RAF was having that particular capacity that is internal of their own specialists to simply determine these matters, I don't think that the cost would be as exorbitant as that. Because remember, even with us in Mthatha, although we have our own corner spaza shops, but if the costs that we claim from RAF can be brought together, there's a lot of money that RAF loses. So I'm saying, therefore, that if they can build their own internal capacity, I think we can be able to circumvent this charging of big costs and not to delay claims. Because the hearsay that we have, that they were accusing the then CEO that the people, when they don't want to work, they always blame their heads at time. Because you ask yourself themselves that, but colleagues were going to school together. Why are you not settling these claims? What is the problem? They will say, no, we're told to stop now, we're told to work, we're told that if a claim is above this amount, we must send it to Pretoria, it must be settled by the national office, not by us in the province. And imagine what the level of backlog that will be there if matters will be settled nationally by one office. So I think those are the problems, Chair.
All right, thank you. Last question from me. So are these amounts stolen money?
Chair,
because
no.
this, you know, the country is abuzz with this spreadsheet here. Is this stolen money?
No, Chair, it's not stolen money.
Look, having said that, I still think if this is one side of the legal costs, the road accident fund still pays too much.
Yes.
It pays too much in legal cost per claim. And through this process, we have to end up where the cost per claim, the legal cost per claim, and all the attendant cost is reduced drastically so that the money can go to claimants. We really have to end up there. I mean, we can't... Sorry, yeah, these are eye-watering amounts, right? And it doesn't help to call each other names instead of actually just solving the problem. And that's my frustration with this thing. Ms. Mfus.
Thank you, Chair. I just want to confirm what Honorable Atkinson is saying. I think essentially we are saying that the court should be the last resort. But what appears to be happening is that there's a repudiation of everything. So that is where your challenge is. Most of those claims wouldn't get to court. They don't need to go to court. So right now they have they use the panel of experts, but that is outsourced. So if they could revise their business model, you'd be able to deal with this situation.
All right. No, thank you. We'll be with them on Friday and again next week. So we'll be able to canvass a lot of these matters and test and challenge and so on. Because we do need to get to recommendations that get the money to claimants. Seriously.
Yes, Chair. Lastly, I think one other recommendation may be on this thing of amendment on looking at the legislation. If maybe you can make submissions that that part of prescription after 5 years must be removed so that people don't go to court. And then instead, they go only to court where there is a fight around the issue of the quantum. We say we disagree, we're not finding each other, only in those instances. But also on our side, as I was saying, that I'm making an undertaking that I will talk to the chair that we must write to the attorneys and advocates when they take instructions, that they are able to explain everything from the client, so that when one day we decide to send our own auditors to firms, because we will require the file, that there be such a document in the file that says that I explained to this client in his mother tongue and so forth, and he signs and the attorney signs. So I think that would help also. Thanks, Chair.
All right, thank you very much. Last question that I forgot. So we asked the Road Accident Fund to send us some referrals to the LPC. Were you finished with that list? I mean, we're not going to deal with individual cases. I just want to know whether you've received referrals from the Road Accident Fund of certain law firms, and basically what's the progress on those investigations. And we'll ask the Road Accident Fund around the same issues, because there were some referrals to the Road Accident Fund, and some appear to be offending a lot more than others.
So, Chair, yes, we do get referrals from Road Accident Fund. The difficulty is with the list that they provided. There's not sufficient information for us to trace specific matters. So we will engage with them. What I can say to you, I think they're referring to 19 matters, if I remember correctly, on the top list. We've got record of more than 19 that was referred to by them. So even you know, from their side, the records do not match. But we do have matters. There are matters that have progressed quite far. There are matters that still need a bit of investigation.
All right, thanks. Now we will also make sure that they send a complete updated record to both yourselves and to the committee. Honorable Matiwan.
Mr. Clarity, Chair, before you close, when Mr. Tia read the 2,795, you said there are three
He was right. Yeah, no, he was right.
Oh, there are no zeros.
No, there are no zeros. He was correct.
Okay.
I was wrong. I actually thought I would correct myself.
Okay, no, Chair. It's looking at this report in front of us. The Broglio Attorneys Incorporated, over a period of 3 years, took over 298 million rands from the Road Accident Fund. I don't know if perhaps we would be able to get how much of that 298 million rands went to the actual claimants.
No, so here's the thing, Mr. Matuan, the reason I'm harping on this, you've got to understand, these are the attendant costs, it's not the claim. It's the process. This is why I'm obsessing about this suggestion here. It's not the claim. A claim on top, yeah. Yes, yeah. So that's why we've got to have a process that does not produce this kind of cost, because these are basically awarded by the court. They go to the taxing master. The taxing master looks at them and they say, all of this is proper, and then it gets paid. Nonetheless, we still need to bring that number down. These are insane amounts of money. Yeah, so that's we really have to make best efforts and take the best advice we can get as the committee from basically process end to end, to make sure we can make recommendations that speed up the process, the result is fair, and it costs far less, and the savings go to the claimants. Thank you very much. Mr. Tia, I was going to say that acting judge, my mother used to teach in school. That's why I was chuckling there. So I know him. No, thank you very much. Let me thank you for waiting. Oh, sorry, you wanted to add something?
Yes, Chair, before that we add, when we arrived, I was still also not properly settled and afraid of the environment, but I was the chair of the council, said I must tender his sincere apology for not coming, because he had a prior commitment before we received the letter of invitation to this committee, that he does not take this committee for granted or any leaders for granted. So he sincerely apologized for not making it. He wanted to come before this committee personally, because even in the last time, he had another commitment. So he said, I must tender his apology. So I wanted to raise that to this committee.
No, thank you very much. You can, sorry.
Chair. There's something that you didn't ask. I thought it was going to be clarified on these costs, which we have been trying to get. These are administrative costs that these ones. What is it that they take in that 25% of the claim? Because it means they claim this side, they get money. They still go for the 25% of that side. Or they get this only, they don't take on the 25%.
Oh, yeah. Can you explain that?
Please take us through. At what point do they get to the claimant's money and take a portion of it?
Right, thank you, Chair. So the way that it works, the amount that you see there, that's the party and party costs that the attorney recovers from the RAF. So once the attorney has now received the capital amount, let's say R1 million, right? He takes his 25% plus the disbursements. Okay, so of R1 million, it's what, 250, right? Plus whatever the medical legals, etc. is. He then needs to go to court to tax his bill of cost. Once that's taxed, the RAF pays. Whatever he recovers from the RAF in terms of the costs and these disbursements, he then needs to give back to the client. Yes. So let's say he took 250 from the capital and he now gets 100,000 from RAF. Then he needs to give 100,000 back to the client.
In a nutshell, it means the costs belongs to the client in a contingency fee agreement, unless it was a situation where the client signed to pay on burden on client.
You see why I think the attorney really should sit down with the claimant. Can you see? It's complicated. We can take it for granted, but it actually isn't. I must tell you, I've worked with lawyers for over 20 years. Even I'm confused. And you guys have been here lots of times. But you wanted to say something, Mr. Bray?
No, thank you, Chair. I think just to Honourable Mente, you're right. A lot of the times it doesn't happen. And those we treat as misappropriation. And we have struck practitioners because of that. But we also do come across instances, unfortunately, and where the clients get given wrong information by the RAF. I personally had a matter last year where the client played me a recording where the RAF says, we've paid your attorney on this date, right? I have my own contacts at RAF. I verify. That money was never paid. So the client is lied to. Then the complaint comes to us. Yes, be that as it may, that might be an exception or a mistake, but it happens. But yes, we do take it very seriously. That money is supposed to go back to the client.
In instances, Chair, where from a practical point of view, if a client come to me and say that, no, man, look, there is this attorney, he claimed this amount and then he gave me this amount, I think I was robbed here. There is a clause saying that, Honorable Atkinson, which means whenever there's smoke, there's fire. Now, what you do, you simply call RAF and ask what happened. And then RAF will tell you that we paid the capital on this date, we paid the cost on this date. Say, can you email that to us, that document? They email you. You simply write to that attorney that we demand that you pay this money in 30 days. In most cases, they pay it immediately because they know the next step is LPC, and LPC is going to strike him off wrong. It speaks to what we were talking about the knowledge, that members of the public don't have knowledge. And I think that's maybe an issue that actually we have to try to put some more effort jointly with RAF to make a public awareness on these things, not only RAF, even on medical negligence. I think you'll remember the cases of Mr. Nonoba, where members of public don't have information. So we need to make the public to be aware. And at times, the problem with the public is that they come to this attorney because this attorney has money. This attorney will borrow him money from time to time, from time to time. Once the claim is settled, that attorney will come with the agreement, say, I want my money, and end up taking possibly the entire amount that was claimed. There are instances like that. So that is why I'm saying that it would be important that we do make those public announcements for even on flyers, on radio interviews, that clients must have the information, and maybe through the Minister of Justice to assist us, maybe even financial, to have some, maybe we outsource this part, that it must be funded by his office to deal with this thing of making public awarenesses. We try to empower our communications officer about these very important things that members of public need to have. And we made some recordings in all languages, not only in English, Xhosa, but all languages, so that everyone becomes aware that if there's a claim, because if you go to Facebook, Chair, you see there are many groups of RAF, and I always say when they ask, I say, why are you not asking your lawyer? ask your lawyer, because they will say that my claim was settled in 2013, 2023, I have not received money. Say, ask your lawyer. If you don't get it, and I put the website of LPC, then go there and tell them that you did not receive your money. Thanks, Chair. Thank you very much.
No, thank you very much. May I ask you that, with the benefit of this conversation, can you please just go reflect on it a little bit and make any submissions on recommendations that you'd like, because ultimately we have to try and have a cost-efficient process that is compliant with legislation. It's fair, it's quick. Even if we don't deal with the whole 430,000, if we are able to at least increase the number of claims that are settled with happiness by 30, 40,000 a year, that's 30,000 families that otherwise would have waited and have been very unhappy. So if you can, please do that. We'd be grateful. Thank you very much to all of you for visiting. For helping us. We didn't bite, as you saw. The members were robust, but didn't bite anyone. Honorable members, thank you very much. Tomorrow we'll start at 9 a.m. Okay, let's do 9:30, and I don't go beyond that. I don't think we will go to 9 p.m. We've set until 9 p.m. However, I do not think you've received the briefing. We are asking the board's decisions that we've discussed here in the committee. And it's all the boards up until this one, until before this one. Then we will have the interim board twice, on oversight and next week, and then the minister and deputy minister. Thank you very much. Really appreciate it. We adjourn. 9:30 then.